Hi, everybody. Thanks for joining us. I was on the wrong thread. Lana will be here shortly. How's everyone doing this morning? I know, right? It's not even 6 a.m., guys. I haven't even had my tea. Okay, so we are ready for day 30. Thanks for joining us. We're going to see some fireworks today, everybody. I hope we do. Get the screen up for you guys. I'm going to go grab some tea. Elo's here.
Great child watches.
I'm going to grab some tea. Good morning.
Good morning, Bella. How are you?
Why are you doing a Minnie Mouse voice?
Oh, because just feel like it, I guess.
Okay.
Did we just have a case of the Mondays?
Don't confuse me on Tuesday. It's so early. You have no clue.
I mean, welcome. I mean,
tea.
Do you think that Hank slept well last night? We have lots to say. This is welcome to the morning show.
I think that Rescue Randy slept better than Hank last night.
Rescue Randy's been dead for
I know.
a long time.
I think he got really peaceful dreams last night compared to what happened to Hank and his behind. But you know what? They should have called them. Bev should have called Hank into chambers yesterday and said she shouldn't have just made her dumbass decision on the bench. She should have called them into chambers and said, explain this to me right now. What the fuck did you do? And I'm going to declare a mistrial with prejudice, and you better have some answers. And then called everyone in the chain of command into her chambers and just like heads are going home.
And just pour a glass of Alizé. Yeah, because it's basically a funeral. I mean, yesterday should have been over. Again, good morning, everybody. This is day 30 of Karen Reed. And La Posada I have her down as the 48th witness. And I have her down as the 10th defense witness by my calculations. But so 48th and 10th. So remember how we were talking about interlocutory appeal yesterday? Can the defense do an interlocutory appeal? Are you there?
You couldn't see I was muted to go get my tea? Yes, we were talking about the interlocutory appeal. I'll keep the conversation going. Go ahead.
Oh, well, I can just talk to myself. I do it daily.
No, you love talking to yourself. I love it. I was just listening like I was just...
Oh, okay. So yesterday we were talking about the interlocutory appeal and could, the defense do it. I asked Andrea Burkhardt about it, and she said that there's just no time. She's like, there's no way they'd have like an answer by Friday, and Bev said that this is over by Friday. And then that got me to my next question, which is, well, why is Bev saying that this is over by Friday? Like, why are we being rushed? Or why, when I say we, the defense being rushed? Now, does this have to do with when you first are talking about things in the beginning and you're telling the jury, because Bev's all about, say, the jury's time. Is it because, well, Hank said his case would take X amount, weeks, and then you guys said that your case would take X amount of weeks? Well, let's be real. I think this is when judges like to be like, hey, you need to give me as much notice as possible. I knew day 3, if not sooner, me personally knew that Hank was treating this case completely different. I mean, I think day 3 is even me being kind. And that I was like, they are not calling anybody to that stand. And so is that when you need to say, hey, we need to have some talks about the way that the prosecution's going about this case? When we quoted you on a week and a half to 2 weeks for our side, that's no longer the case. If what I'm anticipating here by Hank, if he's not going to be calling any of these witnesses, we're going to be calling them, and or maybe not them, but we're going to be having to call other people because we have to lay out our case differently because of how Hank went about it. And I just don't think that in a murder case that you should be, hey, well, we told the jury that we were going to be done at this time. Like, I'm sorry, but I get the jury's time is valuable, but I think what's more valuable than the jury's time is somebody on trial for murder and defending themselves. I mean, this is their life. We're talking about a couple weeks of the jurors. So with that, I'll submit. What do you think?
I'll submit. May I approach? Yeah, I think it's almost in the vein, it's very close to the vein of what it was yesterday when they got back and Alessi told Bev, I want a curative, and I want curative instructions to the jury. And she was like, we discussed that. We discussed that. And like, you totally were like, no. And they're like, no, we had lunch, girl. We had some lunch and we talked about it. And we're like, no, we want some instructions here. And yeah, just change your stance. Like, they're not playing fair over there. But if anyone knows anything about,
I'll be right back.
Okay, BRB. If anyone knows anything about Hank, they know that he doesn't play fair. Also, he's a criminal defense attorney. The criminal defense attorneys, God love them. We need them all. But I mean, obviously, I'm like a huge fan of AJ. If everyone out there doesn't even know that yet, but they're their own breed, and AJ's in a breed amongst the elite because of what he can do, and that's why I love him so much, as his brain. But it's just it's insane what's been done, what happened yesterday. I'm still not fully over it, you guys. I don't know what's going to happen today. Ella will be back and she'll share more of that. Yeah, you guys heard her little frog in her pocket. Okay, that's not what it was. We're just doing things a little differently. Us doing things a little bit differently. What do you guys think? In the comments, let us know. Hi, Angel. But I do think that as the trier, the finder of facts, also, if people don't know this about the American justice system, because a lot of times people aren't like invested in that way, and I get it. Like, just because I have a weird thing about it doesn't mean everybody else would. But the judge is who runs the courtroom. That's why you hear, and you heard Lana and I were talking about discretion yesterday. They run that courtroom, but there's rules that you have to follow, right? You can't lose control of your courtroom. And Bev, from the gate, in my opinion only, has given up control to Morrissey. And that's just how they've been running with this. And these dirty, I won't cuss this early, break character. I don't even know. I'm really upset. But these dirty people have made it. They've just obviously been doing this for a long time. They've been doing this for so long that they think they can get away with it. This is it. First of all, reasonable doubt all day. All day, reasonable doubt, right? But beyond that, if for whatever reason they got some like crazy dirty person in that jury and they're going to taint it or whatever goes down, this is going to get overturned. There's no way this is going to stand. They preserved the record yesterday by telling her they want a mistrial with prejudice. And someone's going to step in at some point. I don't personally think they're going to go for an interlocutory appeal. But I do think that if Bev ever wanted to work in America again and not have to move to another country and not lose her reputation, she could, she could do the right thing and just uphold her oath that she took when she was a lawyer and then uphold another oath that she took when she became a judge to do what's right by a truth and justice. But I think she needs to recuse herself. This is not a mistrial for what happened in there is the lowest standard, you guys. The lowest standard. There is no lower standard. There needs to be more done. When you fuck around, excuse my language, this early in the morning, when you fuck around like that, okay? And you're that dirty. We see the fan. When you are that dirty.
Is that fan moving?
And it's moving at a good speed. You don't just go and get a mistrial. That's the lowest bar. That's an automatic mistrial. Automatic mistrial, okay? There should be heads rolling. There should be careers.
She glazed over that like my glazed donut, girl.
Did you?
Like she was just covering my donut with some glaze. No sprinkles, just a little bit of glaze. As I said, like she just was grazing over it with my glazed donut. So do you think that there's gonna be more talks about it this morning?
I do think the defense. I think the defense was I think they're gonna walk in there with a little bit more talks this morning. Do you know? Did you look at the docket and see if there's any?
Well, my issue is that I would have held off on oral arguing it right there and waited, because what was the difference to do that right there or at 4:00 or even like this morning? Because I would have been like super prepared to like lay like a crisp, like Krispy Kreme donut
on the theme of donuts.
So I just think that for me, there was no difference if it would have happened immediately when he talked then, or to be composed, talk with the team, do some research. That way you can make your oral argument on that. And there would have been like, I don't know. I think it was a little, I think I'm just kind of shocked, I guess you could say, that they maybe didn't talk and say, okay, do we want to say something about this now, or do we want to wait till 4:00? Just how that Bev is. Bev does not like surprises. Bev does not want,
I think their give a fucks are done. They don't give a fuck because she doesn't. They're like, we don't give a fuck what this bitch likes. Like, we are done. We're done having candor towards the tribunal. We are done having decorum. We're done. And I don't blame them at all. I feel like they're just like, we've spent enough money. Remember I was telling you this? We've spent enough money. This is going nowhere. She has her mind made up. She's corrupt as fuck. Let's just fucking throw it. We're going to the Supreme Court if this goes haywire. Like, whoever we paid for, bring them in. If we haven't, whatever. Because I still don't. I'm still like, I don't think they're going to be bringing in that witness that you want, LO. That we all want.
Oh, I'm telling you, Derek Ellington is testifying 100. Is that what you're talking about, Derek Ellington?
Yes, and I hope you're right. I hope
I
you're
know
right.
he's testifying. He
I
has to
hope you're
testify.
right.
I know he's testifying.
I really hope you're right, but I feel that they're just like, give a fucks are done. And they're like, fuck this shit. This is getting overturned no matter what. We're not wasting another fucking dollar. We're done. And
Gosh, I've never heard you say so many F words in the morning.
Oh, gosh. No, I'm upset about, I gotta calm down, but I'm really upset about yesterday.
Yeah, drink some more coffee.
I haven't drank anything because you started talking to yourself, and then I felt so bad about it. Yeah, I don't know, and just it peeves me off. Not to get murky, yeah. Busted Flesh. That is the digital forensic guy for the defense, Derek Ellington, not to be confused with Duke. Not to be confused with Duke Ellington. Oh gosh, now I feel horrible that no kids around. Shoot, because I didn't even think about kids that I'm cussing in front of. It's summer break, y'all.
Oh, I have a story for you guys this morning.
Oh, thank you.
Come on, let's go.
Oh. No F's given. So you guys, women doing false memories. Hi everybody. Good morning this morning. I didn't see the sign, you guys. What is happening? Yes, Duke.
How many PTA moms should I blow up this morning? Just what do you think? Wait, 2 or 3?
Only 2. That's the choices, like A or B. We only get 2 choices.
I mean, you know, between government workers and freaking logistics with schools, these people are why the world does not work. What a bunch of idiots. I mean, what a bunch of morons.
Oh boy. Already this morning?
Yeah. You guys, how many issues happen in the lunch lines or the pickup drop-off lines to go to school? More issues happen with people in pickup drop-off lines for school affairs than anything in life. I swear to God. Like, okay, true story just happened. You guys, I was like, I got out of the car, so I said, I'll be right back. I get out of the car, I'm like, can I ask what's going on right here? Like, what are you guys doing? Why is there a line like all the way back has like 200 cars? I'm like, why aren't we like dropping our kid and moving on? Like, what's going on here? These people are like, they haven't opened the door. I was like, how old's your child? What? We're all here for yeah. We usually just our kids can stand right there. I don't know why they're not opening the door, but like it's 2 minutes to 9. Like, this is supposed to be like a camp thing that they're doing for the children from 9 to 11. Are you being serious? Like, they're not opening up their doors till every day exactly at 9, and we're supposed to sit in a freaking parking lot traffic jam? I said, who's running this place? I said, I want to talk to whoever's in charge of the logistics of the line. How many people should I blow up this morning? I'm like, you guys can open this door at 8:45. Like, this is insanity.
You offered to help them with their logistics?
Yeah, I said, I want to know who's running the logistics. Dude,
Girl.
There was I'm telling you, there was at least 200 cars. I kid you not. I go around, get in the left lane, and just ride all the way up. And I pull up and I said, I want to find out what's going on around here. You know, what's up? What's the problem? Oh, the door doesn't open till 9. I said, why would the door not open till 9? I said, the last time I checked, it starts at 9, so that means the majority of the kids are going to be late. I said, no wonder why everybody gets marked late at this school.
Oh my God. Lana, did you
I was
get
just
him
lighting
upset?
everybody up.
Did you get
I
him
was like,
upset?
yeah, I was like, we're going to have some order to this line for this camp thing, whatever you guys want to be calling this. But I could tell you, I'm not waiting in no 200-person car line. And I said, and my son can stand right here for, and I think all of our kids are capable of standing here outside for 5 minutes, 10 minutes. I mean,
Can you
they're 10
multitask?
years old.
Can you pin my comment?
No, I can't.
Oh my God, I'm gonna have to write it again.
I
You have no idea what it does when you don't pin it.
let me see if I can. Let me see. I can't what I'm doing. What I'm doing right now. I can just wait.
Okay, guys, grab your Bev's bingo lingo card. 1 card per person, please. Yes, Lana, get him.
Well, no, I'm sorry, but I was just like, this is because I asked. I was looking and I was like, why are all these people just sitting here and not dropping their kid and proceeding on with the chlorophyll? Like, what's going on? Are they giving away stuff? Like, what's literally happening? And I was like, wait a second, this is how you think that you guys are going to run this line for the next 4 consecutive weeks? Refund now. Hell no. Because I can only imagine what you're doing for the 2-hour camp if it's being logistically run like this. You know it's just a shit show after that. My kid's doing 2 things. Because they don't know how to proceed with the chlorophyll. Why you 26 in the district with school results? Don't even get me started, PTA.
I can't with you in PTA this morning.
Yeah, because I said, well, don't you think the scores in the district reflect the teaching? Huh? Well, why do you think that we're 26th in the district? We should be like 4th. I was like, usually it's a reflecting of your teachers.
It's 26th.
I was like losing it on these people all year.
I was about to tell you it was 32nd, not 26th, but yeah, it was 26th because there's only 27.
It just takes one idiot in charge, and then it's a domino effect.
Oh, 100%.
You know what I mean?
It's the athletic director.
Hey, come on now. When I was popping over there, they're like, Lana, do you want to be the AD? I was like, oh, God. That means I have to go to all these sporting events. I hate that sport, and I think those people are crazy. No. That means you got to deal with all these parents. Woo.
Mm-hmm.
Yeah. Yeah. So, anyways.
Yeah. Anyways, so you think that they're going to come in with? I think
they're going to come in with some fire.
Yeah. So do I. And I think
they need to make another push for it. Because last night the only thing I thought that needed to be done differently was there was not enough emphasis on Hank's, the way that he laid out the question for Dr. Wolf. Like this wasn't like an aha moment that he had in the middle of trial or the middle of his questioning where he's like, oh my God, there's the holes in the shirt. Like this was
what was it?
Yeah. Oh, this was planned. This was part of his cross-examination. He had all weekend, Wolf testified on Friday. He had all weekend to prep for this cross. Even more so. That's just you know your case. Also, oh yeah, Lally has a duty. Lally tried the case last year. Lally would have known immediately, like, Hank, whoa, dude, those holes aren't from, like, that was done by our criminalist. So Lally has a duty. So I think that if anything in your argument, you need to say, Lally tried the case last year, Your Honor. Lally knew exactly, or should have known, what those holes were from, okay, in the back of John's sweatshirt, and he has a duty to correct the error, and he did not.
And that's true, you guys. That's not even, you guys, none of this is a fairy tale. These are written in the American Bar Association's rules for professional
Yes.
codes of conduct. But beyond that, every local jurisprudence, every municipality, they have adopted these rules and they call them their own, like whatever county you guys are in, they're just called blah county professional rules of conduct. And part of that is as an attorney, any attorney, if you see wrongdoing, you're supposed to report it because they're the ones. Doesn't matter what side
You
they're
have
on.
to not even just report it. You have to correct the record. We're talking about
Yes.
in a proceeding. In a proceeding, fuck reporting this. This is about in a proceeding. If Lally knew right when this whole thing happened, I'm telling you, because incompetence is not, and that's not a defense in it. Like, yeah, that's why they say you knew or should have known. Like your due diligence in this case, you all knew that they cut up the back of the hoodie and did it for samples. Get the hell, like that's
No, they
Maureen.
waited to get
No,
him
no,
on
no, but
the
no. I'm saying Lally knew it right away. Lally knew it right when Hank did what he did.
Yes.
Like he knew what he was doing.
100%.
He knew, like Lally knew
He
that
knew
it was
the game.
wrong. Lally knew that it was like that those holes weren't from anything, like to do with any incident. Okay, and so he should have told Hank, "Hey," and then when you want to talk about a mistake would have been Hank getting that information from Lally, Hank saying, "We need a sidebar." And then that's how, like, you bringing it out, and I could see like that's a mistake. He tried to get away with it. And it's like you do something and you ask for forgiveness versus please, that type of thing.
Yep.
And that's bullshit. And it was just so material. Like this is the most material piece in the case, which is, did John O'Keefe get hit by a car or was he bit by a dog? Like that's the question for the jurors, basically. Or more for them is like, did he, or is there some other reason,
What they did is it was so calculated, and in order to be on the Commonwealth side and not know what was going to happen, that's a fantasy. They knew what was going to happen, every single one of them. You know what? And the way Bev reacted and how she didn't even take any time to pontificate what was going on. And really, I mean, even just Bev, freaking pretend that you give a fuck. Seriously.
Yeah, that's, pretend. It's just, it's so material. It wiped out, like I was saying.
He definitely knew.
He had to do with like 6 people, like, or not that testimony, but that section, that cross, to say that those holes were from that incident, or Dr. Wolf, you didn't see those. I mean, that's just so material. Like that's.
And what Lana means by material to a case, when something's material to a case, it means that it affects the outcome of the case. So when something is material to a case, it's given a lot in appeals.
It's relevant. It's super relevant. This wasn't just some like oopsie, like, okay, like I feel like in the Rust case, it was like that got a mistrial, and that was over what I would consider like nowhere near as material as this.
Yeah, with the prosecutor. Yeah, I mean, that was pretty freaking a shame too, because she was like, she like was flinging her dick around on tables like everywhere, trying to slap everyone's dicks off with her female dick. But like, yeah, she just fucked up, but really bad. Not a fan.
So we have a motion this morning.
Oh, good.
Defendant's opposition to the Commonwealth.
Hey, hello.
Yeah.
Before you do that, I have to mute so there's no feedback. But before you do that, your mic on that, you might want to put it down so it doesn't do that froggy thing. Right now, it's being good. Whatever you're doing now, do that. So we can hear it good with your voice that we all love.
Okay, so is that better?
Yeah, whatever you did at the end was not good, but it was good.
Because I sat something down. I know what I did.
Okay, talk.
Okay.
It's really
thanks.
Okay.
Okay, so they put a motion in 8:43 this morning. June. Isn't today the 10th? Is today the 9th?
Hi. It shouldn't be. I left you alone for a minute. It is the 10th. It's not.
Okay. Well, this is interesting. Okay, so yesterday at 8:43 a.m., June 9th, defendant's opposition to the Commonwealth's motion to call witness in rebuttal. So remember how he wants to call the Commonwealth is calling Maureen Hartnett, Terry Coon, and Dr. James Crosby, but I don't think he's going to be calling Crosby, but I'm not sure. And it's to rebut Dr. Marie Russell's testimony. Ms. Reed further requests that the court limit the scope of Dr. Judson Welcher's rebuttal testimony. To date, defendant has received no discovery with regard to the proposed rebuttal testimony of Dr. Welcher. Defendant reserves the right to supplement the instant opposition with respect to Dr. Welcher's rebuttal testimony upon receipt of any new information. So the arguments are that, number one, the court should deny the Commonwealth's motion to call Maureen Hartnett, Terry Coon, and Dr. James Crosby to rebut Marie Russell's testimony. As a general rule, rebuttal is permissible to respond to the opponent's case. So the Commonwealth was thoroughly on notice of Ms. Reed's intention to present evidence showing that Mr. O'Keefe's injuries were caused by a dog and not by an alleged motor vehicle collision. Indeed, the Commonwealth vigorously contested the court's certification of Dr. Russell as an expert and was on notice of her intended testimony well in advance of the instant trial. Indeed, Dr. Russell testified at the first trial in this matter. This is, therefore, not a case in which the defense theory was suddenly advanced to the Commonwealth by surprise. Because the Commonwealth clearly knew well in advance of trial that Ms. Reed intended to present evidence that Mr. O'Keefe's injuries were caused by a dog, the defendant's expert testimony did not amount to new or unanticipated evidence presented for the first time at trial. For these reasons, the court should not permit the Commonwealth to call Maureen, Terry, or Crosby. Number two is the court should limit the scope of Dr. Judson Welcher's proposed rebuttal testimony. It states as follows. So the court should bar Dr. Welcher from testifying to any additional testing related to potential injuries to the hand or arm resulting from the forces of a motor vehicle collision. The Commonwealth was represented that Dr. Welcher is presently engaged in testing to show that the accelerations and loading on the hand, forearm, and arm associated with human volunteer impact testing, and B, intends to engage in additional human volunteer testing and literature review to examine the effects of load distribution on hand/arm forces and injury potential. These topics are improper for rebuttal because they are properly part of the Commonwealth's case in chief, and they are not responsive to any testing performed by ARCA. The Commonwealth bears the burden of proof for its allegations that Mr. O'Keefe's injuries were caused by a vehicle collision. The Commonwealth, therefore, could have properly presented testimony in support of this allegation, including Dr. Welcher's testimony proposed here as part of its case in chief. But it is clear that there is no right to present rebuttal evidence that only supports a party's affirmative case. And they're citing case law with it, so. Moreover, the proposed rebuttal testimony is improper because it is not responsive to any testing performed by ARCA. and does not therefore respond to the opponent's case. The Commonwealth and Dr. Welcher were free to determine the scope of Dr. Welcher's research and testing in the first instance. The law does not permit the Commonwealth now to supplement its case in chief under the guise of rebuttal. Supplemental material? Yeah, that's so great.
Wait. What did they say?
That is so awesome.
No,
I just
read
love
that sentence again.
the Commonwealth and Dr. Welcher were free to determine the scope of Dr. Welcher's research and testing in the first instance. The law does not permit the Commonwealth now to supplement its case in chief under the guise of rebuttal. This is what Liza got up and kind of said in the beginning. This is just the brief of it yesterday when she was saying that.
You are unmuted.
Oh,
All right, here we go.
hi,
Thank you so much, Karen.
Good morning. Thank you.
Now open and maybe seated.
All right, so I received a couple of motions a little while ago. Good morning, everybody, I'm sorry. And there are some things we need to talk about from yesterday. Are the jurors here? Okay, good. All right, so the order I'd like to do is, Mr. Jackson, yesterday you were going to take a look at any photographs you intend to put in with Dr. LaPosada?
Yes, those have been presented to the Commonwealth.
All right, can I just, are you all in agreement, or are you just looking at them now, Mr. Brennan?
I heard specifically from Mr. Brennan, but the issues that he had, obviously we're not, at this juncture, until we're heard further, we're not going to bring in anything having to do with dog bites,
Yeah.
claws, dogs in tissue, any of that information, but we are going to bring in exactly what we indicated yesterday. If there's an issue with, for instance, the ecchymosis, we've got a clean copy of the photograph without any of the narrative next to it, which is explanatory. The only one I think that does have narrative is the one with the Lucas machine, which Mr. Brennan indicated yesterday did not have issue.
All right,
Physicians would probably agree.
so I need to know, just for instructions to the jury about, I'm concerned about the photograph on page 5, figure 3.
The brainstem?
Yes.
Yeah, that's going to be, we intend to show that. That shows the,
So what I would like you to do, if you could, is just crop the center that shows what appears to be blood cells, or the red. I assume that that's the part you want to get into?
like, just have one.
Sure. If you can crop that, I'll let it in, and I still want to give an instruction, so I need to know what you're going to do with that. I was going to exclude it, but I understand, so if you can crop, yes, if you can do that, I think it takes away some of the sting on the gruesome photographs. All right, so you'll do just the brainstem on that, Mr. Jackson? All right. And so I'm concerned more about the ones that I think may cause the jurors some concern. So the photograph, figure 5, the Wisniewski spots, I thought that was in evidence. I don't know for sure if it's in evidence.
We went back and forth yesterday, and I don't believe that it's actually in evidence. It is not.
Okay, so
it's not in evidence. That was
okay.
Yesterday, we all assumed it was.
Yes.
I'll put it in evidence as.
All right, they've already seen it, so it's
Correct.
less likely to have an impact on them for purposes of the gruesome photograph. But and then on page 8, figure 6, the stomach lining.
Correct, that's already in evidence.
Okay, that's what I thought, Tori, you told me yesterday, the number, right? So those are in. So are you using them again?
I'm going to use them again comparatively and probably side by side.
Okay. All right, I don't have a problem with that, just the Commonwealth?
I don't.
Okay. All right. Those are the ones I was concerned about for purposes of an instruction. If there's objections to hearsay or something, I'll give Mr. Brennan an opportunity to take a look at whatever he's got.
Understood.
Okay. All right. So with that, that's helpful. Thank you. So there is a new motion this morning suggesting that the Commonwealth open the door with their questioning of Dr. Russell to allow Dr. Laposada to
Yes.
talk about bite wounds. So I've read that.
Yes.
Okay, sure.
Yes. This is yes.
I'd like to start, if I may, by marking two documents with code permission. One is Dr. Laposada's entire report, and the second
Oh,
is
great.
her entire CD. if that's
Okay. Yeah, those are the ones I needed from yesterday. So, yes. Yes.
Exhibits D, 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 and exhibits E, 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 E.
Okay. All right, go ahead, Mr. Jackson.
Thank you, Your Honor. We are asking the court to reconsider the court's ruling yesterday concerning Dr. Laposada and her ability to opine on the issue of dog bites, dog bite and claw mark wounds and pattern recognition. We had some concerns yesterday and previous to yesterday about an issue that has been ongoing with the Commonwealth, and we've brought this to the court's attention. The Commonwealth has been using a tactic to shift the burden to the defense with cross-examination that's laced with indications or implications about witnesses that may or may not be called by the defense. That is a problem. I brought it to the court's attention at sidebar. The court will probably remember that colloquy. It was not an open court, but I expressed grave concerns, to use that phrase, that there was a burden-shifting system that was going on when Mr. Brennan is asking our witnesses about, or his witnesses, about other witnesses that may be on the defense witness list and may be called. Obviously, as the court knows, foundationally, we don't have to call anybody. We don't intend to call anybody. We don't have to call anybody, but we can call whoever we feel like. But we shouldn't be put in a position where our hand is forced to call witnesses because of questioning by the Commonwealth, which is improper. After I brought it to the court's attention, Mr. Brennan has continued along that same line. The Commonwealth has continued along that same line, and I want to bring something to the court's attention specifically. Last night, we pulled the tape. Dr. Russell was cross-examined by Mr. Brennan on the issue specifically of Dr. Laposada and her opinions regarding dog bites. He asked questions over and over and over again. The colloquy probably lasted more than 5, 6, 7 minutes with Dr. Russell, specifically on the issue of whether or not she had seen Dr. Laposada's reports, whether she was aware of Dr. Laposada's opinions, implying that Dr. Laposada had opinions about the dog bites. She was asked if she was familiar with Dr. Laposada's credentials. Dr. Russell said, yes, she was familiar with Dr. Laposada by name, that she thought she had impeccable credentials, and she very much wished she could have seen her reports as it relates to dog bites. It was an intellectual curiosity by Dr. Russell that was evoked and elicited by Mr. Brennan on cross-examination of Dr. Russell. She was then asked the seminal question: did the defense, Dr. Russell, give you any reports by Dr. Laposada related to dog bites?
What page is that on here?
On the transcript?
Yes.
Oh, my motion's back at the desk.
Oh, I see it.
Does the court have it?
Yes.
Okay. I'll just read it. Question by Mr. Brennan to Dr. Russell. And so you think of all those forensic pathologists, medical examiners, you think that qualification and experience itself is not enough to qualify someone to give an opinion on a photograph about the genesis of a wound related to dog bites? Answer: well, if a forensic pathologist autopsied 1 or 2 cases of dog bite wounds versus my experience with over 500 to 1,000 cases of dog bite wounds, I'm not sure that person would be a very good expert in that kind of case. Question by Mr. Brennan: Have you ever heard of a doctor named La Posada?
So are you going to read all 3 pages?
No.
So I've read it, Mr. Jackson.
I'd like to
so,
read it into the record, Your Honor.
It's in the record. I will put this transcript into the record. I'm not going to let you read 3 pages here.
It's not 3 pages, Your Honor. It's about another 5 lines.
The
It just
part
goes to
that
the
you
top of the
brought
next
to
page.
my attention is on page 15, not where you're reading.
The colloquy between between Dr. Russell and Mr. Brennan was specific to dog bite wounds. It was specific to Dr. Russell's understanding of whether or not Dr. La Posada had been retained by the defense, whether she was a defense expert, whether she had written a report, and whether she opined about dog bites and dog bite wounds. And after she was asked if she had been provided any reports by the defense attorneys specifically, from Dr. La Posada related to dog bite wounds, Dr. Russell said, no, I haven't been. And to summarize her statements, which the court has in front of it, Dr. Russell went on and said, I really wanted to see what Dr. La Posada had to say about these dog bite wounds. I really wanted to read her report, but no, I was never provided her report or reports by the defense. And of course, Your Honor, as the court knows, that is standard operating procedure. I don't trade reports between and among experts because obviously I want independent analysis. I don't want to cross-contaminate any opinions, et cetera, and be accused of doing so. So of course we didn't provide a report from Dr. La Posada to Dr. Russell. But Dr. Russell's intellectual curiosity was then extracted from the witness stand and the jurors heard all of that. So then days later, not weeks, not months, 3 days later, after eliciting testimony from Dr. Russell about Dr. La Posada having a report, being hired by the defense on the issue of dog bites and not providing that report to Dr. Russell, the Commonwealth then moves to exclude the very testimony that he was eliciting from Dr. Russell, leaving the jurors with a very, very deep and irremediable misimpression. They used it tactically as a sword and a shield, and that's burden shifting. That leaves the jury with the impression that Dr. La Posada was consulted by the defense, number one, that she wrote a report, number two, that the report was about dog bites, number three, that she didn't provide that report to other experts, number four, and the reason she didn't, obviously, is because her opinion, Dr. La Posada's opinion, would be harmful to the defense. That's the only reasonable interpretation of those facts. And the Commonwealth has taken advantage of that. The Commonwealth's questioning of Dr. Russell about Dr. La Posada and her report and her opinions about dog bite wounds specifically was deliberate, and it left the jury with an open question. We know they consulted her. We know it was about dog bites. This is how the jurors are thinking about it now. We know they consulted her. We know it was about dog bites. They hid the report from Dr. Russell because they didn't want her to know about it. Ergo, must be harmful to defense. Now we've got Dr. La Posada on the stand. Her credentials are peerless, absolutely peerless. They've got possibly the most qualified medical examiner in the country, certainly on the Eastern Seaboard, right in front of them, about 6 feet away, and the defense is not going to ask a single question about her opinions concerning dog bites when she reviewed the entire autopsy. How is the jury going to conceive that? How is that going to land with them? The answer is they're going to think, they have no choice but to think, the only reasonable explanation is, if Dr. La Posada's opinion helped the defense, they would ask her. If they don't ask her, it's because whatever Dr. La Posada says about that right arm and those wounds, it's got to be harmful to the defense. They would absolutely ask the question. So the Commonwealth got to have it both ways. They got to ask Dr. Russell about Dr. La Posada and imply that Dr. La Posada had opinions about dog bite wounds. And then they have it the other way, which is, let's ask the court if she will exclude Dr. La Posada from testifying about the very issue that they brought up in front of Dr. Russell. That cannot stand. That ensures It reasonably ensures that the jury will misrepresent or misunderstand the import of why we're not asking Dr. La Posada about her expert opinion, especially as it specifically pertains to dog bite wounds. I want to talk for just a second, and that has, by the way, that has constitutional implications. Ms. Reed is entitled to a fair trial, not a fair trial that the Commonwealth designs, not a fair trial that the Commonwealth curates, but a fair trial. Regarding Dr. La Posada's credentials, we went back through, specific to the court's questions yesterday, her resume. There are no fewer than 13 classes, 13, that she has taught specific to wound pattern recognition that have included dog bite recognition. On page 7, she was the course director for medical legal death investigation. That was in 2013. She taught about dog bite recognition in that case, or in that course. She was a thesis advisor for Master of Science Graduate Medical School, Boston University School of Medicine, taught about dog bites. Staying with page 7, forensic pathology course director in pathology, course 205, taught about dog bites. Member of Quality Assurance Committee, Training Division of Trauma and Surgical Critical Care, teaching on the issue of wound recognition, animal bites, and specific to dog bites. Pediatric forensic pathology, Texas Homicide Symposium. She was a presenter in 1989. She taught about the issue of dog bites as it relates to pediatrics, children, dog bites in children. Forensic aspects of physical child abuse as related to being left with dogs that can injure a child, dog bites, dog bite recognition. These are all classes taught by Dr. La Posada on the issue of dog bites to other medical professionals. The one that stands out, however, and I'm not going to go through the other 9 or 10 or 11, the one that stands out is 2015 and 2016, 2 courses. The name of the course, Emergency Room Forensics, Evidence and Patterned Injuries, New England chapter of the International Association of Forensic Nurses, taught in Norwood, Massachusetts, both times, specific to dog bites and the issue of dog bites as seen by emergency room physicians, how they should handle them, what they should do with them, how they should view them, what to look for in terms of pattern recognition. She's eminently qualified. I will leave the court with one thought. The court indicated when qualifying Dr. Russell, one of the preeminent things that the court mentioned in qualifying Dr. Russell is that Dr. Russell utilized a methodology that the court sanctioned and quoted and said the methodology that she used of wound pattern recognition, dealing with differential diagnosis, utilizing and interpreting dog bites by the method of exactly what Dr. Russell did. Differential diagnosis is something that the court said was exactly why the court sanctioned Dr. Russell and blessed Dr. Russell as a qualified expert, and that's exactly what Dr. La Posada testified yesterday she utilized and utilizes in coming to her opinions and conclusions. Going back to the open door issue, obviously she's eminently qualified, but Your Honor, this cannot stand. The Commonwealth cannot have it both ways.
100.
They cannot walk up and say and leave the impression with the jurors that Dr. La Posada opined about the dog wounds, but we're not able to hear it. We, the jurors, are not able to hear it because obviously that is something that is her opinion, whatever it might be, is harmful to the defense. When in truth and in fact, it's exactly the opposite. Dr. La Posada's opinion has never wavered. Those injuries on John O'Keefe's arm are from a dog, period, full stop. Anything less than presenting that to the jury at this point would be to perpetrate an intentional fraud on this jury. Ms. Reed is entitled to more. She's entitled to better. She's entitled to the evidence.
All right, thank you. Mr. Brennan?
In layman's term, the jury's expectation to hear from La Posada, and Hank brought that expectation on.
The pattern of conduct that stands out is persistent, repetitive, contrary to court rulings and court orders, and deliberate. And that is the defense uses their witnesses to vouch for their own credibility. They use their witnesses to introduce information they know is not admissible. And they use their witnesses to introduce otherwise inadmissible hearsay. Dr. Russell took the stand and she was led into answers where she was vouching for her own credibility. Dr. Russell promoted herself not only as an expert, but through the defense's questions as virtually the only expert in America who has the expertise to give this type of opinion. It is the defendant's tactics that open these doors that they then want closed. The defense had Dr. Russell all but assure the jury that she uniquely was in the position to give any type of opinion regarding dog bites. Inevitably, when I asked Dr. Russell, and I began asking her about her credentials, whether she thought that she was exclusive, and I mentioned Dr. La Posada, she denied ever reading anything about Dr. La Posada. I did not specify whether she read an opinion about a dog bite. I asked if she had heard about Dr. La Posada. She denied it. And then she told us that she knew about Dr. Sheridan. Unsolicited, then added that Dr. Sheridan, involved in a previous proceeding, believed that the bites were consistent with dog bites. I don't know how she became aware of Dr. Sheridan's testimony, and since the defense doesn't speak to her about these things, she must have watched it on her own. But inevitably, she introduced inadmissible hearsay and inadmissible opinions. And so the sum zero here is that Dr. Russell has denied that she saw anything relative to Dr. La Posada, ensured that she was exclusively qualified, and introduced an improper opinion. As it pertains to dog bites. We asked her questions about her specific experience. She did not provide a basis, and so her opinions regarding dog bites should not be permitted in this trial.
Just to clear up the record, two things stand out about that speech. Mr. Brennan literally just said, I didn't elicit any information about dog bites. I just asked about her experience. Question by Mr. Brennan.
That's not what I said. That is
Excuse me.
No, I'm not going to.
So
That's not what I said.
I heard what Mr. Brennan said. You don't need to tell me what Mr. Brennan said, but go ahead to
How
your
about if I quote
argument.
his words? How about that? Question. And so you think of all those forensic pathologists, medical examiners, and you think qualification and experience itself is not enough to qualify somebody to give an opinion on a photograph about the genesis of a wound related to dog bites. The question was specific to dog bites. That's how he introduced the subject matter to Dr. Russell. Then his next question was, have you ever heard of a doctor named Dr. La Posada? Those were his words. Then he goes on, I think he also just said that he did not elicit information about other individuals, including Dr. Sheridan or anybody else. Question by Mr. Brennan. Were you ever told what other people's opinions might be regarding those photographs? That's the question that she was answering when she said, quote, I'm aware that there was a Dr. Sheridan involved in a previous proceeding, and he believed that those were consistent with dog bites. That was in relation or in response to Mr. Brennan's specific question. She didn't just elicit that. She didn't volunteer it. She said it because he asked her. And that was all by design. The entire thing has been by design. He elicited the information suggesting that Dr. La Posada was being hidden from Dr. Russell because her opinion would harm the defense. He left that with her on purpose, then turned around and 3 days later said, and by the way, the defense should be disallowed from using Dr. La Posada to talk about the very dog bite wounds that I asked Dr. Russell about. That cannot stand in this courtroom.
Exactly.
Go ahead.
It's helpful if you read the entire thing in context, which I won't do. We always have a right to object to an inadmissible opinion. So the suggestion that somehow an ambush here is not only misplaced, it's strategic by the defense to try to create an error. It's improper.
All right. I'll be out in 10 minutes on this and we'll get started right away with Dr. Lapasada.
Okay, here we go. She's totally gonna
So she's
sigh.
gonna
Go with,
pretend.
she's gonna know. She's gonna go Hank's way, or not Hank's. She's gonna go Alan Jackson's way. Whenever she rules and goes back to this is her tell. Whenever she goes back to think about something, okay, that's whenever she rules from the bench, it's always in favor of the prosecution. So here she's going back, and she said she'll be back out in 10 minutes. Well, I just want to break this down for layman peeps. Bottom line is that the jury's expectations to hear from La Posada came from Hank and the way that he cross-examined Russell. So the jury is thinking, okay, La Posada, okay, oh, here's Dr. La Posada. We're gonna hear, from her. But during the cross-examination of Dr. Russell, okay, he's doing what AJ just showed you he did. But then what the jury does not know is that then Hank, behind the scenes, so Hank brought the expectation on that Dr. La Posada was going to be talking about the dog bites or the arm, which then she's going to opine that's dog bites. Then Hank, behind the scenes, tried to take it away by motioning after he knew, meaning Hank knew, what he just did by asking those questions on cross-examination to Russell and what he just put in the brains of the jury. That's what AJ says. This was all by design. And so again here, it's Hank's orchestrating and manipulating and using, when he says a sword and a shield, he's using emotion behind the scenes, preventing Dr. La Posada from being able to speak on something, but the jury doesn't know that. And here the jury is just going to think that Alan Jackson doesn't ask any questions about this.
Right. They have an expectation,
Yeah,
and it's
their
not going to be met.
expectation. Yeah,
And
and he's
they're going
saying,
to put that on. They're going to put that burden on the defense.
well, no. Not only did you just put it on me, but then you took it away. Like, you're not only just burden shifting here, okay, but we have the right to ask her these questions, all right? And here, Bev then just takes it away from us because of Hank's motion. But by design, he already fucked with the jury's brains because of that expectation. And then it's going to look like that they're hiding that Dr. La Posada, the way that Hank made it seem like that Dr. La Posada is not going to agree with Russell. And that's exactly the impression that the jury would get, because why wouldn't the defense ask her those questions so that they can have people agreeing? You know what I mean?
Of course, yeah.
And then, but this is going to be the best part about it, though, is if you're a dumb jury person, sure, yeah, you'd believe that. But how about this? Why wouldn't Hank then on cross-examination, if it was in fact La Posada felt differently, then why wouldn't Hank solicit that in cross-examination? But more importantly, why would they even ever call Dr. La Posada in the first motherfucking place? To get what, like, this is absolutely absurd to the point of just like, dude, we're playing Monopoly and I get no money to start with, and you have fucking hotels and cash.
And you have Park Place.
Yeah. I mean, who wants to play Monopoly like that?
Nobody.
Nobody.
Who
And
says
and then Hank literally had the audacity to get up there and misstate the record again, which is misconduct, because he keeps on doing it. Interrupts Alan Jackson. You're not supposed to have, like,
You're never so, you guys. That's why Alan Jackson said, "Excuse me." Like, you're not supposed to do that. It's his turn at the podium.
yeah, it's so obvious that it's so blatant obvious what Hank did by asking Russell that. And then he gets up there and he just tries to tell Bev, no, this is what the defense has been trying to do. What witness? Wait, Hank, let's just start from the beginning. It's your case, you dumb fuck. You called 40 witnesses in this case,
Okay, how can the defense be doing anything yet? Then it's their turn to go. Which one of their witnesses is
All right.
validating somebody else's
So I'm
testimony?
not going to allow Dr. Laposada to testify regarding dog bites.
Get out of
Rights
here!
are saved.
Told
I'm
you.
going to give an instruction regarding burden shifting. So
Her instruction's gonna suck.
Wait,
Conduct is outrageous, and I don't think that a purity instruction can do anything except bring the point home again.
okay.
But if the court is not willing to allow her to testify to her full opinion, to immediately read scientific instruction,
then we're not calling her.
she should at least testify that she reviewed the arm, looked at the arm, and it's consistent with an animal. Can we at least split the baby?
I will do that. I'll allow that. Yes. Over the Commonwealth's objection.
Can I look to have the cross-examiner? Because if you're going to allow a consistent opinion with a dog,
No, Mr. Jackson said animal.
I'll leave it at animal if that's what I can get. I'll take what I can get.
In her experience, Mr. Jackson, you have to lay a foundation. In her experience, seeing animal bites, this is consistent with what she has seen in an animal bite.
And that will include, I'll come to sidebar before I display anything, that will include a representation of what an animal jaw looks like.
No. No, it will not.
Why is that?
That's my ruling, Mr. Jackson.
So no visuals.
No visuals, just that one sentence that's consistent with what she has seen. It's an animal bite. A brief foundation, because I'm letting that statement in as long as she has said, as long as she testifies that she has seen animal bites over the years. That's it, Mr. Brennan. That's what I'm doing. So you don't want an instruction, Mr. Jackson? Okay. All right.
No, I wouldn't want
So
to.
there are two other quick matters, but the jury's been here, and I don't think we'll get past the break without this anyway. I may have left it in there. I left it in my office anyway. So let's just bring the jurors in and move forward with this. All right, Paul, I'm just going to.
I agree, Lana. I wouldn't want a jury instruction from her after what I saw yesterday.
Yeah, nope. I don't want her saying a word. I want to close her mouth, and you know what? But
I'm really proud of him for saying, then I'll say animal.
yeah, then split the baby. You're gonna give me something here, homie.
Mhm.
Like,
I like it.
like I can't even believe it's the most. But if he can get that out, the jury's gonna at least.
Yeah.
I'm sorry, but I think that jurors should be able to, after they watch something, they should be able to say, had I known this, and this, for what it's worth, like.
I mean, they can say it, but what are you saying? That they should be able to go back and change?
No. I just think that you should create a record of it, okay? Because at the end of the day, this is about discretion, okay?
Right,
And I think that it should play into the role down the line in appellate terms, that if jurors were confused, why are we saying someone's innocent or not guilty or guilty, and a juror's over here confused as hell? Like how are they making this decision? And they're just like, well, had I known this, and I get that you're trying to say that's not admissible, okay? But is it just because that's your discretion to do what you did? And so I just think that jurors should have some way to communicate, like
On the record.
the different pieces of a case, because this is just. This case is setting precedent. I mean, that they can cite the Reed case and how Bev ruled in her little like sayings. Like, how embarrassing for like the criminal justice system.
And it's like you were saying yesterday, also, these are also career enders, these cases, because of what she did to Dr. Laposada yesterday, what Bev was saying. What Hank was saying, what Bev was allowing, and everything rides on like, hey, were you, because Alan even asked her on the stand, have you been an expert witness? And yes, I have in other cases.
Yeah.
And so someone can use that against her. Like, were you told that you weren't qualified
And I
on a
think Hank
case.
has to go this way because of what, I didn't mean to cut you off. Go ahead. It's just because of his witnesses being discredited off of like their, like, they lied on TVs and whatnot. But it's like, I, I, I don't think they should be able to attack people like this on the stand, and this is going after someone's career. I think it's just, this is improper.
But what really needs to happen, you guys, the bar is not the lowest standard here is a mistrial. That's an automatic, in my opinion. That's what should have happened. But what needs to happen now here is there needs to be a mistrial. There needs to be sanctions, and there needs to be disqualifications from the bar and carrying a card to be an attorney, if that's for only a year.
Also, I agree here with exactly how Brett said it. How is the judge gonna tell anybody what a medical, like, expert, your physician, is a judge going to determine if that person's qualified or not qualified to testify as an expert to something that, I mean, they don't know any of that stuff. That's why I just think that we put so much, like, that a judge knows all this stuff, or like that a police officer knows all this stuff. Dude, 99% of cops became cops, and then they became detectives because they couldn't get into college. That is a fact.
You are unmuted.
You have 1% of cops that went into it because their families are all cops, or that they absolutely loved and wanted to help people. I'm telling you, you know how many people that I knew, oh, I'm going to just go to, I can just go be a cop and do 6 months of whatever. Why would we want people like that going and being cops?
In the LAPD, they had, like, people stopped after the LA riots, and they had to lower the standards and the height requirements. So, like, all the short people
Just for running over there.
became cops, and like you could tell who became a cop after that got put into place.
You only have to do 5 sit-ups in a minute now.
Like, we'll just lower the bar. I mean,
but the way that okay, let's start.
For the Honorable Beverly Kennedy, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. By the state of the Commonwealth of Massachusetts, this court is now open. You may be seated.
Good morning, jurors. Thank you for your patience this morning. I know we brought you in late. Maybe should have brought you in a little bit later, but we've been working in an effort to sort of streamline things for you. So I do have those questions I have to ask you. Is everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shaking. All right, can we have Dr. Laposada back, please?
I would just come out the gate, ask her those questions, and move on. Like, say, no more further questions.
You're still under oath. Thank you.
Thank you. I will.
Limit his scope.
Your Honor.
Dr. Laposada, witness again. Oh, bless her.
All right, Mr. Jackson, go right ahead.
Thank you, Your Honor. Good morning, Dr. Laposada. Nice to see you again.
Good morning. Glad to be here.
Yesterday, when we last left off, we were talking about a small injury to the upper eyelid of Mr. O'Keefe. Do you recall that?
I do.
Could we have Exhibit 165 with the court's permission, please?
Okay.
I'd like you to take a look at a specific area. I could. There we go. Right here on this exhibit. You see that area?
Yes, I do.
Tell us what that is.
And that is a horizontal splitting of the skin, which was caused by application of force that overcame the tissue's resistance, so the tissue split. And behind that, we see the raccoonite discoloration of the eyelid from the basilar skull fractures.
Can we have Exhibit 13, please? I want to draw your attention to this area of the vehicle. First of all, do you recognize this photograph?
Yes, I do.
How do you recognize that photograph?
I recognize it from looking at it in my materials reviewed, that it's the rear of Miss Reed's SUV.
Taking a look at the area that I'm highlighting, right about there.
Yes.
Could we zoom in on that area? Do you see that overhang over the window?
Yes, I do.
If I use the word spoiler, would you understand what I'm talking about? If we call that a
Yes,
spoiler?
yes, I do.
Is the laceration to Mr. O'Keefe's upper eyelid that we just looked at, is that consistent in your opinion with a strike from that area of the vehicle if that vehicle were traveling in reverse at, say, 20 plus miles per hour?
No, that rounded, thick area would not cause that skin defect in his upper eyelid.
If, in fact, a person were hit at, say, 20 plus miles an hour in the face with that rounded edge, what kind of what kind of injury would you expect to see on that person's face?
I would expect to see a ribbon of bruise that would correspond to the height of that spoiler, and it would go across the eyeball, it would hit the nose. So I would expect to see some horizontal ribbon of bruise.
Did you see anything consistent with that, with Mr. O'Keefe's injuries?
No, nothing.
Thank you. We can take that down. We talked yesterday about this phenomenon known as coup contra coup injury to the brain, correct?
Yes.
What happens to the brain after a coup contra coup, a significant coup contra coup injury?
Yes, this was quite a severe brain injury. Was injured on the back of the brain and also the front of the brain. The falling back and impacting the back of the head made the skull fracture radiate along the base of the brain on the right and left sides. It also radiated around on the side of the skull, and that indicates a tremendous transfer of force and energy to the skull and then to the brain, and the brain is rattled around, therefore, within the cerebral spinal fluid in the skull. So what that does is that it breaks the connections between the neurons in the brain and causes small little hemorrhages, and it causes the brain to swell. So when you get an injury, like if you get an injury on your arm, it starts to swell. The same thing happens when that injury energy is applied to the brain. The brain starts to swell. And unfortunately, the brain, when it swells, it doesn't have anywhere to go because it's encased in the skull. So what happens is that the brain and the brain stem under the brain starts to go down the opening in the base of the skull where your spinal cord goes. And that is a harbinger of death, because that means that the brain stem is getting pushed down in this hole in the skull and compressing the areas in the brain stem which control the heartbeat and breathing. And that's called brainstem herniation, and that you just die after that. So that's what happened to Mr. O'Keefe's brain.
Doctor, can you take a look at that document that I just handed you and tell me if you recognize it?
Yes, I recognize this.
How do you recognize that document?
From looking at the autopsy photos of Mr. O'Keefe's brain.
And what portion of the brain are you looking at?
This shows a photograph looking up under the brain, and it shows a cross section of the brainstem that went down in the hole in the base of the skull, and we see there's hemorrhage in it, and those have a special name. They're called Duret hemorrhages.
How do you spell that?
D-U-R-E-T with there's a little accent somewhere there.
Caret over the E?
Yes. And this shows that the brainstem is going down into the hole where the spinal cord goes. It's stretching the blood vessels and causes little hemorrhage and compresses the neurons in the brainstem, which control your heart rate and your respiration. It's called brainstem herniation, and that's a harbinger of immediate death.
Your Honor, with that, I would ask for the admission of that document is next in order, subject to the appropriate actions.
Okay, so we'll take that into evidence. Yes.
Your Honor, with the court's permission, with the redaction, may I present the...
Not yet. 1 minute. Jurors, I told you before that there were photographs that have been introduced into evidence that aren't pleasant. And you may find that these photographs are graphic. And I'm instructing you again that your verdict must not in any way be influenced by the fact that these photographs, you'll see some more today, I believe, that have already been introduced into evidence. So your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant's entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by the photographs. Importantly, consider the photographs only as they may draw your attention to a clinical medical status or to the nature of Mr. O'Keefe's injuries themselves. So again, these will be presented to you in the deliberation room in an envelope. But today you'll see some on the screen, and I just wanted you to know that before you see it. So now you can display it.
Your Honor, may I approach very briefly?
Yes.
If you wouldn't mind taking a look at that document.
Oh,
Is that
yes.
a redacted version or a closer version of just the brainstem?
Yes, this photograph shows the cross section going this way of the brainstem with the hemorrhages caused by the brainstem going down into the foramen magnum.
With that, Your Honor, actually, I think with the court's permission, I would trade that as the next in order rather than the unredacted version.
All right, is there any objection to switching the exhibits like that?
No.
Okay.
Thank you.
Oh, and the arrows point to that on there.
So this is going to be the next exhibit,
That'll be it.
exhibit 225, Mark.
Thank you. The other one will be for identification, the first one.
Thank you, Your Honor.
And that'll be FFF for ID.
Okay, you can display it now.
Thank you, Your Honor. Mr. Walt? Do you see what's displayed on the screen above your head?
Yes,
What is that?
excuse me, that's a cross-section across the brainstem of Mr. O'Keefe, and it shows where the blue arrows I've put in there show the red areas, which are areas of bleeding, which is the sign of brainstem herniation. All the background is white material, and that's part of the appearance of neurons in the brain. So that shows that the brainstem, because of the brain swelling, pushed it down into the hole in the base of the skull where the spinal cord goes, and it pulls on the blood vessels, causing the blood vessels to break and the blood vessels to bleed, and that shows you that the brainstem has been compressed and damaged, causing death.
May I approach?
Yes.
I'm holding a green laser pointer.
Oh, thank
If you
you.
use the display to your right, so the viewers can better see it, could you point to the areas with that laser pointer of the bleeding that you indicated causes the swelling?
Okay, so, okay. Is that going on the?
It is. It's
Okay,
probably
thank
hard
you.
for you to see.
Oh, that's okay. So this sort of roundish thing is the brainstem, and the arrows are pointing to the red areas. So there's a blood vessel that's broken there because it's been torn and pulled, with surrounding blood going into the neuronal tissue here and over here and over here. And also some of this is also bleeding, with the blood looking brown because the brain was placed in formaldehyde. So all this brown area, the red area, should not be there.
Is this type of herniation life-threatening?
It causes death. Yes, it is life-threatening.
How quickly, we can take that down. How quickly, doctor, would you expect that this could cause, let's first talk about incapacitation.
Yes.
How quickly would someone be incapacitated after they suffer a coup contra coup injury of this magnitude with the concomitant injuries that you see in the brainstem?
Well, there would be two parts to what that injury would cause the body to do. First, there would be immediate unconsciousness because of the transfer of all the energy to the brain and the massive skull fractures. So that, excuse me, so that would disrupt the normal function of the brain and produce immediate unconsciousness. Then the brain would start to swell, and within 15, 20 minutes or so, then that brainstem starts to go down the opening in the bottom of the skull, and then the blood vessels are broken, the brainstem gets compressed, and the centers in that brainstem which control the heart and the respiration then stop. So you go unconscious, brain swells, then you die.
Turning to the actual, your review of the actual brain, in this instance, Mr. O'Keefe's injuries specifically, did you reach any conclusion or opinion to a reasonable degree of medical certainty about his incapacitation, the length of time it would take for him to become first incapacitated and ultimately to be rendered dead?
He would be immediately incapacitated with a decreased level of consciousness. Once he received that impact on the back of the head, he would not be able to make any purposeful movements. There might be some arm jerking or some seizure activity, but he would not be able to carry. He wouldn't be able to get up. He wouldn't be able to walk. He wouldn't be able to do any purposeful activity. He would be severely concussed, unconscious, not able to walk, not able to carry out purposeful activity. And then as the brain continues swelling and that brain stem gets compressed, then the heartbeat is disrupted, the breathing is disrupted, and then those heart and breathing stop. And within 15 or 20 minutes, then he could be dead.
Is that opinion to a reasonable degree of medical certainty?
Yes, it is.
You testified concerning wound pattern recognition pretty extensively during the course of your giving your qualifications. What is a patterned injury?
A patterned injury is very basic to the training in forensic pathology and medicine because it helps us understand some change on the body some pattern injury that corresponds to the object that made it. So we can look at an injury and say, we can figure out what made that. Sometimes you can, sometimes you can't. But a pattern injury is very important for a forensic pathologist to recognize, because it's going to really help the police investigation. Because I could say, oh, this looks like it's a wound from scissors. This looks like it's a wound from a screwdriver stab. So by identifying the pattern that that object makes on the body, I can help the death investigation by helping the police say, you know, look for some screwdriver, look for some hammer. So looking at that, identifying a pattern injury is really important to it's basic to the forensic pathologist's knowledge base, and then also very important to the investigation of the crime or incident.
I'd like you to look at another photograph, an exhibit that's already been put into evidence. 160, please, with the court's permission.
Yes, jurors, this may be one of the photographs as well. Right. Or there'll be a series.
Dr. La Posada, I want to draw your attention to the center of this photograph.
Yes.
First of all, do you recognize what's depicted here?
Yes, I do.
How do you recognize?
I recognize it from reviewing the autopsy photographs of Mr. O'Keefe.
You reviewed it, informing your opinions and conclusions?
Yes.
Can you describe what's depicted in this photograph? What are we looking at?
Yes. So we're looking at the back of Mr. O'Keefe's head and an injury caused by the angular acceleration going down and hitting his head in the back. And then this is also a patterned injury. So what we see is the horizontal tear of the scalp, and we can see it's undermined a little bit. So that means the direction is going from bottom to top. Also, we see these sort of vertical lines in here and down below. So what that tells me is that the back of his head hit something that had a fine granular pattern to it to cause those individual little marks, and then also something that had a linear or ridged pattern that he went back on that broke the scalp there. So we have two parts really to this pattern injury. We have the horizontal tear of the scalp made by impact with some sort of ridged surface. And then we have these vertical scraping of the skin above and also below. They're obscured a little bit by the ruler there, which says that whatever he hit had some little like granularity to it, with each little sort of granule making those vertical marks, and then the ridged pattern having the major point of impact.
What is the significance of the pattern when you say ridged pattern, and there's two things we're looking at, the laceration or the abrasion versus the defect above and below that laceration?
Yeah, so what this injury tells me, or what I would tell the investigators, is that Mr. O'Keefe went back onto some object that had some sort of ridge to it to make that horizontal tear in the skin, but that ridge also had, it wasn't smooth. It had some little grainy grainy things sticking up on it that would make each of then these little things. And then it's the job of the police then to go back to the scene and look around for something which might fit that pattern.
We can take that down. Did you, in furtherance of your investigation, coming to your opinions and conclusions, look at the area of 34 Fairview?
The outside, yes.
Meaning photographs?
Yes.
Did you also see photographs of any significance to you related to the garage, the interior of the garage?
Sustained. Jurors, disregard that comment, that question.
What part of the area did you see? What part of the location did you see?
Excuse me. I saw all the scene photographs taken by the police, which showed the front yard in the area where Mr. O'Keefe was found. I also saw some photographs of the inside of the house and the inside of.
So I'm going to stop you there, Dr. LaPasada. Jurors, I'm striking anything after what the pictures from outside, Mr. Jackson. Move on.
Let's stay with the outside of the home. Did
Yes.
you see the front lawn area?
Yes, I did.
How did you, what did you note about the front lawn area?
Well, I was looking at the area where Mr. O'Keefe's body was found, because we know once he came back and slammed his head, he's not going to get up and move around.
So, yes, I'm going to strike the second part of that. Just answer the question specifically.
Okay, I'll try, Your Honor. Thank you.
Why were you interested in the outside area where his body was found?
Because then I could identify an object possibly there that would have caused the injury on the back of his head.
Did you see any such object in any of the photos that you reviewed?
No, there was nothing there. It was a flat grass surface.
Would the flat grass, let's assume that the grass was very cold and very hard, the dirt was very cold and very hard. Would falling backward onto that dirt, hard or not, would that cause the patterned injury that you see, that we just saw in Exhibit 160?
No.
Why do you say that?
Because if you fall back on a flat surface, you get many times the tear you get in the scalp can be more like a star, because you've just hit one part and then the tears go in kind of a star pattern. And also because you would not have those discrete vertical scraping of the skin. You would tend to, if you fell back on grass, you would tend to see, you might see grass in the wound, or you would tend to see an irregular kind of crisscross pattern of the flattened grass. And that's not what we have here on Mr. O'Keefe.
Do you have any training or experience in diagnosing hypothermia in individuals?
Oh, yes.
Have you conducted autopsies of individuals who've suffered from or died from hypothermia?
Yes, many.
How many?
100 or more, and then I've supervised my assistants who've also diagnosed the same death from decrease in body temperature.
Have you ever engaged in any death investigation, aside from the actual autopsies, death investigations in which the cause of death was deemed to be hypothermia?
Yes,
How many times would you say you've undertaken that type of investigation?
at least 100.
Have you ever reviewed any peer-reviewed medical literature associated with or discussing hypothermia and something known as Wisniewski spots?
Yes, that's in the medical literature and also in our forensic textbooks.
Did you review the medical examiner's file, Dr. Scortibello's file, as it related to, in connection with this case, you reviewed the entire file, correct?
I did.
Did you conduct a differential diagnosis as it relates to the potential for hypothermia?
Yes, I did.
Describe, before we get into your findings or your conclusions and opinions, what is inferential thinking?
Inferential thinking is another name for making a differential diagnosis. In other words, seeing a finding and then saying, how many ways can I get that finding? And then go and investigate each one of those ways and either rule them in or rule them out as being responsible to causing that finding.
Did you note whether or not the medical examiner, Dr. Scortibello, mentioned hypothermia as a potential cause of death in this case?
She did put that on the death certificate,
Along with something else?
along with the blunt force head injury.
Do you agree with or concur with the blunt force head injury
Yes,
as a cause of death?
Yes, Mr. O'Keefe died from the blunt force head injury.
Do you concur with the diagnosis of hypothermia?
No, the body did not have any hypothermia.
What led you to that conclusion?
Well, when you have we know that normal body temperature is around 98, and we know that then at the hospital that Mr. O'Keefe's rectal temperature was around 80. So we know that his temperature went down. So there are two ways the body temperature can get down. It can get down while you're alive, or a dead body also cools when it's in a cold environment. So those are the two things you have to look at.
Boom, that's awesome.
Take a look.
No one's ever said that.
I'm sorry, Mayor Coach.
Yep, show Mr. Remington.
If he
Thank you, I apologize.
died instantly almost.
Do you recognize what's depicted in that photograph?
Yes, I do.
What is that?
This is a photograph I took from our forensic medical literature, and it shows the lining of the stomach. So the stomach is opened up, and we look at the lining of the stomach, and it shows a characteristic pattern of small ulcerations throughout the stomach, which are called medically Wisniewski's ulcers. And that allows a forensic pathologist to diagnose death from being exposed to a cold environment or death due to hypothermia. And they're caused by, as the body gets colder and colder when it's alive, these small blood vessels in the lining of the stomach, they start to break, and then they're in the acidic environment of the stomach, and you get tiny little ulcers, which then look like small dots. And that is how at postmortem examination or autopsy, it's one of the findings I look for to see if a person died from hypothermia.
Doctor, what is gastric mucosa as it relates to the stomach lining?
The gastric mucosa, when you open up the stomach and you look at the inside, the first cells lining that inside is called the mucosa.
Is that what we're looking at in this photograph or no?
Yes, we're looking at the mucosa with ulcerations, which are little craters that form in it due to hypothermia.
Is that exemplar of what Wisniewski spots looks like as it relates to hypothermia from a book that is, or literature that is peer reviewed?
Oh, yes.
Is it widely accepted in the medical field?
Yes, it is.
And is it referenced by forensic pathologists and used in teaching?
Yes.
Your Honor, I would move for the admission of that photograph.
Okay.
Exhibit 226.
Permission to display, Your Honor?
Yes.
Is this a fair representation of what you were just looking at?
Yes.
Describe what we're looking at.
Okay, so this, I took this photograph from our forensic medical literature, and this was from a person who died due to exposure to a cold environment. And this is the stomach has been opened, and we're looking at the inside of the stomach. And the normal appearance is kind of pinky white. That's how it should look like. And what's abnormal here is all these black dots, which are the Wisniewski's ulcers, which are diagnostic of death due to exposure to the cold. So these areas are little tiny craters, and they fill up with blood. And we see that in over 90% of the cases of people who die from exposure to the cold.
Doctor, did you also look at Mr. O'Keefe's stomach lining?
Yes, I did.
If we could have, with the court's permission, Exhibit 164 put up as well.
Okay.
Do you see the photograph on the right?
Yes.
What is that of?
This is the Mr. O'Keefe's stomach, which has been opened up, and we're looking at the inside. We see that the mucosa is a little bit red, and there's a little bit of increased blood flow here, and this is the normal pattern of the inside of the stomach. It's kind of ridged. That's called rugae. That's the normal folds inside the stomach. But there's no ulcerations here. So the diagnosis of death due to hypothermia is not appropriate in his case.
Did you see, or do you see, any classic Wisniewski spots in Mr. O'Keefe's stomach lining or gastric mucosa?
No, no.
Do you observe any ulcers specific to Mr. O'Keefe's stomach lining?
No, there are no ulcers. It's a normal appearance of what we would call a gross specimen. When you open the stomach at autopsy, you can see some redness of the normal lining of the stomach.
Did you, let me ask this first. Do you have an opinion as to a reasonable degree of scientific certainty based on the totality of your review and examination of the autopsy and its associated file, an opinion as to whether or not Mr. O'Keefe died of hypothermia or complications related to hypothermia?
I do have an opinion.
And what is that opinion?
He did not die of hypothermia.
And is that opinion to a reasonable degree of medical certainty?
Yes.
Taking a look at the darker red areas in the stomach lining of Mr. O'Keefe on the photograph to the right.
Yes.
That's Exhibit 164. Can you describe what those are? What are those darker areas?
Well, here we see a little bit of bleeding. The darker areas are the areas of the lining that are at the bottom of the normal rugae, because the inside surface of the stomach sort of looks like it's covered with little mountains. And so we can get the redness in between what the rugae in the stomach, and there's a little bit of increased redness here, but no ulceration.
Do you have an opinion, or were you able to form an opinion as to what the increased redness might be or is associated with?
Yes.
Did you note anything of significance in the rest of your examination of the file, the autopsy file, the medical examiner's file, that was related to what you see in the photograph 164?
Yes.
All right, I'm going to see its eyebrow for just a minute here.
We can take that down.
This is when I say F you, Bev. This objection by Hank, because he knows where AJ's going with this, and he wants to stop it. Oh,
No, there's three. There's three. Oh boy. Okay, so oh boy.
Oh boy, your papers. Are you tossing your papers?
No, I was flipping a pad. So, well, I was just gonna say I think she's basically saying he split his head on steps. Like the steps is what caused that.
You're right. Oh, you're gone.
I'm right here.
May I continue?
Yes.
Thank you. With regard to the, it's my word, not yours, doctor, so forgive me, the defects, the redder marks that you're mentioning on the rugae or in and around the rugae on the gastric mucosa, did you note that there was a machine that was used for life-saving measures as it related to Mr. O'Keefe?
Oh, yes, it caused some damage to the body.
Okay, let's talk about that for just a quick second. What is that machine called?
It's a mechanical device to administer chest compressions, and the company that makes it is called Lucas, or one of the companies, so it's called a Lucas machine, and it can be attached to the body. Your arms go up over a ridge, and there's a plunger, and it goes around your back, and so it just plunges, and it does mechanical resuscitation and chest compression, compressing the chest right over the lower sternum, about 2 inches or so, and it's very helpful in a situation where the manual compressions, where the attendants and the ERT people, they get tired continually compressing for a long period of time. So the mechanical device was invented to prevent the EMT fatigue when administering chest compressions.
When you mention the sternum area of the body, are there, go without saying, are there organs beneath the area that's being compressed by the mechanical Lucas machine?
Oh, absolutely.
What do those organs include?
Well, ideally they include the heart, because that's what's supposed to be pumping the blood out, but it's also in a circular area that's right below the sternum, which includes the heart. But what is also under there is the esophagus and the interior of the stomach. So this area is right under where the machine is compressing as well, as long as, in addition to part of the head of the pancreas, which is also right there under the lower sternum. And what can happen with the Lucas machine pushing in for 100 times a minute for a depth of about 2 or 2.5 inches, that these organs right underneath of it get compressed between the Lucas pump and the bony vertebral bodies that's along your back. So you have the Lucas machine compressing these organs, and they're compressing them against the vertebral bodies of your bony vertebral column in the back. So you can get other injuries, organ injuries, that is a complication of the automated mechanical resuscitation. You can get cardiac ruptures, you can get ruptures of the liver, because all those organs are clustered right there, and that machine is pushing those organs in between the pump and the back of the bony spinal column.
Doctor, in your review of the medical records, was there any indication that an automated chest compression machine, a Lucas machine, was used on Mr. O'Keefe?
Yes.
May we can take this down?
Yes.
Hey Bella, so my 2-year-old timeline was right. That I thought he walked around to the back to the base to the backyard, and he entered where the dog was, and the dog, was startled. Here he walks into the garage
That's what I'd like to show you first.
side door,
That document, and then after your
and that's how he fell back.
familiarizing yourself. First one and then the second one.
Yes.
Taking the first document that addresses the Lucas machine,
Yes.
how do you recognize that photo or those series of photos and graphs?
These are illustrations I put in my report, and one shows a generic patient with the Lucas machine in place around him to do the chest compressions. Then I have a photograph of the actual apparatus of the Lucas machine itself. Then I show what's recognized as medical complications and injury from that machine. It shows, I have an example of a CAT scan of a section through the body horizontally, right where the plunger goes into the chest. And it shows in another patient hemorrhage around the pancreas and around the top of the stomach. Then I have a diagram also taken from our medical literature that shows the direction of force that compresses those organs between the resuscitation paddle and the vertebral body and the backbone.
Doctor, are those photographs and graphs taken from peer-reviewed literature in the medical field that's normally relied on by other medical professionals?
Yes.
Your Honor, I'd move for the admission of that first document.
Right, subject to lead action?
I don't think so. I think that that one is not objected to.
Okay. All right, so would you hand that to?
Sure, thank you.
Exhibit 227.
Permission to display, Your Honor?
Yes.
Doctor, I know that's a little bit small and far away. We'll enlarge it as you need.
Okay.
It's not an eye test. Can you tell me what we're looking at? Yeah, let's take the top half of the document. What is that to the left, and then what's the machine in the middle?
Okay, so what you see on the left is a anonymous patient showing how the Lucas machine is placed onto the patient, where the arms are pulled up and clasped against these rigid mechanical bridges. And then here is the engine which puts the pump, and that's the pump which just goes up and down to do the chest compressions. And so that's how it's affixed to a patient.
To be clear, doctor, that is not Mr. O'Keefe. That is
No, this is
could be a model.
an unknown person.
Okay. And then what are we looking at in terms of the actual machine to the
Yeah,
right?
this shows the actual machine before it's put on a patient. You can see how it encircles the patient, and then there is this circular pump, which is the compressor pump.
If we can look at what is that a picture of, the highlighted portion?
That's the circular part that actually is projected down onto the body.
That makes contact with the chest?
Correct, and it has a spring in there that the engine above it gives a certain number of compressions per minute.
And you said on average the compressions per minute would be about what?
They should be around 100.
Okay. If we could go to the bottom half of the page, or the graphics on the bottom. What are we looking at in this photograph?
Okay, we're looking at, on the left side, we're looking at a CAT scan, which scans a person who's had some injury from the Lucas compression machine, and it's sorts a cross section. So the arrow here is pointing to the head of the pancreas and the area of the esophagus, and then the machine would compress down onto that. And the important part is that I don't know if that's working on there. The little thing that looks like at the very bottom, that's circular and then has a little, looks like a little steer head, that's the vertebral column, and that's bone. And so the pump is pushing in that area where the arrow is pushing those organs against the bony vertebral column. Excuse me. And that's on an actual patient that had that. Then on the right, it shows the schematic of the blue arrows indicating the force coming down. Then we see the organs, and the red arrows show how the pancreas can get hemorrhage, and also some of the esophagus that goes into the top part of the stomach. And we see that that's, I can't really see where that, I think it stopped.
Okay. May I approach you?
Yes.
Oh, no, you've got it. Okay.
Maybe a battery issue.
Okay. And then we see at the bottom with those three little things projecting from it, that is the vertebral body, which is made up of bone. So you can see how the chest compressions, not only hoping to save the life by keeping the heart blood functioning, can also cause some injuries and damage, not life-threatening usually, to the other organs there.
We can take that down. Doctor, taking a look at the second document that's in front of you, do you recognize what's depicted in that document?
Yes.
What is that?
This is a picture of Mr. O'Keefe, his chest, while he's at the hospital, which shows a lot of the resuscitation equipment.
Is that a true and accurate depiction of of Mr. O'Keefe at the hospital based on your review of the medical file?
Yes.
I'll move for the admission of that.
Okay.
Oh.
Exhibit 228.
Permission to display briefly.
Okay.
Taking a look at the photographs to the left and to the right, do you see any indication on Mr. O'Keefe's body that is suggestive that the Lucas machine, where the Lucas machine was situated?
Yes, as I pointed out here with the blue arrows, that big circular mark there is the mark on the skin where the compression pump compressed the chest of Mr. O'Keefe, and it caused some rib fractures, and it also caused those reddening of the stomach and some hemorrhage in the pancreas.
We can take that down. Doctor, based on your review of the medical records, did you calculate the approximate number of compressions that Mr. O'Keefe would have been subject to based on that Lucas machine?
Yes.
What is that calculation?
His body was found around 6 in the morning, and he got to the hospital around 6:37, I think. So if they put the Lucas machine on him when they got him into the ambulance, and it's compressing at 100 times a minute, and that is from the time of the body being discovered to the time at the hospital, that's around 37 minutes. So if you multiply 37 minutes times 100 compressions a minute, that's around over 30,000 compressions that would have been done to Mr. O'Keefe's body in the course of his resuscitation efforts.
Doctor, do you have an opinion as to what caused the hemorrhaging that we saw on Mr. O'Keefe's stomach lining?
Yes.
What is that opinion?
It was from the blunt compression of the Lucas machine.
Is that opinion to a reasonable degree of scientific certainty?
Yes.
You indicated earlier that there is a difference between someone dying of hypothermia or complications associated with hypothermia and a body that's already passed away just cooling, correct?
Correct.
Do you have an opinion as to a reasonable degree of medical certainty as to whether Mr. O'Keefe suffered from hypothermia?
I do have an opinion.
What is that opinion?
He did not experience hypothermia.
Did you observe any signs of frostbite?
No.
Did that have any weight concerning your opinion, overall opinion, as to whether or not Mr. O'Keefe died with complications associated with hypothermia?
Well, if someone dies due to exposure to low temperatures, you expect to see not only the Wisniewski's ulcers, but you expect to see some frostbite changes in the extremities.
Based on your overall review of the medical records associated with Mr. O'Keefe, were you able to reach an opinion and conclusion as to the cause of death of Mr. O'Keefe?
Yes.
What is that opinion?
He died of brain injuries and skull fractures due to blunt force trauma of the head.
Do you hold that opinion for Mr. O'Keefe's cause of death to a reasonable degree of medical certainty?
Yes.
I want to shift gears for a minute, Dr. La Posada, and talk about patterned injuries elsewhere on Mr. O'Keefe's body. You've obviously talked about your training and experience as it relates to recognition of patterned wounds, correct?
Correct.
That's something that you were trained in when you were training, correct?
Yes, it's very basic to the discipline of forensic pathology.
And have you also trained others during the course of your 40-year career on the issue of wound pattern recognition?
Yes.
You've taught courses and given lectures, is that right?
Yes, I have.
I'd like to show you Exhibit 167 with the court's permission.
Okay.
Do you recognize what's depicted in this photograph?
Yes.
How do you recognize it?
Is a photograph of the right arm of Mr. O'Keefe.
Did you review and consider this photograph and others in coming or forming your opinions, coming to your conclusions and opinions in this case?
Yes.
In order to come to your ultimate opinion and conclusion, or opinions and conclusions in this case, is it important to take all of the injuries that a decedent may have suffered into account rather than one or two piecemeal?
Now you have to look at the whole picture to understand what happened to the body.
Why is that? What's the importance of that? It may be obvious, but explain that for the jurors, please.
Well, when you're looking at changes and injuries to the body and trying to understand what happened to the body, there are different patterns of injuries on different parts of the body. And by trying to separate those and understand what patterns were caused by certain things, then you're able to put together a sequence of events that happened to the body prior to death.
What role do photographs play in a forensic medical examiner reviewing the medical evidence and coming to opinions and conclusions? How important are photographs?
Oh, those are huge. It's standard practice to always document at the postmortem examination important findings with photography.
Were the photos in Mr. O'Keefe's case useful in coming to opinions and conclusions concerning his injuries altogether?
Yes.
What about the injuries to his right arm?
Yes, those photographs are very important to understand those injuries.
Do you believe that there is a patterned injury on Mr. O'Keefe's right arm?
Yes, there is a pattern injury there.
Have you ever seen, in your experience, either being taught or teaching, patterned injuries as they relate to animal wounds, generally?
Oh, absolutely. Very common.
Do animal wounds include both claws and teeth, dentin?
Yes.
So bite marks and claw marks might be two different types of patterned wounds that you may see in your evaluation, just
Correct.
in general?
Correct, because when an animal approaches the body, there may be damage from the claws and also from the mouth.
Do you expect to see punctate wounds as well as linear abrasions?
Yes.
Do you expect to see certain bite patterns as well?
Yes.
What types of injuries, let's talk about animals in general, what types of injuries do animals produce on the skin of human beings?
Well, animals can produce, if you're talking about, mammals, can produce injuries from their claws, where you get parallel scrapes of the skin from the claws applied to the skin, or you can see a pattern from the jaw configuration of the animal. And most animals that attack or get in contact with the body have canines. So there's two canines on either side that make paired marks, and that would be called a pattern injury. So it makes parallel sort of gouges, and as the canines move in a horizontal pattern or a vertical pattern, the space between them can change. The other thing you see in an animal bite is you see not only the canines that come out, but depending on how the jaw is applied to the body, you can have little dot-like imprints in sort of a U-shaped pattern, which are from the incisors, the little incisors of the animal. So you look for punctures, you look for paired gouges, which would be the canines, and then you look for arced patterns of little dots, which can be the application of the incisors of an animal bite.
What is an incised wound?
An incised wound is a wound due to cutting from a sharp object.
Would you expect to see incised wounds from an animal bite or claw marks?
No, they don't cause, they're not like knife wounds. They cause more of a scraping injury.
Do you see the injuries that you're looking at in Exhibit 167, are these more consistent with incised wounds or the scraping abrasions that you just talked about?
Sustained.
Were you able to determine from your review of the medical records whether the injuries that you see on Mr. O'Keefe's right arm were pre-mortem or post-mortem?
They were, yes, I can determine that. They were inflicted prior to death.
Do you have an opinion as to whether or not the wounds that you see, the patterned injury that you see on Mr. O'Keefe's right arm, is consistent with an animal bite or claw marks?
Yes, it is, very much.
Thank you. We can take that down. May I have just a moment, Your Honor? Actually, Your Honor, may we approach very briefly?
Okay.
On the approach. What do you guys think? She is MVP, isn't she, Lana? Lana will be with us shortly. She's very relatable, and when you're explaining something to a jury, you have to kind of come at it from in a place of like explaining like you're 5, right? Explain to me like I'm 5. And she does that very well. And I think you're spot on, Lana. She literally took the MVP spot. What do you think they're talking about? Where's Peggy? Just full on moving the bedroom sets up in there. I think the reason that I think the O'Keefes really need to take it in and think about suing the Commonwealth for leading down this path and then go after the Alberts. But I don't think they will. We're back at it.
May I inquire?
Yes.
You indicated that, in your opinion, the wounds to Mr. O'Keefe's arms were pre-mortem, not post-mortem. His right arm, I should say, were pre-mortem, not post-mortem, correct?
Correct.
What's the basis for that opinion?
Well, a forensic pathologist has to be able to differentiate changes that happen to the body while the person is alive versus things that happen after the person is dead. For instance, there is something called post-mortem predation, where if the body is out in the woods and dead, then wolves and such can come and make, quote, injuries to the body. But we're able to tell from our training and experience that those were made after death. The usual way we tell is that when it's made during life, the blood vessels that are damaged, the heart's pumping blood through, so you can see a reddish color and maybe some blood around it. Whereas if the body is damaged after death, the changes to that body and those, quote, injuries look more yellowish and kind of brown because the blood is not flowing. So that's how you can tell if something done to the body is while the body was alive or whether it was done after death.
Do you have an opinion to a reasonable degree of medical certainty that the wounds on Mr. O'Keefe's right arm were pre-mortem?
Yes, they were done while he was alive and bleeding.
You talked about death investigations. As a matter of fact, you mentioned something about what a forensic pathologist's role is in a death investigation to potentially send investigators back out to answer certain questions, correct?
Yes.
Did you see any evidence in the medical records or the medical examiner's complete records that any effort was made to send investigators to the location to see if there were any animals at the location at or around the time of John O'Keefe's death?
Objection.
Sustained.
Do you believe it's important? Well, let me ask it a different way. Would following up with investigators be an important part of any forensic pathology investigation?
No, absolutely. You're working as a team to figure out what happened to the body.
Thank you. We talked about the theme and theory of differential diagnosis, correct?
Yes.
How does engaging in the process of differential diagnoses avoid bias in an investigation?
By after you have your findings and you sit back and think, well, how many ways could I get this finding? And so bias sometimes means, oh, I think it's this, and then you just stop. So that's a sort of a bias where you make a decision too quickly and you don't then stop to consider what other things could cause this same finding. So you have to consider not only what immediately comes to mind, but then you think, how else could we get this pattern of injuries?
Did you engage in a differential diagnosis as it relates to this case?
Yes.
Did you consider whether the injuries could have been caused by a motor vehicle accident?
I did consider that.
Did you consider whether Mr. O'Keefe's right arm injuries specifically could have been caused by being hit by a motor vehicle?
Yes, I did think about that.
Were you able to rule that out?
Absolutely. Not.
So the objection sustained, jurors strike that answer.
Tell me about, well, let me ask it this way. Did you come to an opinion or conclusion as to whether or not Mr. O'Keefe's injuries as a whole were produced by a motor vehicle pedestrian incident?
Sustained.
You indicated that you've done thousands of autopsies yourself, correct?
Yes.
You've supervised many times more than that.
Correct.
How many of those autopsies that you've performed or supervised have involved motor vehicle incidents?
Now, hundreds.
How many of those hundreds have involved motor vehicle pedestrian incidents?
Almost as many.
Have you performed autopsies specifically on individuals known to be hit by vehicles?
Yes.
Have you performed autopsies on individuals believed to be hit by vehicles?
Yes.
Have you engaged in differential diagnosis and inferential thinking in terms of developing an opinion or conclusion to a medical certainty about whether or not the injuries that you see on a decedent are consistent or inconsistent with a motor vehicle pedestrian incident?
Yes, that's part of what we figure out as a forensic pathologist.
Did you do that in this case?
Yes, I.
Sustained.
What are some of the injuries that you would expect generally to exist if a pedestrian is hit by a motor vehicle at speed? Not 1-2 miles an hour, let's say 20 plus miles an hour.
Yes, one of the things you see is a pedestrian is, standing upright and is impacted by this blunt object of a automobile or a van or a SUV. And what you see first most is the tissue is crushed where the projections of the vehicle impact the tissue. And when you crush the tissue, that gives you a bruise. So that's the first part of the pattern of impact. It crushes the tissue, it gives you a bruise because it breaks the blood vessels underneath the skin. And then depending on how much more force is applied, the skin can break.
So I'm going to strike that. Next question, Mr. Jackson.
In addition to bruising, what else might you expect to find in an individual who's been struck by a vehicle at speed?
So let's come over to second.
We got another sidebar. So Lana has been saying some things, even though she's not here, we could put her info up on the screen, have her talk through the screen. I'm trying to find that one comment. This Dr. Laprasada, this witness, is nailing this. And I guarantee you, if you look at what people in the courtroom are going to say about it today, they're going to tell you the jury is taking notes. They're very attentive. Nobody's rolling their eyes. Nobody's yawning. Lana says, oh, wow, he's going for bias. Genius, AJ. You can get it through. You can get it in through her. I'm loving this line of questioning right here. Chef's kiss, bitch. OMG, yes. It was cute yesterday when AJ said, "Just stop it." That's what it reminded me of right now. Hello. This witness is the MVP. I think even like her first answer, her first significant answer that she gave, just ended the Commonwealth's theory, just blew it out of the water. And I seriously, after the first trial that we went to out there in Canton, Mass, not to be confused with any other Canton, I don't know, guys, like I lost my faith in a lot of juries. Well, that and also going to the Delphi trial. That was freaking horrible. But yeah, I think that we are making some headway with the jurors with this witness. Do you guys want to see what I sleep in? I don't really sleep in it, but wait, watch. Let me turn my camera on while we have a sidebar. I'll give you guys a little treat. Where is this cam? Here it is. Look. No, I always forget it. It's AJ on my tits. Hi AJ. Say hello. He's just so slick. Obviously it says, should I stand up? It's a tight squeeze. Obviously it says this. Have a seat. But yeah, so AJ on tits. Birds are singing. Got my tea. And we're back at it.
May I inquire?
Yes.
I forgot where I left off, so I'm just going to pick up
Okay.
as best my memory can serve me. It has been suggested that Mr. O'Keefe's right arm, Doctor, was injured by contact with the right rear taillight of Miss Reed's 2021 Lexus LX570.
Objection.
No, I'm allowing that in.
Thank you. As Mr. O'Keefe, it was struck as Mr. O'Keefe was standing and the Lexus backed into him. That was a postulate put forward. I want to find out from you, do you agree with that?
Well, that's something to think about.
So,
Oh, I'm sorry.
yes, I'm going to strike that question and answer.
Let me ask it a different way. Let me ask you a different question.
Mm-hmm.
Do Mr. O'Keefe's pattern injuries on his right arm, do they correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm?
No, not at all.
Why do you say that?
First of all, those injuries are patterned injuries from an animal bite. We have the canines, we have the incisors.
All right, so I'm going to strike that, and let's see you at sidebar.
Okay, another sidebar, apparently. I was saying this yesterday. So like psychologically speaking, okay, how, like, take yourselves out of this and what you know about the Karen Reed trial and how much you guys have followed it, okay? If you're a jury member and you're there to do a civic duty, and you psychologically are going to be more aligned with the judge than with any, like with the defense or with the Commonwealth.
What is
The
going
way that,
on?
hold on a second. So the way that everybody, the way that everyone in a jury looks at Bev, it's almost like Stockholm syndrome psychologically, because she's the one that gives, like, okay, well, there's food here for you. You know, we're taking breaks. So those things make the jurors more aligned with her than anybody else. She gives them treats, basically, right? So her attitude and her discretion goes a long way and is incredibly material, more than we think, just on a surface level to a case. So her interrupting AJ and admonishing him and sighing is really in bad taste, in my opinion. I think there's a way you can do it and show decorum, and she's supposed to do that. But yeah, Elo, you can unmute.
Yeah, what's up? So Alan Jackson is going to these line. This was what this whole before the day ever started, and Alan Jackson was saying, "What can I ask her? What can I say? All of that. Like, can you give me something? Blah blah." He's asking the questions. She's the one that's providing this answer. I mean, he doesn't have an opportunity to talk to her or anything to say that she can't say or do. Like, you know what I mean? Like, I'm not allowed to talk to my. You know, if he was to talk to her, Hank would say, "Did you talk to Alan Jackson? Oh, you did. Oh, well, tell us what you know what I mean? Like, so it's like a catch-22 for Alan Jackson. Like, I'm asking these questions. These are her answers. I have not talked to her to tell her she can't say this or she can't say that or she can't say this, because I don't want to have her asked questions by Brennan on cross. Oh, did you talk to Alan Jackson? And so, like, Bev wants to say, oh, I want to see everybody at sidebar to talk about what my expert witness's answers to questions that are well within her expertise, to talk about why she feels a certain way, and it's not her, just it's her expert opinion. This isn't. So I just think that I think that's what they're talking about. I think that's what they're talking about, and I think Alan Jackson's holding his ground with, well, on, because Brennan's over here saying, see, he's eliciting this type of testimony, blah blah, and this is what you said it wasn't going to happen, and then Alan Jackson saying, I haven't had a chance to talk to this witness or say, like, you can't say this, you can't say that, nor would I want to, based on the way that Hank Brennan goes about it on cross, trying to discredit a witness if, God forbid, they were to get logistics, or hey, there's a new ruling or whatever. So that's my opinion on what's going on right there at that sidebar, is that they're talking about that this was already ruled on. Well, yeah, she's not saying, she's saying animal bite, and she's saying the canines, is she's referring to the tape.
Yeah, it's a name of the case.
Yeah,
that's what they're called. They're even called that in humans. Everybody, we have canines. Yeah.
All right, let's see what she does.
May I, Your Honor?
Yes.
In your report, Doctor, you indicated that Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. Do you recall putting that in your report?
Yes, I wrote that.
Do you stand by that?
Yes, that's my conclusion.
And you also wrote his arm had no tissue bruising from impact injury. Do you remember writing that?
Yes,
Do you stand by that?
I do.
You also wrote, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. Do you remember writing that?
I did.
And do you stand by that?
I do.
You also wrote that you noted Mr. O'Keefe had no bruising on his arms or torso. Is that right?
Correct.
And you also wrote, in particular, Mr. O'Keefe did not have bruises on his legs, correct?
Yes, correct.
And you indicated that that was shown by dissection of the leg tissue and muscle at autopsy. Is that right?
Yes, there was a special leg dissection done to look for bumper impacts.
You reviewed the entirety of the medical records associated with the autopsy,
Yes.
including photographs,
Taken to the hospital, yes.
okay, and autopsy photographs,
Yes.
and other data and documentation, correct?
Yes.
Are x-rays an important part of an autopsy generally?
Oh, yes. Usually there are x-rays taken of the body prior to the examination.
What do x-rays show? Why are those important?
They're important because they show foreign material in the body, like a bullet. They also image the skeleton, so we can look for fractures of the bones.
Let me have just one of y'all. May I approach?
Okay. Yes.
Looks like we need another timeout. Okay.
We do need another timeout. And I think that this time around, AJ and the whole defense team, they're not taking any bullshit. They're not.
I love it.
I love it too. It's time.
Dude, let me just tell you what an amazing DoorDasher I am. I had this all timed up to go back to camp, pick bags up, have the food ready on the doorstep waiting so that we can just devour, the lunch hour for the best kids in the West and the East. And now we have to listen to Hanky Poo getting all upset because things aren't going his way. What did Alan Jackson pull out there? Like blueprints to the house?
They resemble, like they're in the format of how a blueprint would be, but they kind of look like they were pictures. I don't know. But yeah, it's interesting. I just love that man. He's on my tits as we speak, but they're just not taking the bullshit. And they're
I saw you were showing everybody your pajamas.
I just need to sleep with AJ every night. No, I'm kidding. I lied about it though. I have to be honest. Weren't really my PJs.
Rise for the jury.
So they're removing the jury. So we are probably going to be getting some outside the presence of the jury arguments going here. So we're going to find out more about what they're talking about at sidebar. In my opinion, I think that's what's going to happen. And the amount of time and attention given to the scope of this amazing witness tells us how much the Commonwealth is scared of her testimony, doesn't want it to happen. The jury has left. We can commence.
Dr. Lapasada, you can step out, okay? All right, I did receive another motion this morning for a curative instruction. I'm not going to even consider this today. We can consider this at the charge conference. So that's where we're at with that. All right, work it out. If you can't work it out, let me know. I'll come out before the jury.
All rise to the court, please.
Work what out? You're not doing the curative, you're not addressing the curative instructions right now, which is what they want. The defense wants her to tell the jury, okay? Special instructions to the jury regarding the misconduct they saw yesterday. Now, what does she want to work out, Lana?
Yeah, wait, hold on though. What's happening here is that this is the morning break. Don't worry, that's just my catch up. Okay.
Catch up with a K, not catch up with a C. Okay.
Yeah, that's just, momming 24/7 over here. So, she was just giving another motion, but she was letting them have a break. So when they were over there at sidebar, it was, okay, is this a good time to have a break? Maybe you guys can discuss some things. And so they're on their little 20-minute morning break, and she was just handed another motion. So what I think Alessi is doing over there, or, I don't think it's Little, because I think Little's, Jackson's right hand, but I think Alessi is like literally writing motions mid-trial while sitting at the table. He's authoring up stuff.
Yeah, but I think that motion started yesterday because he's the one that stood up and said, I want a curative instruction to the jury. And yeah, he turned it in. And that is, she's going to consider it, but just not right now. She said, we'll consider this basically at the end. I'll consider this at the end of trial. Whether she does what they're asking or doesn't, at this point, this is such a donkey shit show that doesn't even matter, because this is all, if it goes sideways, it's all going above Bev's head anyways. Doesn't even fucking matter. This thing is done. The Commonwealth didn't meet their burden. They were unethical.
Hank fabricated evidence to the jury. That's what Hank did.
That's the least of what that's like the least of what he did. We saw it on TV.
A public defender being overworked could have missed that. Okay. And that, I'm telling you, would find somebody guilty.
100% it can, if it doesn't get caught. 100%. And by that, Lana, means it's material, which is a word from earlier today on Sesame Street. But yeah, so this is the morning break. You're gonna eat, and then when
what? No, Jax, I'm not eating.
Okay, well, for lunch, do you think
you can just go ahead and mute yourself right now? I got it.
You should do your timeline.
No, I can't, because I can't use Hector the right way without it cutting out. It'll all be fixed here soon. All right, so what I did want to say, though, is let's talk about Lapasada just being stacked. I mean, MVP status. She just comes in there, total trustworthiness. She basically, the jury is not looking at that woman like she's trying to pull one over on us. That woman isn't, she was around before people would try to get creative with defenses and a bunch of money, and the jury's not seeing that in her. The jury is seeing a very trustworthy, very decorated, grandma type, mom type figure, and the jury is right there. Like that. I mean, if you didn't get it with Russell, okay, now you're getting it from her, and I think the jury's over here like, God, Hank, if you go at this woman, you better have the goods versus just trying to fling mud. And so I hope that Alan Jackson is defensive of that and left and right, but you have to be careful when you're objecting though too. It could come across to the jury that you're scared of what her answer would be or something like that, so you're objecting. And that's why you see a lot of, when there's not a lot of objections, like there's no reason to be objecting, but more importantly, it's all about those people that are sitting in that well, deciding your fate. And if you're objecting and acting like you think you got something to hide, and I think that's just the thing that stinks about not being able to say why you're objecting, like badgering the witness or asked and answered. Like, that's just the downfall with that, with not being able to state your objection. And the jury knowing why you're objecting. So that just really stinks for purposes of wanting to protect your witness. Woo, it's a nice day. So what do we got here? I think they basically have hit on every point that Alan Jackson wanted to make. I'm curious to see Hank's angle to try to like. I think he has to go the route of asking her if things are possible, or versus trying to discredit her, trying to say that there's and like let her. But I think Hank's got to be careful too, because then he's got to let her answer, and then she's going to say why she doesn't think it's possible that it'd be like a car strike, SUV strike. But then, if Hank's able to ask those type of questions, but Alan Jackson was limited and he couldn't ask those questions because it was like outside the scope, then how can Hank come on cross-examination and say it? So I think Alan Jackson has to be really on the ball with that. Don't let Hank ask any questions that were outside the scope for him, and you're gonna be set. You're gonna be set. MVP though, this woman, she should be the juror's reason to say not guilty. What else? Through the transparency, Speedbird Atlanta. I hope we can do Idaho 4 early tonight. We all wanted to know about the emergency order from the defense and the order to stay, so we're not getting confused. Yeah, I think people are getting confused about that. In a nutshell, Ann Taylor put in an emergency order. She wants testing done, whether it was testing done that hadn't been done on something, or whether it was retesting based on the inadequacies that the defense would have laid out in a motion. So she's wanting something tested, whether it's a retested by a third party, or whether it's testing that has not been even performed yet, and they want to do. So think about the blood in the case. No work on that blood. And then we'll talk about a delay possibly coming on. She wants an independent review, and I'll discuss what that is. And again, what I kind of see here is this whole rush here at the end, just like this case here with Karen Reed. Are we going to see that? But see, with the Kohlberger case, the Idaho 4 case, they set aside 3 months. Voir dire for the jury starts the end of July, and then first day of trial starts August 11th, and it goes until November 7th. So I think, when did we start with this case? Jury voir dire was April 1st. And then I think that they did 3 weeks to seat this jury. And then I think their first questions began on August 22nd. So, as far as this case goes, Bev Canone said that this case is going to be in the hands of the jury by the end of the week. So I'm guessing jury instructions closings on Friday, and then they get the case on Friday. That's what she's anticipating. So that's giving Alan Jackson like today, tomorrow, and Thursday. I want to do a recap of all the witnesses to date and which witnesses. I mean, if you're taking notes and you're going back to the deliberating room, depending on how the jury is going to do it, how they choose to do it, the foreman here gets picked ahead of time by Bev, and then when they get back there, I'm curious if they're going to take an initial raise your hand if or if they're going to start talking first and then not pull until possibly a little bit later on. I know that they did that in the Delphi case. They did not take an initial poll with the jury when they went back there. They didn't do that until after a couple hours of talking. So, let's see. Sometimes things that you maybe say to yourself, maybe it's a blessing in disguise that Higgins, nor Brian Albert, nor any of the Alberts, nor any of those people were called. Maybe it's a blessing in disguise, because you never know if you're going to have some people go back to that deliberating room and say, we really think that all these people would be involved in something like that, or because if they get things confused and thinking that all those people, like Chris Albert, Julie Albert, that they were all there that night, we think that all these people would be involved in a cover-up. And I think that that's not even what you'd want kind of the jury to be thinking about. I think that you would just want the jury to be thinking about, did John O'Keefe get hit by a car or not? Like, we just want them focused on that. Did John O'Keefe get hit by a car? And I think the reason that this witness seals the deal for me, remember what I always said, is you need to explain what would have happened as to have John's phone is to explain that data, that boom, 12:32, that phone supposedly never takes any more steps until 15 in the morning, 6:12, 6:04. Explain that. And this woman, for me, explained it. She explained it that as soon as his head suffered, he was out, boom. Whereas these idiots, when I say these idiots, Hanky Poo and them, said that John basically got hit and then got up after getting hit by the car, got up and then walked around, and was wobbling and like that type of shit. Well, after hearing her, I'm able to say, okay, I don't think that John would have gotten up from after hitting his head based off of this woman's testimony. Okay. So he hit his head after taking those steps. And I think that's just so important. Like, he something happened to him that forced him backwards to then hit his head, and it rendered him unconscious. And I think that getting out of the vehicle, walking over, opening up, instead of, if Jen McCabe was like, hey, come to the side door instead of the front door, and when John walked up, he thought, oh, the side of the garage side door. And so he goes and opens up that door. That's where the dog was. The dog was startled, and the dog just came flying, right out the door and went at him. And then that's what forced him back. And that's where you have that little 1 or 2 steps, they said, and that's your ridge, and boom. So Um, and I also think as a juror, based off of what we're seeing here versus what we all know happened from trial one and all this other talks that we have, in social media world, I think with these jurors, if I was in their position, I would think that this was um, a horrible accident, and then somebody didn't do the right things afterwards, and that was not Karen Reed. Like, whatever transpired was a horrible accident, right? And then those people didn't get him help. But that's not what I'm here to determine. Karen Reed's culpability in it, and it's not guilty across the board. But what would be going on in my back of my head is that this was a horrible accident that somebody didn't render aid, didn't try to get John help. And that's the non-conspiracy way of thinking about it, or the non having all this outside influence, or but to keep it simple, I mean, but you would no way, shape, or form would it be that Karen caused that, because in order for Karen to cause it, she would have had to hit him. That's the Commonwealth theory. And I think that you can say not guilty beyond a reasonable doubt, that's no. And you just leave it as that. So, yeah. Yes, Amy Lee, and I agree. The fact that you said no hypothermia. Yeah, and I believe that was also said before, too, and this just reinforced it. No frostbitten. I think it tells America, though, to not, I was giving you guys my perspective as a juror. Now, what this tells America, though, and even outside of America, who's ever watching it, it's being watched all over the world. So, everybody that's watching it that's not a juror, okay, if John's your friend, you guys are so well connected. An accident's an accident, okay? If the dog did that, oh my God, John, the dog, oh my God, let's rush him to the hospital. Blah, blah. It's. No one's getting in trouble for that. Nobody's getting in trouble for that. The dog's going to be put down, but nobody's getting in trouble for that type of a situation. No, none of this should have happened. And I think that's when you have to ask yourself, okay, you got that type of pull, you're not going to get any type of trouble. When you can control something like what all the stuff that has happened to this point, you can control that, hey, this was an accident, and they're going to believe everybody, and it is what it is, and boom, it's over. So that's where I think the whole
Lana, you know what?
What?
The dog doesn't even necessarily get put down because he's in his house, if that's the theory, and John walks in and startles him. He's doing his job. So no one gets in trouble. But the bottom line here is,
hold on,
when you talk about,
hold on, please. It's on my end when I'm hearing it. Is all the stuff breaking up when I was
you
talking?
gotta mute. I think you gotta mute when I talk. What's happening is civilians and law enforcement officers are held at a different level, and first responders have a duty of care. So you're talking about a house with law enforcement officers who didn't render aid. But again, it isn't up to the defense to say what happened in that house. It's that the Commonwealth didn't meet their burden. You want me to mute and see if it's better?
I'm trying to see if that's better.
No, I think your first one was better. The mic, the mic, the mic. It's all about the mic. I don't even have my mic plugged in. This is the laptop mic. Yeah, so but what we expect as I don't know, jury instructions and how much they listen to it, where like the judge will usually tell them she did that in the beginning. Bev did that, reasonable doubt. Karen Reed's presumed innocent. The Commonwealth has to meet their burden. That stuff needs to be taken seriously. The amount of reasonable doubt here, and Dr. LaPrasada just sealed it really nicely for everybody. And it was the hypothermia comment was the first real, out of foundation question that was asked, where she put the boom down, which is he didn't die from hypothermia. And this is a person this is an expert witness with such a stacked CV, with such a stacked resume, and has been an expert witness in so many trials. There's a lot of credibility behind her name. She's worked in this field, so her opinions and her opining on something has merit. She's allowed to do that. She's been deemed credible over and over and over again. And when she says this man did not die from hypothermia, that's not to be taken lightly. So that right there is reasonable doubt. The ARCA guys getting up there, or the ARCA guy at this point, getting up there and saying it doesn't match the pattern of the taillight, the brakes on the taillight do not match any of the scientific tests we've done, and the Commonwealth doesn't have their expert witness. Their expert witness. Some pussy ass 2 mile an hour backwards, do my yellow paint first, then we're going to go through the primary colors here, yellow, and then I'm going to do blue, and then God damn it, we didn't get to red. Hopefully that's coming up soon. I don't even know. What are you doing? Paint by numbers? I have no idea what you're doing. 2 miles an hour. Honey, you need a Randy. I don't know. I just feel that on its face, looking at this, everybody can see it, that there is something going on here, and it's not a conspiracy to say, because it's just on full display. This is not a conspiracy. This is disgusting. They have railroaded a woman, a civilian. So that's where we are, and we're doing this weird break, this normal weird break. Yes, and the line. Yes, so when you're hypothermic, you take off your clothes because you feel like right before you die, you start feeling like you're really hot. Your body is sending you the wrong signals, so you start taking clothes off. But I don't know if that happened. And it could also be argued that he was so drunk that it didn't get to that point. I don't know, because I haven't like looked and researched into something like that. But yeah. Ella, what are you saying? Since Mike, I think it is now about how big a civil suit does Karen have? Yeah, I think it's actually even been that for a minute. But yeah, now it's just, what was it? 50 mil? It sucks for those living in Massachusetts because you guys had to pay erroneously for 2 trials.
Reporting for duty.
It sounds good.
Okay. I just threw away everything. Just went to the store and bought new stuff. All in 10 minutes. We like that name right there. The only people calling it a conspiracy is the Commonwealth. So,
P-I-U-T-R-I-N-A.
Just to fuck with people. I don't know who needs this many breaks and who needs this long of breaks. Okay, if our kids can eat in 20 minutes, I think the jury feels the same way. Like, they start at 9:30. They don't need a break. Like, what are you doing, Bev? You need a break. I think she's having a nervous breakdown.
I'm still going to go with my anal bead theory. I amended the year.
What's up, Dr. Latina in the house, baby? Shake it.
I don't see Dr. Latina. Where's she at?
Yeah, I just saw her. Well, I thought I just saw her.
Wait.
Oh, yeah, she's here. Disingenuous.
No, I didn't see you.
Yeah.
You have the best mods.
Yeah. So, best witnesses for the... So I have my little stack out here. Correct me if I'm wrong. I have the defense started off with Matthew DeSogra. Then, let's see. Yeah, Matthew DeSogra. He was witness 38. Then Jonathan DeMantis, who was the friend of Proctor, was 39. Kelly Dever.
Deva.
Maria Russell, 40. Then we have Lucky, Nicholas Barros, and Karina Kolakithis, giving us 42, 43, 44. Arca Wolf, 45. And right here, right before La Posada went on, was the PI Tendon, or whatever, however he says his name, John Teneman. He was witness 9 for the defense, 46 overall, or not 46 rather, but 9 overall and for the defense. And then right here we have La Posada. That's what I have us with. And call me crazy. Oopsies. Call me crazy, but
Oh, you so crazy.
in order to get the garage in, just call Caitlin to the stand. And you need her to say that John was on the lawn if you want, but she can also testify to what her garage looked like. She lived there. Same with Brian Jr. Use them for the garage. That's how you'll get in those garage photos. They're the ones that can, unless you think they're going to say some off the wall stuff like, no, it was cushioned, no, it was carpeted. but you can use both of them to say that you have Tristan, but I don't know.
You are unmuted.
Oh. We have
A lot of people more that didn't see a body on the lawn. Don't know. Oh, we're back. 45 minutes. 45 minutes.
Counsel, why don't I see while the jury's coming in?
Ugh.
counsel. Let me see you at the sidebar. I gotta adjust my anal beads, please.
So
One
is that
second.
what everybody else has for the witnesses? Am I missing anybody that the defense has called?
I mean, who else is counting witnesses like you, Lana? Nobody.
Oh,
So I
come
think
on.
you got it. I think you got it right on the money.
Well,
Panning down. And there is TB, and there is that Ted Daniels next to him? Oh, Peggy. Peggy is back. Nice to see you,
there's
Peggy. Everybody,
Paul's
please
friend. I think everybody was just like, let's shave our heads.
Oh, well, you remember the first trial and everybody on the stand on the on the Commonwealth side had shaved heads.
I'm curious to see if she's going to allow these what do you call it, rebuttal witnesses, because I question. I want to know what they're going to testify to.
To the rebuttal, you want to know what the rebuttal witnesses are going to testify to? They're going to rebut.
There's nothing to rebut. Like what are these people? They don't have anything to offer.
Honey,
I agree with the defense. Like you can't supplement your your case in chief. Like these are just things that we didn't ask them on, direct examination, that now we want to rebut, and we're going to ask them this stuff. Like it's like what?
no, listen. You know how Hank does stuff, though, right? He confabulates.
Yeah,
So,
but okay. Fuck, Hank. I'm talking about procedure here. In order to have a rebuttal witness, they're going to be you have to present your rebuttal witness with, this is what this person is saying, okay? And now you're going to go ahead and rebut that. It's because of what they, meaning anybody the defense has called,
right.
who are these rebuttals to that? And what you'd be, usually if you have rebuttal experts, they're disclosed, and they have to be disclosed prior to. Like there's a case management order, and you have to disclose these people. And so the rebuttal, like.
And they disclosed it, but okay. And so do you see anything?
Wait a second. I want to know what they disclosed that Coons and Hartnett and where are these? Well, I want to know what they disclosed. I cannot imagine Hartnett being anybody's rebuttal. But I'm here for it. Like these, like I'm just sorry. Like I think these people have lost their minds. They're just making up their own rules. And no, like it is what it is, I guess.
Oh, I didn't like Liza's body language right there. Ouch. Here we go.
Oh.
Gentlemen, may I approach?
Yes.
On the court's bench, there's an item that I'd like to retrieve back.
Miss, we need that marked for identification.
I need all three of them marked for identification.
Okay, and we'll do that afterwards. Just please go ahead.
Do you see any x-rays?
I did.
What were the x-rays of?
The x-rays were taken of Mr. O'Keefe at the medical examiner's office, and they were x-rays of his chest, his arms, and his legs.
Did you specifically review x-rays of his right appendage? Hand, forearm, arm?
Yes, they were included in the x-rays.
Have you seen x-rays before?
Oh, many times.
How many times?
Thousands, probably.
Is part of your job to review x-rays
Oh,
to make a
absolutely.
determination of whether or not they indicate broken bones, fractures, hairline fractures, things of that nature?
Yes, it's part of the medical legal autopsy to study the x-rays of the deceased.
That's done in the ordinary course of being a forensic pathologist, is that right?
Yes,
Are you trained on how to read x-rays?
yes,
You have to be a radiologist to read an x-ray as a medical doctor?
no,
Medical doctors do that all the time, correct?
yes, it's part of general medical training.
And is it also part of specialized training for forensic pathologists?
It falls under the rubric of general radiology that a doctor knows. There are some specialized areas in forensic where you have to understand like decompositional changes that you can see on an x-ray that aren't something that you would see in a clinical setting.
Taking the appendage one item at a time, did you look at Mr. O'Keefe's x-rays of Mr. O'Keefe's right hand?
Yes.
Did you see any defect in the bones of the right hand?
No, no bony defects, and the tissue was normal.
Did you take a look at the x-ray of Mr. O'Keefe's right arm?
Yes.
Did you notice any defects at all in the bones in the right arm?
No, the bones in the right arm were intact.
No breaks,
Correct, no breaks.
fractures, hairline fractures?
No,
Did you look at the upper arm x-ray of Mr. O'Keefe?
yes.
Did you note any defects in the bone structure of Mr. O'Keefe's upper arm?
No, the bones were 100% intact.
No breaks, fractures, hairline fractures?
Correct, none of those.
Was there any indication in your mind, based on your review of those three x-rays, the hand, forearm, the arm, that arm had suffered any kind of bone trauma at all?
Sustained.
Was there any indication, based on your review and your expert opinion, that his arm had been broken, fractured?
No, the bones were intact. No breakage, no fractures.
Thank you.
Thank you.
No more further questions. All right, cross-examination. Hank Brennan, your case is on the line.
Good afternoon,
Fourth
Dr.
quarter.
Laposada.
6 minutes till the afternoon. Good afternoon.
That's okay.
Ooh, spicy.
You wrote a report in this case, doctor?
Yes, I did.
Do you think that based on your analysis, was Mr. O'Keefe thrust backwards? Is that what you determined looking at his head injury?
That he was, I didn't understand you had your hand in front of your mouth.
Sure, I'm sorry.
Yeah,
You talked about a head injury that Mr. O'Keefe had, that
Yes.
he suffered from,
yes,
that caused his death.
yes.
Was that caused by being thrust backwards?
Yeah, the motion was upwards, down.
Okay. And the way you just showed it could be a fall.
Correct.
Did you have an opinion looking at his wound that he was thrust backwards?
What do you mean thrust?
Well-
His body went backwards. There may have been some applied force to it.
I don't know about thrust. I'm asking if you have an opinion. Your words. Do you have an opinion about thrust?
It's in her report.
What do you mean thrust?
Did the forensic pathology diagnosis mean Mr. O'Keefe's body was thrust backward?
If you want to say thrust as indicating movement, that it went backwards, then you could say it was thrust.
Okay, may I approach?
Yes.
See, I knew it. It's in a report.
I'm showing you page 2 of your report, Dr. Laposada.
Yes.
I'm just going to ask you to read it, not out loud, and then I can ask you the question after we take it, but I want to
Yes.
take a look.
Yes.
Are you familiar with that?
No, absolutely.
So, Dr. Laposada, what did you mean when you described that Mr. O'Keefe's body was thrust backward from a standing position?
I mean that he was standing upright and his body had momentum and went down and hit at the back of his head. So it was thrust backwards.
You cannot tell forensically how much momentum he had, can you?
No, we don't do those analysis.
If you can't tell if anything caused that momentum based on the head injury, can you?
What do you mean causative? It was caused by his body went backwards.
Yes. And so the amount of force causing him to go backwards, that's not something you can determine from the head wound, is it?
No, I can't tell you the amount of force. It was significant because he had the massive skull fractures.
Did you say it would be significant?
Yes, significant force.
In modern medicine, there are a number of different machines that can help us see the brain, like a CAT scan, perhaps?
Sure.
MRIs?
Yes.
Would you agree with modern medicine that the use of MRIs and CAT scans and other tools give a clinician equal, if not better, opportunity to examine the brain as actually cutting it and holding it in your hand?
No, the actual gold standard is the pathology, to be able to have the brain in your hand, look at it with your naked eye. And we have conferences in the hospital where we meet with radiologists and say what we find at autopsy and see if their radiology was correct.
Can CAT scans and MRIs show contusions on the brain?
Well, they might.
Subdermal hemorrhages?
Subdural hemorrhages. Yes, they can.
Herniations?
They can.
Do you have any doubt about the modern medicine and the use of MRIs and CAT scans? Do you think they're inadequate in any way?
Well, I'm not a clinician, so I don't use those to diagnose diseases in living patients.
Dr. Laposada, have you ever had any experience studying the brain in real time, clinically, going and opening somebody's skull and treating the injury before the person dies?
No, I'm not a neurosurgeon.
You don't have any neurological expertise, do you?
I'm not a neurologist. I'm not a neurosurgeon. I'm a forensic pathologist.
Do you have any clinical experience at all where there's an acute head injury and you're making an effort to observe it and analyze the injury as it progresses in an attempt to save the person's life?
I don't treat or diagnose living patients.
I understand, but as far as your background, have you ever had any experience, clinical experience, showing the progress of an actual brain injury and trying to treat it?
I understand the physiology of what happens to the brain when it is impacted by something, whether it be a bullet, a boulder, a fall. So I know what happens to the body to cause the changes from that trauma. I don't treat people for those injuries.
In observing a brain that's in trauma and making determinations of how long it's viable or whether the person will expire, do you know the process that a neurosurgeon would go through in order to fight to preserve the person or save the person? Do you know the step-by-step process that they would undertake?
To do what?
To try to operate or save somebody from a head injury, from a brain injury.
I'm going to allow it because of prior testimony.
Well, it depends on what the brain injury is. If you have head injury and you have bleeding on the brain that's pushing the brain one way or the other, it would be a subdural. Then a neurosurgeon would come in and try to take that blood away so it doesn't compress the brain. So that's something that neurosurgeons do to treat head trauma. They can also put in drains into the ventricle of the brain, and that can relieve pressure in the brain because that brain swelling is a bad thing. So those are some of the things neurosurgeons do to treat brain injuries.
And can they remove part of the skull to relieve pressure?
Oh, yes, they can do that. It's called a craniotomy. They can take out part of the skull if they need to.
So there are a number of different steps that a neurosurgeon can take when someone suffers acute brain trauma to try to save the person, isn't there?
Well, the job of any doctor is to try to save a human life if you treat living patients. So certainly a neurosurgeon would evaluate the patient and decide if there's any treatment needed that could improve the patient.
When you've had cases in the past as a medical examiner where there have been issues regarding brain injury, wouldn't you agree that you have sought outside consultation with people who have a higher degree of specialty in brain injury than you?
Sometimes what we do is when we're examining the brain, we can call in for a conference and have a neuropathologist come in and review the brain with us.
And back when you were a medical examiner, you did that on a number of occasions, didn't you?
Yes, that's routine.
The reason why is because there are different specialties in medicine, and some are different and separate than your specialty, correct?
Of course.
And a neurosurgeon or a brain surgeon, it would be a different specialty than yours.
Yes.
And they're focused on the brain, yes?
A neurosurgeon does brain surgery.
And so, how many times in your career do you think that you've assisted the help of neurosurgeons to take a look at brain study to help you?
I've never needed to speak with a neurosurgeon to look at a brain. Sometimes we call in neuropathologists and we have a forensic neuropathology conference where we look at brains with the interns and residents.
How often would you call a neuropathologist?
Maybe once a month we would have a routine conference.
And again, the neuropathologist, that's dealing with a person's brain after they're already died.
Correct.
So it's not a clinical setting or a clinical experience of actually watching the brain at work and seeing the injury as it progresses.
We don't do neuropathology like that on living people. The person is deceased.
You had an opinion to the jury today, and you said that you believe that Mr. O'Keefe died within 15 minutes?
Yes, I think that process would start within 15 or 20 minutes.
Is that to a reasonable degree of medical certainty, that opinion?
Yes, based on the severity of the injury and the brain swelling.
You're aware that there are numerous level 1 trauma centers around the country that deal with brain injury, right?
Sure.
And the idea is that people suffer all types of brain injury, and if they are given medical attention in a reasonable amount of time, there's a chance they can be saved, yes?
Well, it's possible, but many are so severe that they cause death no matter how fast they can get medical attention.
In fact, every day when people get the right attention or proper attention, they're brought to level 1 trauma centers around this country to try to help them or save them. Isn't that fair to say?
I would hope so.
Do you think?
Sure.
When you looked at Mr. O'Keefe's brain, obviously it's after he already expired, correct?
Obviously, yes.
And so you didn't have any clinical observation of the progress of his injury that night, did you?
I was not observing him. I did not observe how he got his injury.
When you gave an estimate or you give an opinion about how long he was alive for, are you aware that there's certain tests that are done by neurosurgeons when people are suffering brain injuries but there's an attempt to save them?
Sure.
Have you ever heard of a Guzman coma score?
Glasgow, you mean?
No, but it's Glasgow, but you've heard of Guzman?
It's called Glasgow coma score.
Have you ever seen the assessment that a level 1 trauma center goes through when they're trying to save somebody with a brain injury?
I'm generally familiar with the emergency procedures to save somebody's life.
Have you ever read any statistical studies attempting to correlate the brain injury with the time somebody would live for?
I am aware of that, and I see that in my practice of people who have survived brain injuries and die of something else. Then I can look at the brain and understand how the brain can heal or react to injuries.
And many people who suffer coup contre coup will go into a brain surgeon center, and many of them pass after time, don't they?
Now, every case is different.
Right. Some might live for an hour, hours, weeks, months, or survive the injury. Isn't that fair to say?
It depends on the case.
In this case, you don't have any objective criteria to identify the amount of time Mr. O'Keefe would have lived if he had the appropriate help. Isn't that fair to say?
I don't think it would have been effective because there were massive skull fractures to the base of the skull, and there are cases where the amount of force and energy applied to the head, causing skull fractures, breaking the neurons, causing the brain swelling, despite rapid medical treatment, those people cannot be saved. They can't effectively stop the brain swelling.
Oh,
Many people can't be
bam.
saved. Did you know that about 1/3 of them do get saved?
I don't know what you're talking about. 1/3 of everybody has different sorts of injuries. 1/3 of what?
With a clivus fracture, coup contre coup. Are you aware that 1/3 of those patients survive if they get the proper treatment?
It depends on the amount of force.
Okay. Are you aware that a study would show, have you ever read a study by Isaac Wolf on clivus fractures?
No.
Have you read any studies on clivus fractures?
Clivus fractures? Yes, I understand what clivus fractures are. It's a part of the base of the skull.
Okay.
And
And
it
have
depends.
you,
Okay, go ahead.
please, did you want to say?
No, you go ahead.
Oh, I'm sorry. Have you read any studies that tell you with the proper treatment, despite these potentially catastrophic injuries, that 1/3 of patients can survive?
No, but that's not the case we have here.
And so in this case, I asked if you had any objective criteria. You don't have any objective criteria about the progress of Mr. O'Keefe's wound that can be a basis for you to conclude that he would have died in 15 minutes. Isn't that fair to say?
No, I understand what happens to the brain when it gets that sort of injury. I understand the time course and the physiology. I've seen hundreds of individuals who've had brain injuries. Some survive for a longer period, some die earlier, and it depends on the amount of force and the amount of brain swelling. And in Mr. O'Keefe's case, we had the massive skull fractures of the base of the brain and immediate swelling and subarachnoid and subdural. So he had a large force applied to his head, which caused the brain swelling and the and the progression of the brain stem down through the foramen magnum that stopped the brain. It was a very forceful impact.
You examined his brain after you looked at photographs. You can't tell us objectively when his brain swell started.
It started immediately after impact.
And you can tell us what the progress of that brain swell was by looking at his post-mortem photos.
By looking at the postmortem photos and the postmortem examination, I can tell the degree of force from the extensive skull fractures that were present.
What was the degree of force?
It was medium to large.
Well, that's a wide range. What do you mean? Quantify medium
So I'll
to
strike
large,
the comment.
please.
Ask the question, Mr. Brown.
What does medium to large mean?
Enough to cause a lot of fractures to the skull. He didn't just sit down and lie down.
If he sat down and lied down, he probably wouldn't have fractured his skull, correct?
That's obvious, yes.
Right. And so when you're telling us you can identify that he immediately died or died within 15 minutes, I'm asking you for objective criteria. For you to give that opinion, I'm asking you what objective information you have. And so you said that there was a large amount of force, correct?
Sure, but because there were massive skull fractures and there's a lot of energy transmitted to the brain start swelling immediately
How do you know this wasn't medium force and not large force?
because of the extensive number of skull fractures,
So are you saying it was medium or large force?
medium to large.
Okay. How much force is that? Can you quantify it?
No.
What other objective criteria do you have to support your opinion that Mr. O'Keefe died within 15 minutes?
My training and experience of seeing thousands of deceased people from head injuries and knowing some of their clinical course when they get immediate medical treatment, they don't survive.
But you would agree many do.
Depends on the case.
And in this case, you didn't have any opportunity to observe the progress of Mr. O'Keefe's injury that night, correct?
Objection, Your Honor.
I'm going to allow that.
I wasn't there. The
You had-
body told me what happened to it.
You have no assessment of the development of his brain injury and how much time it took that night, do you?
I do, from understanding the significant skull fractures and the swelling of the brain and the compression of the brainstem that all happened very rapidly because of the amount of force that caused all those skull fractures on the base of the skull that actually then hemorrhaged into his upper eyelids. That's a large amount of force.
Was gross edema found on his brain?
I think it was swollen, yes.
But was that a finding?
Yes.
Where did you see that finding?
Well, in order to have the herniation of the brainstem, the brain swells.
Where did you see that finding?
I can't answer that. I just know it from understanding, looking at the pathology.
So at the end result, at some point, Mr. O'Keefe had gross edema.
In order to get the brain stem hemorrhages, the only way you get that is because the brain has swelled. And there's no, after injury, tissue swells, and there's no place for the brain to go when it swells except down into the natural hole in the bottom of the skull where the spinal cord goes down. So that's where the pressure goes. So that seeing the brainstem herniation tells you that the brain has swollen a lot.
Undoubtedly, but it doesn't tell you when it began to swell or the progress of that swell, does it?
I don't know what you mean.
You see inevitably because of the swelling, there's the suffocation, but when you see that, you don't know when the swelling began or how quickly it progressed. You can't tell that from an autopsy.
Yes, you can, because of the severity of the skull fractures. I know there was a lot of force, and that force applied causes you to go unconscious, then your brain swells. If there was just like one skull fracture, then that's a little bit different. But this was massive skull fractures on the base of the skull. So there's a lot of force applied. So I know because there's a lot of force applied to cause the skull fractures, that the brain would swell rapidly.
You would be unable to identify the rapidity of the swelling if you don't know the amount of force. Isn't that fair to say?
Well, I do know the amount of force because of the amount of skull fractures.
In what you know is, in your words, medium to large force.
Yes.
You've heard of periorbital ecchymosis,
Yes.
and that's sometimes called raccoon eyes.
Well, periorbital ecchymosis just means bleeding and bruising around the eyes.
And you saw the bruising around Mr. O'Keefe's eyes, didn't you, in the photographs?
Well, it wasn't bruising caused by blunt force trauma to the eye. It was bleeding in the upper eyelid because the plates above the eye and the base of the skull were fractured by the brain hitting it. So, and that's a result of basilar skull fractures and not the application of force directly to the eye.
Would you agree it takes a few hours for the bleeding to accumulate in the person's eyes?
No, as soon as you break the skull bones and the heart's pumping, the blood comes out of those injuries.
So
It starts to accumulate right away. It starts within minutes, you can see it.
So you would disagree with the suggestion that it takes at least 1 to 2 hours for that bleeding to occur in the eyes. You disagree with that?
I do disagree with that. It starts immediately.
Do you have any studies that you've relied on or literature or support for that?
I understand the physiology of what happens when you get those skull fractures and the density of the blood vessels. And if your heart is pumping, you pump the blood out those broken blood vessels into this small area above the eye. And it can happen within minutes.
Do you have any studies or literature to support that?
That's my training experience. I can't cite you a particular article at this time. I could certainly go look it up and bring it to you.
Okay. Let me ask you questions about the wounds to the back of Mr. O'Keefe's head.
Yes,
You see a linear abrasion?
yes, vertical lines, yes.
Now, would you characterize this as a classic wound caused by falling backwards and landing on your head?
What do you mean every wound is different?
Every wound is different?
Sure, every person's different, every way you get injured is different.
And so if somebody falls backward on their head and suffers the basal fracture, the wound from your perspective can look different.
It depends on the impacting surface.
Wounds on the same surface, say two people fell on the same surface, could they have different wounds on the back of the head if they suffered the same injury?
In theory, if they fell, if they rotated their body, if you could reproduce something exactly, then you would see the same wound patterns.
This wound pattern is typical of falling backwards on a hard surface, isn't it?
We know it's from falling backwards and striking something hard.
Can the frozen ground be hard?
A frozen ground can be hard, but it doesn't fit the pattern in this injury.
We'll get to that, but is it
okay.
hard enough to cause a basal fracture?
It can cause a skull fracture.
The frozen ground is different than a sheet of ice, right? It's not smooth and flat like a sheet of ice, is it?
It could be, I guess.
Okay. You mentioned there's some granular patterns in this wound.
Yes.
didn't you?
Yes.
The area in front of 34 Fairview, the frozen ground, do you know if there was any impediments in the lawn that was frozen?
In the what? Oh, the lawn?
Yeah. Yes. Sorry.
Yes, I saw the scene photographs of when the snow was removed, and it was like winter lawn grass. So it was some green, some brown that was pushed down, and like straw that was going different directions, which wouldn't give you that pattern.
Did you see the exact area where Mr. O'Keefe last moved?
I saw that general area, and there were a lot of photographs,
Well,
yes.
You say general area. Can you tell us that you saw photographs of the spot where Mr. O'Keefe was lying when he was found?
Yes, that general area.
Could you see the ground where his head was? Can you identify that?
Yes, with the scene investigation, they shoveled the snow off of that area.
And you had never had a chance to go out to that scene yourself, did you?
No, I just looked at all the photographs.
You cannot see what's under the grass and the dirt, can you?
Well, dirt's under the grass.
Well, do you know if there's any rocks or impediments or bumps?
It was a smooth surface covered with grass.
It was a smooth the front lawn was a
It
smooth
was a
surface?
flat surface
Flat.
covered with grass.
Okay, and do you know what was under the grass, whether there was any pebbles, rocks, debris?
I didn't see any.
From the photo.
Correct.
But you don't have any firsthand knowledge that exact area where he ended, what the turf was like, do you?
I saw photographs of that lawn where they removed his body from.
So you're relying solely on the photographs, is that fair to say?
Correct.
Do you know if Mr. O'Keefe was wearing anything that could cause abrasions when he landed to cause that scraping pattern in addition to the linear abrasion?
He did have a baseball hat on, but that would not cause that pattern.
The area of the abrasions, is that in the area of the level of where a baseball hat would be on the back of somebody's head?
It could be.
Could be. If somebody hits the ground and falls backwards, can they slide?
If they're on an incline,
What if they're thrust?
well, if you fall backwards and you fall backwards on an incline, your body might move.
Well, what if you fall backwards on flat ground? Does the body, can it move after it falls?
Not really, maybe a little. If from the momentum of the impact, it might move slightly, but not really.
So when a person falls backwards and lands, you don't think their head has any room for movement?
Not significant.
Well, not significantly, maybe just a quarter inch, half inch.
No, it's possible.
Okay. And did you see the scrapes around the wound of Mr. O'Keefe's head?
Of course I saw them, yes.
Okay. And they're all within, what, about an inch?
What are you describing? What part? Are you describing the tearing, the laceration of the scalp, or the vertical abrasions?
The vertical abrasions.
There were maybe an inch, inch and a half.
Inch and a half? Do you think that if someone fell backwards and landed on their head, they could move an inch and a half?
Well, he landed on something that had a ridge on it to cause the laceration in the scalp, and then with a little bit of movement, those vertical scratches were caused by some kind of like pebbly-like surface.
You mentioned that the orbital bones were broken and you had opined that it was caused by the brain. Do you agree that a brain is very soft, consistent with, for example, tofu?
Oh, gross. No. What do you mean? It is soft.
Is it that soft? Is that the texture of it?
Well, it depends on what kind of tofu you have.
Okay. Do you think that the orbital could have broken when the break on the back of the head split the skull and then would cause the orbital break instead of the brain?
The orbital plate fractures, if you look at the base of the skull after you take the brain out, you can see the fractures go up from the back to the front into the orbital plate. Sometimes when you fall backwards, the brain can also slap those orbital plates and cause some damage, but I could trace the fractures from the point of impact along the base of the skull to the part of the skull over the eyes.
Do you think the base of the skull break, when it separates, could have caused those orbital fractures?
I don't understand your question.
Okay. When Mr. O'Keefe incurred that head injury,
Yes.
the basal fracture, do you think that the pressure, the damage from that basal fracture, the separation, could have caused the orbital breaks in his eyes?
Well, the fracture of the plates above the eye, when the blood is still pumping, there's a space there where the blood can come down into the upper eyelid.
So you described the brain as causing that break. I'm asking you, could it have been from the basal fracture, from the skull fracture?
Yes, the fracture that was caused by the impact to the back of the head, radiating to the front of the base of the skull.
So when you told us on direct it was from the brain that caused those fractures, was that just a summary, or is that to a reasonable degree of medical certainty?
Well, sometimes the brain can also, in a fall, flap and hit those, but in this case, I could also see that the skull fracture started at the back and came to the front, but it could also be contributed to by the brain hitting those delicate bones.
I guess my question is, when you've provided the opinions generally of what you believe and what you've seen, are these general opinions, or are they actually specific opinions based on the facts of this case?
They are opinions based on my examination of this case, but all that's based on my 40 years of training and experience.
But when you told us about the brain causing those orbital fractures, you would agree with me, at least now anyways, that it very likely could have been the basal fracture that caused those breaks.
They're both.
It could have been both?
Sure.
Okay, could have it been just the basal fracture?
That's possible.
When you offered the opinion to a reasonable degree of medical certainty, had you considered the basal fracture as the source of those breaks?
Of course.
Is there a reason you didn't share that with us and you just said it was the brain?
I had no reason not to share it.
Okay. Was there any depressed fracture to Mr. O'Keefe's skull?
No.
Can you tell us a little bit about a depressed fracture? Depressed fracture is different than what we saw with Mr. O'Keefe, isn't it?
A depressed fracture is when something fractures the skull and then pushes the skull and moves the skull inward. This just had a fracture, but it didn't move the skull inward.
And you've seen depressed fractures in your practice over 40 years, did you say?
Of course.
In those 40 years, depressed fractures can happen from sharp objects,
Sure.
pointed objects.
Sure.
If someone hit a person in the back of the head with enough force, with like a hammer, for example, that could leave a depressed skull fracture, couldn't it?
Certainly. You can hit somebody on the head with a hammer and cause the fracture, and then the continued force will move that fracture into the brain.
There was no depressed skull fracture in this case, was there?
Correct.
You gave some opinions today about you gave some opinions about wounds on Mr. O'Keefe's arm. I'd like to talk to you a little bit about that.
Sure.
Could we have that photo brought up, please?
My question is why wasn't there depressed skull fracture? If he asked that on
Do you see
redirect.
all of those superficial abrasions?
Yes, I see patterned injuries.
Right. Would you agree that they're superficial abrasions?
Yes, they go along the skin surface.
How many punctures would you identify in that photograph?
Let's see, there may be some punctures like around the elbow, consistent with the teeth puncturing. Most of them are the teeth scraping along the skin.
Well, I'm not going to ask you what you believe the cause was. I'm going to ask you just about the wound. How many punctures do you see?
Well, this doesn't show, there are other photographs which show more of them, but there's the little dot-like areas, you could call an area of skin puncture.
Can you tell us from this photograph how many punctures you would say are in that photo?
I didn't count them.
Well, did you suggest that there was more than one puncture on that wound?
I think I see more than one, yes.
Pardon me?
I see more than one on there.
Okay, could you give us a count of how many punctures you see?
Well, without looking at all the photos, I couldn't give you a correct number.
Okay. You've written a report, haven't you?
What?
You wrote a report?
I did.
And in your report, you describe many of those abrasions as punctures, don't you?
Yes.
And a puncture isn't just a scratch. A puncture is a penetration of the skin, isn't it?
Yeah, a point-like penetration.
A puncture has a very specific medical meaning, doesn't it?
Yes, it's a point-like penetration of the skin.
And according to you, there are many punctures in that wound.
Yes, I can see 1, 2, 3, 4, 6 or 7.
Can medical professionals disagree on opinions about wounds and causes?
I suppose they can.
You also gave some opinions that you did not believe that Mr. O'Keefe's scratches were caused by having some impact with broken pieces of plastic or glass, correct?
Correct. They weren't caused by that.
Broken plastic or glass can cause a number of different angled wounds, can it?
It causes an array of irregular, random injuries.
It can have infinite different patterns, couldn't it?
Could.
There's nothing to hold a wound from a broken shard to be north or south or east and west. It all depends on how the force is impacted on the body, true?
I'm not quite clear on your
Okay,
question.
I'll try to do better. When you're talking about shards of broken glass or broken plastic, there is no set direction that they may cut somebody, is there?
Well, it would depend on the case and how those occurred.
They can happen in many different forms as far as depth, yes?
Well, anything's possible.
Okay. How about length?
What about length?
Wouldn't that change, couldn't that change depending on how the injury occurred, the length of the wound?
Sure.
And in this case, you talked about your opinions of injury relative to a motor vehicle, didn't you?
That was something I considered.
That's something you considered. Did you know much about the details of the motor vehicle in this case?
Yes.
Okay. When you considered your differential diagnosis, did you consider whether there was any DNA on the vehicle?
I didn't look at any of that.
I'm sorry?
I did not look at any DNA.
Did you know if there was any hair on the vehicle?
I don't know.
Did you consider the scene itself where there may have been a debris field? Did you take a look at the debris field in this case?
I know there were photographs of various pieces of plastic around the area where the body was found.
And do you remember where those pieces were found?
Somewhat, yes.
Did you have an opportunity to consider other evidence like a shoe in the area near where Mr. O'Keefe was found?
I know one shoe was on his foot at the hospital, the other was at the scene.
Do you know if his hat stayed with him after he landed on the ground?
The hat was in the area where his body was found.
Did you take a look at his pants, the back of his pants?
I looked at that, yes.
Okay, what did you see when you saw the back of his pants?
Well, because he had bled from the back of his injury and he was on a hospital gurney, some of that blood came down, so some of the blood was on the back of his pants.
Did you see anything else other than blood on the back of his pants?
I don't remember.
I'm sorry?
I don't remember if I saw anything else.
Did you look, when you were doing your differential diagnosis, did you look at any evidence other than physical evidence? Did you look at any data evidence?
I don't know what you mean, data.
What?
Like data you would find on a cell phone?
Okay.
Did you look at any of the data evidence from the defendant's Lexus?
No, other than looking at the contours of the back to see if it had impacted Mr. O'Keefe.
When you were doing differential diagnosis, did you look at any information that would tell you what the speed of that impact may have been or allegedly was?
Well, it didn't hit him, so it doesn't matter.
Okay. So you didn't care to know anything about the car or the data in the car because you had already formed your opinion?
It did not hit him, so it was not relevant to my opinion.
Is that a different way?
By looking at the body, I could tell that there was no evidence of impact with a vehicle. So whether the vehicle was going slow or fast is not relevant.
And so you didn't try to get any information about the speed of the vehicle? It was totally irrelevant to you?
Correct.
And did you also disregard, well, let me ask you, do you ever look at statements?
I look at witness statements if they're available to me.
Were any of the defendants' statements made available to you?
I did hear some of them.
Did you consider the ones that you heard?
Of course.
Which ones did you hear?
I really can't answer that. I don't know what you'd have to give me an example.
You said that when Mr. O'Keefe first incurred his injury, you think that he was unconscious?
Yes, I think that the severity of the impact made him immediately unconscious.
So if hypothetically Mr. O'Keefe incurred his injury sometime around 12:32, Is it your opinion that he never moved again until he was moved physically by somebody else?
Well, I don't know the exact time that he got the injury on the back of the head, but after that time, he could not carry out any purposeful activity.
May I approach sidebar, Your Honor?
Okay.
Oh my God, welcome back to Truth and Transparency. Let's talk about it. Oh my God, talk about literally rounds 1 through 5. Give it up for the good Dr. Elizabeth La Posada. God, she just literally went body shot, left hook, body shot, right hook. Literally just chopping down the Russian right there. Rocky Balboa, pounding him. She literally just gave Hank the most gentle ass beating I've ever seen. So gently. Rounds 1, 2, 3, 4, 5. Hands down. MVP right here. I didn't have to consider that. Doesn't matter if the car was going fast, slow. The car did not impact John. It didn't cause it. Then he said, what if the phone data, the data? She's like, what data? I love it. What data? Because he just asked like that, like, well, did you consider the data? She's like, what? I don't, what? And we kind of said this like simultaneously. It's like, what data? Like, I knew what he meant because we've known this case, but who does this man think he is? Hank, did you consider the data? What data? The phone. If the phone stopped moving, like, so if John stopped moving at 12, bottom line is that when he suffered that blow to the head, he's out. He's out. He is not moving by himself, walking anywhere. Oh, God, love it. God. And this is what confident people that know what they're doing, like, this is how they testify. Straightforward. No, I didn't need to consider it. Well, oh, and did you hear him go, why? Did you consider the DNA on the car? Did you consider the hair on the car? Nope. Where was his hat found? How about his shoes? Mm, did you consider that? And she's like, what? We're talking about the wound. We're talking about what he suffered on top of his head. God, I mean, I wouldn't even call Dr. Rensler. He's not needed. He's not needed. He's not needed. He's just not. They're going to call other people. Leave Hank thinking that you're going to call him. I wouldn't call him. There's no reason to call him. Hank is literally losing his shit over there. We got a 30-second timeout. Hank was like, I need to go puke really quick, and I might need to take a shit at the same time. Yeah, you know what's great? You know when I get giddy is when I see cheaters still lose. You cheated and you still couldn't win. Allegedly, supposedly, simply unique 22-month member. Turtle Boy just tweeted that the jurors were smiling at no car impact. her answer as to why she didn't consider the car and all that stuff, and that there's no bruises on his body, there's no broken bones on his body. She's saying because of that, I was able to rule out that he was hit by a car. He's asking if he could probably ask certain questions to lay some foundation here to see what you have a
All right,
report.
so
What is
jurors,
she?
rather than keep you here while we do things, I'm going to
Mm.
excuse you for lunch. Lunch will be about 50 minutes or an hour, and when you come back, we will go straight through the afternoon. We're going to do everything we need to do now.
Jurors, please follow me. Close your notebooks, please.
Okay, thank you.
I don't
is
think we're going on
something.
a lunch.
Wait, you don't think we're going on a real lunch? Is that what you said?
No. I don't think so because I think that they have to handle something right here. So hang tight.
We're on the edge of our seats. She just dunked on all of them.
Here we go.
May be seated.
All right, so Mr. Brennan, if you can briefly tell me what it is you want to introduce through this witness.
To remind the court, on direct examination, the defense promoted Dr. Lapasada's credentials, including specifying her successes with the station nightclub fire and her running of her office. I have an audit from 2005, State Department of Rhode Island, Department of Health. In that audit, it paints a very different picture than was presented on direct examination. In that audit, they investigated the chief medical examiner, and they compiled the history of statistics for the medical examiner, which was Dr. Lapasada. There were no reports, incomplete reports, and unsigned reports of over 1,500 individuals between June 30th, 2000 to June 30th, 2005. So in that 5-year period, there was an extraordinary number of individuals that weren't properly attended to, showing negligence, if not malfeasance. It was recommended that the standards, policies, and practices of Dr. Lapasada's office would need to change because of the extraordinary backlog of cases regarding autopsies. In addition, it was noted that the incomplete reports confirmed that there was significant concerns with the historical management practices of the medical examiner's office shortly after Dr. Lapasada resigned. In addition, it was promoted that in the station nightclub fire, Dr. Lapasada had a heroic effort, and in her testimony, she also noted that there was a failure, or implied there was a failure because the medical examiner or somebody did not go to the scene to look at the turf in front of 34 Fairview Road. She suffered the same criticism for hours and hours after the station nightclub incident. She was contacted with a request to come to the scene. She refused to come to the scene, did not appear for at least 17 hours, directly on point to the claims that she's making against other people is the same conduct she engaged in on a more extreme scale. She testified in Commonwealth versus Tompkins. In Commonwealth versus Tompkins, she was listed and testified as an expert, attempted to testify as an accident reconstructionist, which was denied. Inevitably, the court made conclusions. Actually, in that case, her efforts to be an accident reconstructionist were denied. Then she testified in a case called Patino. And in Patino, after testifying, she received great scrutiny and criticism from the court. The court noted on page 1025 of the transcript, when Dr. Lapasada gave the testimony, she knew the boy wasn't like this because he fell off a bed. She knew the mother was lying. She read the text messages and knew the defendant had beat the boy. The only reason I conclude that she offered such testimony was to distance the defendant from causing those bruises, setting up an argument against malice, but instead destroyed her credibility. On cross-examination, she came across as a hired gun. Sometimes it's seemingly small things that impeach a witness's credibility. Inevitably, on the credibility determination by the court would agree. The jury gave greater weight to the testimony of Dr. Gilson and Snelling than they did Dr. La Posada for the reasons I addressed previously. The jury was justified in discounting her testimony and concluding the other doctors testified apparently impartial. While she appeared as a paid advocate, at least on this occasion, without impugning the witness's integrity, because that witness is known to the court, but in this case, when she testified, she was not credible. That's a direct credibility determination by another tribunal about her testimony. So I would like to, and that's why I came sidebar rather than ambush, to give the court notice that I'd like to get into the criticisms regarding her run as medical director that led to resignment after she was audited and left 1,500 bodies unattended or incomplete. Also get into the criticisms she received for her handling or lack of handling of the station nightclub fire, and finally get into the adverse credibility determination in the Patino case.
So I'm not familiar with the Patino case, so I'll need a copy of that.
Yes.
All right, Mr. Jackson, I'll hear you.
Thank you, Your Honor. First of all, Mr. Brennan said that the audit established that, as the chief medical examiner, the audit revealed that she left 1,500 bodies unattended, was his quote. Bodies unattended. That's absolutely not what happened in that situation. It was a political situation. The medical director for Rhode Island came in and took over. He began to change protocols and cut quality control. He said he did not want a second set of eyes on any of the reports, not the autopsies. There was never a suggestion, ever, that an autopsy was not performed efficiently and timely. Never. The reports that were attendant to the autopsies it was a two-tiered set of criteria that Dr. La Posada put in place to establish quality control and quality assurance. First, the medical examiner conducts the autopsy and writes a report. Then the doctor herself, the chief medical examiner, because she is a perfectionist, determined that she was going to establish a protocol in which she would put eyes on every single report. Hundreds and hundreds of reports per year. In doing so, she had to prioritize which reports were going to take a priority, which ones were being subject to litigation, which ones were going to be subject to criminal cases, and which ones were never going to be subject to any review at all. For instance, if somebody was found, let's say somebody that was without family, etc., found and unidentified, there's no litigation attendant to that report, she would put that report aside and get to that report after she dealt with the reports that were on sort of on the front burner, if you will. After, by the way, none of the reports were ever not done. They were all completed. There were a small fraction of reports, according to the audit and according to Dr. La Posada herself, that had to take a back seat. When the medical director came in 2005, by the way, this is 25 years ago, right? These are autopsies that were performed, and the audit was performed for autopsies and reports dealing with the year 2000. It's 2025. This is 25 years ago. When the new medical director came in for Rhode Island, he said, I don't want any review of any of the reports because it's more efficient and it's faster to get the reports out in a timely fashion. She resisted and said, I will never, ever, and she was published saying this, I will never, ever sacrifice quality for speed. I want the highest quality coming out of this office. They had a difference of opinion. She walked away because he was asking her, the new medical director was asking her to sacrifice quality of the conduct that she was undertaking as the chief medical examiner for the state of Rhode Island. So it's a very different circumstance than was just suggested. No bodies were ever left unattended, ever. Certainly did not involve the other phrase that was just used is negligence and malfeasance. It was a backlog, and they had a very public political fight over it. Number two, with regard to the Station nightclub fire, her staff was on location immediately. She, as the chief medical examiner, was there the same day. So that's of no legal moment. It's of no consequence. It certainly has nothing to do with her opinions and conclusions in this case. The Tompkins case, we've already talked about that in voir dire, Your Honor. The Tompkins case dealt with an issue dealing with accident reconstruction, which she's not undertaking. I'm not asking her, and she ain't saying.
I've excluded that part of it, based partially on the Tompkins case.
Right, and I don't know anything about the Patino case, and what I would say is, given the fact, look, we don't know what the facts of that case were. We don't know what the trial was about. We don't know what the cross-examination was about. We don't know why she was called. We don't know what she looked at. We don't know why she was looking at what she did look at. We don't know why she didn't look at things that she might not have looked at. We don't know why her opinions and conclusions were ultimately rendered. We would have to have a trial within a trial, which I would be happy to undertake if someone gives me a file. Happy to do that. But I don't think we want to do that. I don't think the court wants to do that. Also, I will say, I don't think that attacking this witness's credibility is in good faith by the Commonwealth. Mr. Brennan himself has hired Dr. La Posada personally no fewer than 4 or 5 times. Maybe it's 3 or 4 times. He knows her qualifications. He knows the quality of her work. He's actually undertaken to consult with her as a medical examiner and a consultant. So I don't believe that these last 2 issues are in good faith. I don't believe the station fire has anything to do with anything because she was late, according to Mr. Brennan, in coming to the actual location. She was there the same day, and she had an entire staff that was there immediately. And in terms of the audit, it's a 25-year-old political fight that isn't quite what Mr. Brennan made it out to be. So I don't think any of these things are relevant for cross-examination. I'll submit.
All right.
I just want to make a note that Attorney Jackson has a way with words to just inflate or make things up. I have not hired Dr. La Posada 4 or 5 times. And so that is just a mischaracterization which he likes to do for the public. But the reality is I've used her a few times, and the last time I used her, I'm not going to disclose why I don't use her anymore because it would be unfair without her in the room. But the suggestion that somehow I'm endorsing the qualifications of this witness, I am not. That's what I'm going to say on the record.
Okay. So the first 2, the backlog issue, if we can call it that, with the ME's office, I'm going to allow the Commonwealth to get into that through questioning. Same with the Station nightclub fire, based on the testimony already in evidence. Those 2 areas, and Mr. Jackson, without leading, you can certainly go back and rehabilitate her. But those 2 will come in. I'm not going to do anything
Why?
with Tompkins because I used
What's
it
the relevance?
for the basis of keeping out what appeared to me to be biomechanical engineering opinions of this witness, and she's not qualified to do that. So I have not read Patino. I will read it over the lunch break and see if we get anywhere with that. Okay, so I need a copy of that. I want you to give Mr. Jackson a copy as well.
I will.
Okay?
He has a copy.
Okay, so,
I didn't know that. I appreciate that.
all right.
The only other thing, I don't know if you want to hand it now or after lunch or later, but I want to address the issue of the 3.
Okay, so let's mark those now.
Sure.
God, Bev, you act like you're just pissed that you have to do your job.
Can we mark them all as 1 A, B, C?
I have no preference one way or the other. It's just 3. They're all
Mr.
filled out.
Jackson, if you can I just see it?
Mr. Jackson. You know what's so sad is that if he wasn't involved in this case, Bev would be jizzing. Bev would be like, Mr. Jackson, I'll allow you to do whatever you want to me. If he wasn't involved in this case. Mr. Jackson.
You know what? Show me that one again, too, please.
You know what? Show me what you're working with, Mr. Jackson. Mm-hmm. was a joke.
This is her Kegel squats.
Yeah. She's like, God, she's just, ugh. But she would swallow him whole if he wasn't on this case. Mr. Jackson.
He wouldn't put that in her mouth. Vile.
Yeah. Mr. Jackson, if you're nasty, babe.
H, quadruple H, and I, blue I.
All right. All right. Mr. Brennan, there's no objection to these coming in through another witness, so you agree that they'll be coming into evidence?
I'll stipulate
All right. And what's the objection to them coming in through Dr. LaPosada?
it's not part of her report or opinion. And she's gone beyond her report, talking about the fact that she's studied x-rays and given an opinion. I think that suffices. It really, I think, is beyond the scope of her testimony to begin with. I'd be gracious with it. Stipulate to these, I'm sure Dr. Wrench will utilize them if they're stipulated.
So you'll stipulate to them prior to Dr. Rentschler?
I will.
So you can use them with Dr. Rentschler?
I expected that I could, because he certainly used them in his analysis and opinion. But I should be subject to the entry of evidence in the defense case in chief. I understand I can use it in Dr. Rachel's testimony, but I want to use them with Dr. LaPosada. She's a medical doctor.
Would you
consider them for purposes of her opinion? I cannot understand.
So what do you want to ask her about them?
Are these the x-rays that you reviewed? Yes, that's it. That's
Okay.
it.
Okay. So go ahead.
And if that's all he's going to ask, I won't have a problem.
Okay. Yeah, I have no problem with that in that form.
That's it. Literally, you see the x-rays that we talked about a little bit earlier? Yes. This is the right hand? Yes. That's the arm? The forearm? Yes. That's the upper arm.
All right. So they're cumulative, but if they're coming in anyway, I will let you put them in.
They're not cumulative
So
at
the
all.
last thing is Dr. Rentschler. I need to hear argument from both sides. I have a new PowerPoint. So I'll hear both of you. Mr. Brennan, I'll hear you on your motion.
We've received the most recent update to Dr. Rentschler's PowerPoint. There are some additions, different analysis in that PowerPoint. This is within 24 hours of him testifying. There are opinions on page 6 and 8 of his May 7, 2025 report. And there are a number of numbers that we have objections to. Dr. Rentschler just generally shouldn't be allowed to express opinions and conclusions about what he thinks about the case or about other witnesses.
All right, so I'm looking, I think, at the new,
Do you have a copy of the new one?
from today, page 6. So what I have are just photos with measurements, so I don't know what the testimony that corresponds with those. I've read, obviously, the report of Dr. Rentschler from May 7th. That does not seem to detail everything, and that's no criticism. I'm just saying it's a scant report, so I don't know what the opinions are regarding these.
I'm sorry. Yep.
I didn't want to speak over Mr. Brennan, I apologize. I just wanted to let the board know we're talking about after now. We went through, based on Mr. Brennan's suggestions last night, and significantly edited the entire thing. Literally every single slide that you had a problem with. There were a couple that we just literally left, but it's very, very.
I see that a lot of the hearsay's been removed.
Okay.
And I can identify this report as helpful.
Thank you.
I'm sorry?
I can identify this report as helpful, the ones that were changed.
All right. So what do you both, I'm going to hear from Mr. Brennan first. What are you objecting to as the report now stands?
I have a most recent copy of the report now. So 9 through 27.
Slides 9 through 27 or pages?
Slides 9 through 27 now have Dr. Rentschler identifying and attempting to match different abrasions with different holes in Mr. O'Keefe's sweatshirt. And so basically what he is trying to do is to suggest that there are a different amount of abrasions relative to the amount of holes, or perhaps he might want to testify about that the holes in the sweatshirt were in a different place on Mr. O'Keefe's arms than the abrasions. The reason why this is concerning is because there is no background for him regarding fabrics. This is a different and new opinion that we have not prepared or obtained an expert for. We probably have very little time to get somebody to rebut this analysis regarding fabrics. I don't see anything in his CV or his history that allows him to equate the number of holes in fabric with the number of abrasions on somebody's arm. It does not consider or account that there could be multiple wounds from one hole, or there could be holes that don't create wounds. So whatever the implication is going to be by Dr. Rentschler, we're not very sure, but it obviously would require some type of expertise, which I do not think that Dr. Rentschler has a foundation for. So those are 9 through 27 generally, and then specifically, I can run through quickly the individual objections I have. Slide 6 tries to define the theory of the alleged incident. Doesn't say whose theory it is. It implies it's the government. It's an improper suggestion.
Okay. Okay, so which one of 1, 2, and 3 on 6?
1 is objectionable. What's the core issue of the case? It's an ultimate issue for the jury. An expert reconstructionist or a biomechanical engineer shouldn't be defining the core issue of the case. And then 3, first event is alleged contact between the rear of the Lexus and Mr. O'Keefe's right arm. Again, that's offering an opinion that doesn't have facts and evidence, not in a position to draw that opinion.
And is 2 okay? Or are you moving to the whole slide?
No, on number 6, all 3 of them shouldn't be there. Asking what the core issue is in the case, Dr. Rentschler and no expert should be defining what the core issues in the case are. They should talk about their training experience, any testing, observations, evaluation, and then give their opinions, not core issue in the case.
All right.
Slide 9 outlines perhaps his process. The first step of the analysis to determine if the arm injuries are consistent with the physical evidence. Evaluate the abrasions and compare the evidence. I suppose this is what he's done. This is one of the less offensive ones, although unnecessary. It doesn't provide an opinion. I could live with that. The next one.
You could live with what?
Number 9.
Okay.
Number 23. Again, this gets into that new core opinion about trying to identify or, I think, compare the abrasions to the different wounds. I think the part that's objectionable is the words measurements, question mark. I'm not sure if it's implying failure of somebody else. It seems to be an opinion, and I'm not sure of the context of it. 24. The expert is trying to define what Dr. Welcher had done. It may be that he's saying he conducted his testing based on the position of Dr. Welcher's arm. I think that would be an appropriate comment. but it's not clear what they're saying. The pain transfer test, number 2, is the only test noted with respect to the arm.
So without the text, are you objecting to this
No.
slide?
No. No.
Okay.
31 posits questions regarding ultimate opinions. I think it's inappropriate. And then 32, I think, is improper because it ultimately endorses or vouches for the witness's credibility. I think he certainly can give an opinion that the evidence is inconsistent with the injuries to Mr. O'Keefe's arm, but I don't think it should be on the slide bolstering his opinion. 33, again, it's posturing the weight of the evidence. And it's resigning the government to a particular study, one study. It's really a commentary on the government's case. It goes like this. Number 1, Dr. Welcher only did A, and second part, A is insufficient. So that's really what this is saying. It's commentary, it's hearsay, it's inappropriate. 34. I think if one said that that's what he did, I, Dr. Rentschler, took a step to determine the kinematics of Mr. O'Keefe's arm during the alleged incident and asked how would this arm move. I think that would be appropriate. But he shouldn't be giving an opinion on what steps should have been taken by Dr. Welcher. Number 2 on slide 34. And number 3 I don't have a problem with. The next one is 46. Again, this is bolstering the expert's opinion by putting it in writing on a slide. I think some of these opinions are appropriate for Dr. Rentschler to share with the jury, but his final ultimate opinion shouldn't be endorsed on a slide. 47. Again, this is self-endorsement of the success of his tests and giving his opinion about his success. Number 1 and 2, I think, are inappropriate. Number 3 has really no context standing alone. And number 4, if he notes that's his next step, I wouldn't have a problem with number 4. Slide 54. Again, number 1 gets into his opinions. Number 2, he gives an opinion about a different expert, a medical opinion. And number 3, it's, again, self-endorsement on his own opinions. So all these are opinions either bolstering himself or somebody else's work. I don't think it should be in a slide. 55. I think it's accurate. I think it's proper testimony. I don't think it's proper for a slide. Same with 56. I don't know that he has the basis for number 1. Number 2, I don't have a problem with on slide 56. And number 3, again, it's bolstering his opinion. So I think 1 and 3 are improper too. Not. Slide 58. I don't know what the basis for number 1 is. I suppose we'll have to see. these are Dr. Renschler's views. I don't know how they're relevant to the Commonwealth's case, but certainly I think he has the experience to make these conclusions, but it shouldn't be in a PowerPoint. He shouldn't be commenting on the reports of another expert in a PowerPoint, number 3. And number 4 is ultimately an opinion that he's self-endorsing. 66. Again, it is an opinion. I don't think it's an admissible opinion, and it shouldn't be in a slide. He's trying to draw a conclusion on what the jury should conclude based on the Commonwealth's evidence. He's not in a position to do that. 67. Parts of this are objectionable. I think that he certainly could testify. He hasn't seen any simulation by Dr. Welcher, but posturing it about in a manner that suggests there should be doubt in some way is inappropriate. 68, I don't think Dr. Welcher's report was introduced, and putting in a fraction of a report, I can't appreciate the significance of it. It's hearsay. Perhaps there's a reason he'll be able to point to the report or talk about the report. I understand that, but putting in a random page from a report is hearsay. Should not be admissible. I don't know if there's going to be a conversation about trying to introduce the entire report, but one page will take it out of context. 72. I think the expert has a basis for the opinion. I don't think ultimate opinion should be in PowerPoint because it's self-endorsing. 74, again, it's a conclusory opinion, it's bolstering. Some of these can be said but shouldn't be in PowerPoints. Same thing with 75 and 76. They're ultimate conclusions. And so I'm not in agreement with all of the conclusions that the expert may try to introduce, but testifying about an ultimate opinion and putting it on the board to self-endorse shouldn't be permitted. And those are my objections.
Okay. Ms. Little?
Thank you, Your Honor. First of all, there are, because if I stand here only because I would be able to reference the PowerPoint.
Yeah, that's fine.
Thank you, I appreciate that. First of all, there were no additions, just to be clear, to the PowerPoint. The only changes that we made were directly in response to the objections that were filed by the Commonwealth. We did delete a large section, try to accommodate some of their concerns, as well as shorten some of the opinions. So those were the only changes. I just wanted to make clear before there are no additional opinions that have been set forth in the PowerPoint. With regards to slides 9 through 27, that was not one of the issues that was identified in the Commonwealth's motion. They objected to slide 9. There's half of those slides are not referenced.
I do agree. It's a new objection. I just don't know when there's an objection raised how a biomechanical engineer is qualified to testify to tears and clothing.
So this is a direct test. His testimony is going to be based on his knowledge of forces and forces applied to certain objects and how that results in a use.
And I understand that, but some of the specifics that he says, I'm just saying I had a concern, so I understand it's new.
I think that we'll be able to satisfy the court's concerns by laying a proper foundation for him.
All right, so we can come back to the fabric argument or whether it's beyond his scope of expertise. But actually, Ms. Little, if I can just ask you, and I can hear you later, as I assume everybody wants lunch and we're coming back in at about quarter of at the latest. Can you just explain to me why these slides, if Dr. Renschler is permitted to express these opinions, why we also need them on slides? That's the problem I have.
I think that's a great question, Your Honor. And the reason we did these on slides is because we objected to Dr. Wilkins coming in on his PowerPoint.
So I looked at that yesterday.
Copy of the specific
So which one? Because I did look last night at that and did not see it.
It's slide 136, Your Honor. The totality of the evidence.
Hold on one second. Is it a conclusion page?
I don't know. I just
Hold on.
but it's page 136. It's entitled Evidence Reflexes Hypothermia. And it states the totality of the evidence is consistent with the right rear corner of the big 2021 Lexus impacting the and the zero key, striking the rear posterior aspect of his head on the frozen ground.
Okay.
So if he's allowed to do that,
So that is different than what I said he could be asked on his ultimate question, right? But it still came in? Was there, I'm sorry?
yes, that came in over the
All right. Because what I did note is that I was very careful to say exactly what the ultimate question could be from Mr. Brennan. In fact, there were objections. I sustained them twice, so I wrote out exactly what could be said, and Mr. Brennan asked a variation of the first one, and there was no objection. So I didn't remember that this came in. All right, so I will take a look at that. What I would like to do in the interest of time, so maybe we can talk about that in the conclusion page, but where he outlines everything else, there's so many pages with text that I may not have a problem with testimony regarding this, but why do we need testimony and text so much here?
This is to assist the jury.
It's what?
This is to assist the jury. There is a significant amount of information that needs to be relayed.
Okay.
This is an 80-page PowerPoint.
Okay.
This is solely to make sure that this goes efficiently and effectively. I think it's helpful for we've narrowed down the text on the slide significantly. It's important to see those PowerPoints.
Okay.
Just to the major issues. I think we've streamlined this a lot, but I think having the PowerPoint will allow us to make this go smoothly and quickly.
All right, so I will look at these. What I'll try and do is if there are any changes in the first 15, I'll try and get those done during lunch, and then we can have this argument afterwards.
Thank you, I appreciate that.
All right. All right, we'll see everybody no later than 4:45.
Hi, everyone. So you guys just heard Hank get up there and do that for that whole time. Okay, who wants to see this shirt again? God. Let's see AJ on my tits just for a just for a mid-afternoon pick me up. I swear, you guys, I don't understand. Here, hold on, I have to always get used to, okay, right there. Because it's the opposite on StreamYard when you're not used to it, like the way you move. I have to stand up. Such a tight squeeze. This isn't my normal setup. So it's obviously, you have to see the back, but I have no control. Here, look. I don't know what you guys can see. Can you see? It's a lot. Doing a whole bunch of stuff. I don't know, you guys. That irks me. He just got up there and literally went through each slide. Like he starts off like slide 9 through 27 and then literally like breaks everyone down. And sheesh. Yeah. He's a little cutie. And then Liza gets up. I want to make a comment about that though. We haven't seen this in a minute, but when the trial first was starting and we were in pre-motions and we were seeing a bunch of pre-motions, like before the trial began, Bev was so condescending towards AJ through Liza. So it's like she was the golden child in Bev's narrative and AJ is the scapegoat in like the narcissist scenario. And she was like overly sweet to Liza. Liza, what do you have to say? Miss Little, what do you have to say? And it was like to show that it was a way for her to basically gaslight and show that she wasn't, impartial to the defense, that she liked the defense. But, she was just not putting up with AJ's tactics. That's not true, Bev. You are licking boots bent over a bench. Yeah, you guys saw that. So going back to today, Dr. Laprasada just sealed everything up in a really nice, tight bow for the defense, for Karen Reed, for reasonable doubt, which is why we're here. And I think the jury sees it. And I think some people were commenting that they saw Turtle Boy tweet that the jury was taking her well, was smiling along with her, was finding her very relatable. And I think she's a pro. And she's the MVP 100 times over. I don't know, you guys, like this case is so done. It's done. And yet here we are. And Bev wants to talk about wasting the jury's time. Yeah, Bev, you are, because you should call a mistrial with prejudice and send everybody home. Free Karen Reed. I mean, who can look at this, objectively look at this case and say there's not reasonable doubt there? Who can do that? Anybody? Eminem. She's the MVP. I mean, okay. So they are talking, the defense did say that they are bringing Dr. Rentschler in, and he is going to talk about, he's one of the ARCA guys, if you guys didn't remember that from the first trial or weren't here for it. And Dr. Wolf on the stand kept referencing him and saying that, that's going to, Dr. Rentschler is going to clear that up, and that's what he's going to talk about. So I think there's like an expectation from the jury that we will be hearing from him. So I guess there is that kind of burden has been put on the defense, so they will put him on. I don't even know if they need to. At this point, it's about money also. There's decisions to be made. Every minute this goes on and on and on, you are spending more of Karen's money and resources and time. And these are not their only clients. She's not their only client. When I was talking to AJ, he made it very clear that his clients out in California are very starved for his attention. Can you imagine? Like, he's your attorney and he's just out in Boston this whole time. Like, you know, when he gets back, it's like balls to the wall. He has no other time. My comments aren't showing up on StreamYard. Give me a second. Let me grab my phone so I could see what you guys are saying. I don't know why StreamYard does that sometimes. Did it just stop? I don't know, maybe messages just did weird things. Yeah, so it would be about how much is this costing us and where are we getting? We're preserving the record. We've just dunked on these motherfuckers. We've just made our case. And I can't stress that enough, right? Here, let's look at AJ's pretty face. Again. I wish I could sit here like a normal person. Pull up, bitch. These people are so dirty. That's all I gotta say. Dirty. So yeah, so then obviously Hank's bringing his rebuttal witnesses, you know, Lana was saying earlier, and I have to agree. What are they going to be rebutting? What did the defense put on for some of these witnesses to even rebut? I welcome Welcher. I want to see him. I want to see him talk crap with his arm up on the podium. Like, I want to see him talk crap about Dr. Wolf and his actual scientific study, not to do with the color chart and primary colors, but actual things. Yeah, Smirky, I think that's what I saw too. I was just like, wait, did it stop on stream? But you're right, it did. So what do you guys think is going to, anyone have like anything to say about what these rebuttal witnesses are going, besides Welcher, that they're going to rebut to? What are they going to say? What can they say? And I know some motions have been put in. So hold on, let me just look and see. But she's Dr. La Prasada was very relatable. She explained everything like you're 5 years old, which is incredibly smart to do as an expert witness. You want to do that because you have to make it make sense to the jury. You're an expert in your field. Your vernacular and the terms you know and what you know is far beyond their area of expertise. That's why you're there. And you can tell she's a professional expert witness, and that's what you want. And her not getting rattled by Hank was like the best thing today. Her little snarky comments and her trying to hold back giggles when he was just annihilating medical terminology left and right. And she was trying to, I was wondering if he said basal cranial. He almost said that word wrong. But I mean, squishy bum. Oh, your little doggy's so cute. There's reasonable doubt with Rick Allen, and look where that got him. You can't trust the jury. We'll do the right thing. Yeah, I mean, that tainted a lot of things for me. But I have faith in this jury for some, like I got a second wind like 2 weeks ago. Like literally about this jury. I felt like you did. And 2 weeks ago I got a lot of hope. But what it comes down to, you guys, it doesn't even matter. It really doesn't, because there's so much misconduct and so much underhanded deception and just the manufacturing of evidence and trying to present it as trying to discredit an expert on the stand. You are in trouble. A mistrial, like I said before, is the lowest bar. Mistrial all day, every day. This is going to, if it goes left and Karen Reed is found guilty for some bizarre reason, you know, in the hands of jurors, you do not never know. We don't know what goes on in deliberation rooms. Not like there's a black box in there, right? But this is going to get overturned. This is so blatant and it's irreparable. It is literally irreparable. It's material to the case. What he tried to do, and that's like a career ender, what he was doing. So yeah, I can't, man. Like, it's over. I don't care. Like, I have that much faith, at least as of right now, I have that much faith in our judicial system higher up, because this is egregious to anybody who's ever, it's egregious to all of us as citizens of this country, and probably other people around the world feel the same way. But if you take the time and take that oath to be an attorney, and you take the bar, and you are governed by the American Bar Association professional rules of conduct, what happened in this courtroom is so disgustingly egregious that burn your cards right now, lawyers. If this doesn't go to an appeal, burn your cards. You're in the wrong profession, because it's never going to go anywhere. You're not there to get justice with people like this in the way. Okay, let me say, Shannon, do you think the jury understands fully what is going on? They can't talk to each other right now, can they? About the case, can they talk to each other about this case? I can't answer that, because I'm not fully aware of what the instructions were to this particular jury about speaking about the case prior to deliberations. Depends on each case and what the jury instructions are from the judge. But they have their notes that they're taking. And I think that what I've heard is they really resonated with Dr. Wolf. They didn't like when Hank was badgering him with, use whatever adjective you want there. But let's just be nice to Hank. And when Hank was questioning Dr. Wolf, they weren't appreciative of it. They were like wincing when he was being overly dumb. I'm trying not to cuss. And then what we heard today is they really resonated with Dr. La Prasada. And I think that they are sent, I think from those reactions and what I'm getting from people that are in that courtroom, that they're getting the gist, at least, and they don't seem to like Hank. I'm not saying every single one of them, but there's enough that are just like eye rolling him to death. And that's what we need. Yeah, William, I think they don't have respect for him. And at this point, I wouldn't either. Like, okay, so one of the objections, which we can't hear in the Commonwealth, like why they're objecting, but a really normal objection is cumulative, which means you keep asking the same question, but in like different ways, but it's literally the same question. And it's enough. Like, it's just ridiculous. And that is what Hank does. And even though there's not an objection that gets called out, that's got to be annoying when you're a jury member sitting there, like trying to get to what is the point, Hank? What are we doing? What is your point? What car dude came in today? If he talked to the defense. I mean, like, if Dr. Leprasada is a neurosurgeon, dude, she's a pathologist. You are asking questions. You're asking questions about living people and treating them. And she literally was holding back eye rolls and holding back giggles because she is a professional. And I can't, man. It is a lot. It is a lot. YBE. Let's see. 30 years for my, I got a mid comment. I didn't scroll up. Okay. I can scroll up and see if there's murky. What? I'm curious for more info about juror in seat number 1. Are they still not taking any notes and seeming like their mind is made up? Interesting. I didn't know that, murky. Listen. Okay. So being at the Delphi trial, no cameras allowed, you guys. Okay. So you have to rely on started out as 16 seats, for people, and ended up with 11 public seats that I was lucky to have one. Lana was lucky to have one. There were some jurors. Actually, let me tell you guys, the foreman of that jury, the foreman, he only took notes while I was there, only took notes twice. And he was the foreman. So it's interesting, but and obviously that jury was freaking rogue AF, right? But it makes me wonder, like, maybe their processing, I just give people a lot of grace, but like maybe their processing system is different than mine. Like maybe they don't need notes. I don't know. But that is weird if they just don't take notes. Like, why are you even there? Okay. YB. My great aunt got convicted of colluding to end life of her husband in the 1980s, even though he was ended by some dumb thug my great aunt didn't know and didn't want to happen. God. That's the scary thing too, is if you don't have the funds to, I'm not saying your great aunt didn't have the funds, but most of us just don't. I mean, I couldn't do what Karen Reed's doing. If you don't have the funds to fight the system and you end up with like a public defender who's just back scratching the state, you're screwed. You're literally screwed. What are you supposed to do? And that's not how our justice system is set up to work. And I keep saying this, but like, especially in Massachusetts, you guys, where our forefathers birthed this nation. And we need to get back to the roots of that. But that's just because I'm a constitutionalist. I'm a female Alan Watts. Yeah, thank you. That's what I do on my channel, but I just haven't been. I need to relax to my own voice. I'm kidding. Yeah, no, it's horrible. So my paid attorney, I had a paid attorney who's on retainer for my business. I was a really good client, but it's just known that what he would do is feed some of his clients to the state. And that was the system. He throws a couple of his clients to the state, lets them, get some charges on those clients, and then, helps like clients that are higher up in the ranks. And I don't know. Sometimes public depends on the public defender, though. There are some public defenders that are so good and they're so hungry and they are there and they haven't been tainted and they want to do the right thing and they put in the work and they really, really take their oath seriously. They have not been tainted. They aren't lazy. But even criminal defense attorneys you could pay for are like that sometimes. I'm on live. Let me see what I am on my phone. Oh. Yeah. I'm on all. Oh my God. Why don't we? You know what, you guys? Have you guys seen? I'm going to look at Lana's back end to her channel. So have you guys in chat, if you go to lives, have you guys seen like the crowns? So people that chat the most get a crown for the day. It's like you get like the top spot for being the best chatter. Yeah. We were hungry. We were hungry as a nation, but what our forefathers put in was right. It was righteous. And our country is literally built on really righteous rules, you guys. Like, seriously, if everyone just follows them, like, our Constitution is solid. It's very good. So was she convicted? Was it overturned? Oh, bless her heart. Oh, bless her heart. That's like a really difficult thing to go through. I mean, and especially when it's an emotional thing, like it's your husband, like, get the fuck out of here. When is court due, BM? When are they due back? I was walking in, so I missed what Bev said, but she was like, no later than. Does anybody know in chat? A quarter after? Chris Harder, I can never take what you say seriously because you're just Chris Harder. A quarter after. Are you on the West Coast, Chris Harder? On their time. Yeah. 1:45. Okay, so it's either okay, Murky says 2:45 East Coast time. Oh, Chino Hills in Cali. How you doing in Chino? You guys, seriously, I literally would be over this case. Yesterday, I just pitched everything. Like, I was so upset. And then this morning, you guys heard I was just cussing up a storm. Oh, Murky, okay, I'll put it up. She said 1:45. Okay, 1:45. Okay. Oh my God, are we talking about in 2 minutes? Oh my God, Lena's back. Hi. I do too. I appreciate a Chris Harder joke. Go harder, go home. I don't, Bev needs to adjust those beats. I'm just sticking with it, guys. I don't know. It's Bev's time. Noelle, no. What is the Canyon Corral? Oh, good. The corner kicks. She's talking soccer terms. Quarter up. Okay. Okay, you guys, where did I get this shirt? Okay, well, last year we went to the trial. And wait, StreamYard. And I just like had to have this freaking shirt. And then I sent it to AJ. I'm like, AJ, I'm wearing you to bed. And then everyone calls me a stan of a lawyer. I'm like, oh, F me, I am. Wait, here. I don't know what you guys can see because I can't see the camera. But yeah, it's a good shirt. So I was out there and I just got it out there. I love it. I love it. But so I don't know, you guys. If I can find the link, I'll send it to LO. And maybe she'll put an affiliate link in. You guys can get it. Maybe we should make our own merch. Put in I hate how StreamYard, I'm like so not used to StreamYard anymore. Put in ideas. I think AJ tucking his shirt into his really amazing pants today would be a really, really good, like image on this. Okay, got it. So what do you guys think about merch? While we wait. And it's going to be how many minutes now? Oh, we are on Bev time. It's literally like a minute to go. Okay. Yes, LO, you do. You have merch. Jalatina, hi. How are you? We miss you, girlie. Something's like tofu out there on Hanky. Something's like tofu. Yeah, so we are on Bev time. It's literally 1:45 out there on the East Coast, right? She did say that. Okay, I'll be back in a minute.
All right, let's all get geared up back in trial mode talk here. We can be expecting lots of fireworks to go off here after lunch break as Hank plans on trying to discredit the good doc here. That's what we can expect. You can expect a lot of objections from Alan Jackson. I cannot believe that Bev is going to let 25-year-old material come into the case when they couldn't even talk about Lank with stuff that happened in the past. So, again, discretion here. Judge's discretion, and good old Bev says that we can talk about 25-year-old office management, political bullshit. And he's going to try to say that she resigned because she did something wrong. And Alan Jackson said there at the end, this is not in good faith. This is not in good faith at all that you're bringing this into play. So. All right, try it again. Again, back here, Truth and Transparency. We're out here at the field checking out the ball fields. Soccer fields, ball fields. It's summertime. We can expect to wait, past 15 minutes for Bev. The jury got to leave out about 20 minutes earlier, so the jury's just been waiting. Nobody takes an hour and a half lunch break, but so.
You are unmuted.
Back to session, you may be seated.
All right, the jury is coming over. I just wanted to tell you what I was able to do during the lunch break. So, Mr. Brennan, you argued for 4 points of admission regarding this witness. I'll allow in 1 and 2. I've had a chance to look at 4. I think I already told you I would not allow in 3 because I've already considered it. I've now looked at the 4th one, the case. I'm not going to let you get into that during cross-examination. If the door is open and you think you can get into it after redirect, please come to sidebar.
Thank you.
All right, and also I had a chance to look at the actual exhibit regarding what came into evidence from Dr. Welcher and Ms. Little. Contrary to what you said and what Mr. Alessi was nodding to, page 136 did not come into evidence. It's a blank page. So that PowerPoint did not come in. I had a chance to look at Dr. Rentschler's PowerPoint, and at least for now, maybe you can persuade me otherwise, any text that has hearsay on it that you say will help assist the jury, what I want to say is I think we have to give the jury some credit here, okay? They have been listening to this case intently for weeks. I don't find that anything that you've recommended here comes in to assist the jury is necessary to assist the jury. So before Dr. Rentschler testifies, those slides that were objected to that have text are out.
Can I have a moment just to examine the Dr. Welcher PowerPoint?
No, not right now. You can look at it, yes. You can look at it while we're bringing the jury in.
Okay, because we have 4 copies of the PowerPoint, and I know that I'd like to be able to. 137 is the report.
Mr. Alessi, please. One 136, 137, and 138 are all blacked out. All right, the jurors on their way, right? Okay. Tori.
Please rise for the jury. Court is in session, please be seated.
All right, Mr. Brennan, whenever, I'm sorry.
Good afternoon, Dr. Lopez.
Good afternoon.
Am I on point now?
You are.
You were asked on direct examination about your qualifications. You were a medical examiner for the state of Rhode Island, is that fair to say?
Yes, I was the chief medical examiner.
For 20 years?
12 years.
I'm sorry, 12 years. When's the last time you worked as a medical examiner?
In 2005.
When's the last time that you conducted an autopsy?
I've done probably a handful of autopsies, private autopsies in my consulting practice.
Since 2005?
Correct.
When do you think the last time you did one is?
Maybe 4 years ago, 4 or 5 years ago.
4 or 5 years ago?
Yes.
Okay. Since you left the medical examiner's office, have you had any specialized training in brain injuries?
It's all part of keeping up with the medical literature and knowing the forensic pathology literature, reading medical literature. So it's a continuing endeavor to keep yourself educated with medical updates.
Since you left the medical examiner's office, have you had any specialized training in brain injuries?
I've not gone to a course on brain injuries.
Since you left the medical examiner's office, have you taught any students on brain injuries?
Yes,
Have you given any classes or seminars on brain injuries?
yes, I have.
And coup counter coup, how many times have you experienced that as a medical examiner, that condition?
Well, I myself haven't experienced it, which was good, but in cases, hundreds of cases, it's a common injury.
You said you did differential diagnosis. That is to exhaust any potential bias you have, correct?
Well, a differential diagnosis is to think, how many ways can you get this finding? And it does help prevent bias.
Did you say on direct examination, part of the benefit of differential diagnosis is to make sure that you don't have a bias?
Yes, yes.
In order to eliminate bias, you're supposed to look at all reasonable alternatives, correct?
Yes, that's part of it, making a differential diagnosis.
So you don't just look at a person's body, come to a conclusion, and ignore other evidence. That would kind of defeat the purpose of differential diagnosis, wouldn't it?
Well, you always have to look at all the evidence.
And so if you didn't look at all the evidence and you disregarded some of the evidence because you had already made up your mind, that really wouldn't be the proper study of differential diagnosis, would it?
Right, I don't do that.
I'm sorry, ma'am.
I don't do that. I always look at all the evidence.
And would you look at all the evidence even if it was contrary to whatever opinion you want to give in court?
Well, the evidence allows me to come to an opinion. So it's not like I decide on some opinion I want to give and then look for the evidence. The evidence is going to tell me what happened to the body.
So you would never say, like, I don't need to look at that evidence. If it's presented to you, you would look at it and study it and consider it in differential diagnosis?
Sure, it may or may not apply, but I'd look at it.
Because if you did that and said, well, I don't need to look at this, and it was relevant evidence, that would defeat the whole idea of differential diagnosis, correct?
Well, you always want to look at all the evidence that's going to help you decide what happened to the body.
If you were to ignore relevant evidence because you already made your mind up, that could create some type of bias, even if you're not recognizing it, correct?
Well, I don't make my mind up. I make it up on all the evidence I have. Then if something else other evidence comes up later, I have to reevaluate everything and consider that new evidence.
When you were talking about car collisions, I don't want to belabor the point, but you didn't major in physics, did you?
In what?
You didn't major in physics, did you?
No, I took physics, but no, didn't major in it.
Okay. And the last time you took physics was probably, what, undergrad?
Correct. Thank goodness.
You have no study in biomechanical engineering?
No, I'm not a biomechanical engineer.
Understood. You never taught courses in accident reconstruction, have you?
Only in terms of looking at the injuries on the body and showing how that they could or could not have occurred from impact with a motor vehicle.
Have you taught classes in accident reconstruction?
Only as far as it would affect the findings on the body.
Do you know what I mean by when I say accident reconstruction?
Well, accident reconstruction meaning, and I'm telling you that my expertise in accident reconstruction is restricted to looking at the body and then understanding how impacts may or may not have occurred to the body. I don't take a car and look at mileage and such like that.
You don't do any studies of the actual vehicles, you're focused on the body?
I'm focused on the body, but I also look at the vehicles to look at the points of impact that might be possible.
You do not have any advanced study in biomechanics, do you?
No.
Okay. Now, you had mentioned that when you were in the medical examiner's office, you had a number of higher profile cases.
Well, every case is important because somebody's dead.
You pointed out some pretty specific ones on direct examination. Were those more important, the ones that were highlighted, or is that the same as every other case?
I don't know what you're talking about.
Well, you had mentioned the Egypt airline crash, station nightclub fire. Those were highlighted or pronounced on direct examination. Are they equally important as every other case?
Oh, absolutely. Every person is my patient.
You talked about some of your commendations. The station nightclub fire, You received quite a bit of criticism on that, didn't you?
Well, there was a flurry of negative press without any basis.
You had mentioned that a doctor, a medical examiner, should have gone out to the scene to look at the area where John O'Keefe was found to make observations. Did you suggest that in any way on direct examination?
You have to know what the scene looks like, and usually that is documented in police reports and in police photographs who document the scene.
The Station nightclub fire, that had numerous victims, didn't it?
Yes, 100.
And you received criticism because you were repeatedly requested by emergency responders and police officials to come to the scene, and you refused?
That's incorrect. First of
Okay.
all, nobody called me to come to the scene, and medical examiners are not first responders. As soon as I got a call that there was that fire in the nightclub, my investigator went right to the scene, and I was in constant communication with him throughout the early morning hours of that horrible accident. And I went into the medical examiner's office because I had to start getting ready to run our office 24 hours a day to not only take care of the poor individuals who expired in the nightclub fire, but also the regular work of the medical examiners. So there was no need for me to go to the scene because I had my investigator there, and my job would be at the office to get things all set up to handle the influx of deceased.
Did you receive criticism that over 17 hours there was an effort to have you come to the scene, but you refused?
There was,
I'm going to allow it in a different form.
yeah, that's incorrect.
Hold on, Dr.
Oh, I'm sorry.
Oh, no, I didn't mean to scare you. Just
Oh. Okay.
Hold on for a second.
Okay.
Asking differently, Mr. Brennan, please.
Did you receive criticism that officials?
I'm going to allow it based on the ending, pursuant to the ending. Let's hear it.
Did you receive criticism that for over 17 hours officials were asking you to come to the scene and you refused?
It was untrue. It was printed in the newspaper. We looked up all the phone records and provided it to the newspapers and showed that nobody called me to go. I would have gone if I needed to. I had my investigator there. It was just bullshit. No, it was erroneous stuff.
Was there other criticisms in 2005 before you left the office?
No, there was a flurry of stuff in the papers. There were union issues, new director of health, new governor. So yeah, there was a little flurry of stuff, which was not substantive.
So you inevitably did resign in 2005.
Yes, because my budget was going to be cut, and I knew that if I had to get rid of a medical examiner, we couldn't do a good job for the state, and I'd done it. I'd been chief for 12 years. I'd been on call 24 hours a day for 12 years, which was an honor, really. But then if I couldn't do a good job, if we cut the budget, I had to get rid of a medical examiner. I couldn't serve the people of Rhode Island well, so I resigned.
Did you resign shortly after the audits and criticism?
No.
Same year?
Oh, I don't even remember.
Okay. After you resigned, you opened your own company?
Yes, I started an independent consulting practice.
How much of your business is consulting?
It's a consulting practice.
Yep. How much of your business, how much of your income is consulting?
100%. It's consulting.
Do you consult in both criminal and civil cases?
Yes, I do.
What percentage of cases are criminal cases?
It's maybe half and half.
Half criminal, half civil?
I don't keep track of it in that way, but that would be a guess.
I'm sorry, I'm sorry, I didn't hear you.
I don't keep track of numbers of civil or criminal cases that I'm consulted in. If I had to give an estimate, it would be half and half. I've worked on over 1,000 cases in my private company.
And fair to say you get compensated for your time?
Yes, I get paid for my time.
Dr. LaPosada, you had mentioned that there were some scratches that you had taken a look at on Mr. O'Keefe's body. If we could have Exhibit 165, please. Now, would it be fair to say, Dr. LaPosada, you do not know the genesis of that cut on Mr. O'Keefe's right eye?
I do not know what caused it. I can tell you what didn't cause it, but I don't know what did cause it.
You said that was from blunt force?
It's from application of blunt force to that little area that broke the skin.
When you were asked a question about whether that was consistent with a punch, you opined that it was consistent with a punch, yes?
It could be consistent with a punch.
You weren't saying it was consistent with a punch to a reasonable degree of medical certainty, were you?
That would be within my differential diagnosis.
It could be consistent with all other types of blunt impact, or many other types of blunt impact, couldn't it?
That's correct.
Ground, perhaps?
No.
No, an object?
If it was an object that could get into that area under the eyebrow, yes.
You mentioned the spoiler on the back of Miss Reed's Lexus. Do you remember that?
I remember that.
Do you know how tall John O'Keefe was?
He's around 7 foot, 5'11", I think, 7'2", something around in there.
No, he's more closer to 6'1". Does that make sense?
Sure.
Okay. And that spoiler on the Lexus, do you know how high off the ground that is?
No.
Did you ever try to measure it or ask for photos or any information about that?
I looked at the photos.
Did you ever ask for any measurements or try to take any measurements?
No.
Could I have Exhibit 166, please? Did you see this cut on Mr. O'Keefe's nose?
That's a scratch. It's not made by a sharp instrument. It's not a cut. It's a scratch.
Is there any scratches on the left side? Do we have a photo of the left side? Please. And that, you say that's a scratch, not a cut?
Correct, because a cut means it's made by a sharp thing, like a knife, and a scratch is made by something that's kind of rounded that has a little point on it, but it's not sharp.
Okay. Do you have any information or basis to say where that scratch came from?
No.
Did you do any differential diagnosis on that scratch?
I don't know what caused that. There could be a number of things that caused it.
There was no scratch on the right side of Mr. O'Keefe's nose?
I don't see it one, no.
Could you zoom in, Ms. Gilman? So the only scratch was on the left side?
Looks to be, well, that's not a good photograph because there's some blood obscuring the skin.
Yes.
If my memory serves me, there is a scratch on the left side of the nose and maybe a small scrape on the tip of the nose.
And we can go back to the left side? And you said that could not have been caused by a sharp object?
Correct. It's not an incised wound. Incised wound means a bladed sharp cut. This is a scratch, not made by a blade.
Were you aware the defendant made a statement that she pulled a piece of glass from the defendant's nose?
No.
And you would say that that wound is inconsistent with being caused by glass or a sharp object?
It would not be caused by a blade. It could be caused by a piece of glass that was thick.
I thought before I offered you that statement, you had said that it could not have been caused by glass. Do you now have a different opinion?
I don't remember saying it couldn't have been caused by glass.
Didn't you say it couldn't have been caused by glass or a sharp object?
A sharp object.
Like
a sharp object, like it's not an incised wound made by a blade. It could be caused by something sharper that's thicker, but does not have a thin blade. So it could be caused by a thicker piece of glass.
If somebody is deceased, does any blood pressure from their heart still move in their body?
No, they're dead.
If somebody removed a sharp object like glass from somebody's face, would they spurt blood if they've died?
If you're dead, there's no blood pressure. So if you're dead and you remove something, there may be some superficial blood, but it's not going to have blood flow because your heart's not pumping blood out of the cut ends of the blood vessels.
So it's not going to spurt if you pull something out of a person's skin if they've passed?
You wouldn't get a spurt of blood from arterial pressure.
I just want to ask you a very few questions about hypothermia.
Sure.
You mentioned that Mr. O'Keefe's body temperature at the hospital was 80 degrees,
Yes.
and there's different ways to take somebody's or body's temperature, isn't there?
Yeah, that was a rectal temperature, so that's a good representation of the body temperature.
Is the variance between a common practice of taking temperature and by somebody's mouth and rectal, is it about a 3 or 4 degrees difference, or do you have a different experience?
It can be different. A rectal temperature gives you a better internal body temperature. The oral temperature, if you're breathing in or if you just had something cold in your mouth, may not register a proper temperature. So the rectal temperature is the preferred temperature to for a medical diagnosis.
98.6 is an important temperature, isn't it?
Yeah, it's our usual normal body temperature.
And so, is there a standard? Is 95 degrees considered hypothermic?
If you have, then clinically you would start to worry that the person might be experiencing bad effects of hypothermia.
At 95 degrees?
At 95, you start to worry about it.
And could some of the things that happen is labored breathing?
Is what?
Labored breathing?
What about labored breathing?
Well, if someone is hypothermic, if they're 95 degrees, does it affect their breathing patterns?
Not especially.
Okay. Does it affect the way their respiratory system works?
No.
Does it have any effects on the human body if you're hypothermic at 95 degrees?
No. You're still okay.
If that temperature continues to decline, it starts to become dangerous, doesn't it?
It can.
Mr. O'Keefe was evaluated, and at the hospital, his body temperature from a rectal reading was 80 degrees at about, what, 6:37?
Correct.
Did you know that before he got to the hospital, first responders had him in an ambulance?
Of course.
Did you know they turned the heat up and put blankets on him and tried to provide warmth to him before he got to the hospital?
Yes, that would be standard practice.
And that standard practice would usually add temperature to the person, wouldn't it?
Well, it might.
Okay. So it's possible it could, but it might not.
It usually doesn't add that much.
I see. And so inevitably, at 6:37, Mr. O'Keefe's body was 80 degrees?
Yes, when he got to the hospital, his rectal temperature was 80 degrees.
And so that is a drop from the standard, or what's expected, of 98.6 degrees. That's a drop of at least 18.6 degrees?
Yes.
You mentioned that Mr. O'Keefe, after suffering his head injury, would not have moved other than twitching.
Correct. No purposeful movement.
Were you aware that he had an iPhone with healthcare data on it?
No.
If there's no movement, assume for a second there's no movement of Mr. O'Keefe after 12:32:16, and he's found a little after 6 a.m. in the morning. That's about 5 hours, or 5.5 hours, correct?
About.
And if somebody is in the cold for 5.5 hours, that's consistent with dropping from 98.6 degrees to 80 degrees in body temperature, isn't it?
If the person is dead, yes.
If a person is outside in the cold and still alive, will their body temperature decrease?
If they can, people can die of hypothermia, but that's not the case here.
Well, not the ultimate death, but if somebody's outside and they're alive and they're lying in the snow and it's below freezing, will they lose body temperature?
They will, especially if they're not bundled up well.
And body temperature can drop from 2.5 to 4 degrees an hour?
In a dead body.
Okay. In a living person, it can drop 1.5 degrees.
No. A dead body at room temperature will usually lose body temperature at like 1.5 degrees an hour. If a dead body is in a cold environment covered with snow and avalanche environments, the dead body can cool at 4 degrees per hour.
And so a person who is in cold conditions, starting to be covered by snow, less than freezing, they can lose body temperature when they're living, can't they?
If you're sure, you can. People die of hypothermia, but that's not the case here.
Well, someone could be alive, lose body temperature, and not die. That can happen, can't it?
Yeah.
Right. So if someone is in the cold, let's assume they're not dead for a second. They're in the snow, below freezing, not moving. Can that person lose body temperature if they're still alive?
Sure. They just lie there. They can become hypothermic and die.
Even before they become hypothermic, can they lose body temperature?
Well, losing body temperature makes you hypothermic. Thermic is temperature and hypo means below. So your temperature goes down and you're hypothermic because it's going down.
And people can survive from being hypothermic if they get the right care.
Sure.
And so in that 5.5 hours, it is consistent with a person being outside in the cold and starting at 98.6 and ending at 80. That's consistent with being in the cold for 5.5 hours, isn't it?
For a dead body, yes. That's how a dead body would cool in a snow-covered cold environment.
And it could also be consistent with somebody who is alive for some time and then dies, correct?
I don't understand your question.
Somebody could be out in the cold, under the snow, sub-freezing. They could be alive for some time. Their body temperature could drop. And then when they pass and die, their body temperature could continue to drop probably at a more rapid pace. That still fits within
No.
5.5 hours, doesn't it, Dr. Laposada?
No.
Oh. Because if someone can drop 4 degrees of body temperature in an hour,
A dead body.
yes, it would only take about a little over 4 hours if it was at 4 degrees to go from 98.6 to 80. Yes?
Correct, yes. So he was exposed to that cold environment for 4 to 5 hours.
If somebody was alive for a couple of hours, it's a lower rate, say they lose 3 degrees, and then after that couple hours, they lose body temperature at 4 degrees, that would still fit and be consistent with a drop from 98.6 to 30 degrees,
No.
to 80 degrees, wouldn't it?
No, you were saying a dead body cools in a cold environment at maybe 3 to 4 degrees an hour. And that has nothing to do with a living body and how long they can stay at a body temperature.
Do you disagree that somebody could be alive, lose body temperature, out in the cold, freezing temperature below 32, they could lose body temperature at a certain rate, then pass, die, and then continue to lose body temperature? Is that possible?
Anything's possible. It's just what's important is what happened in this case.
I'm asking for your medical opinion, though, rather than to be an advocate. As far as your medical opinion,
So sustained, and I'll strike that.
as far as
Dr.
your,
Laposada,
Yes.
could you listen to the question, please?
Of course, thank you, Your Honor.
as far as your medical experience, could somebody be alive, outside, in the cold, below 32 degrees, not moving, covered by snow, still alive, and lose body temperature?
Sure.
And then could they, after an hour, 2 hours, could they then die and continue to lose more body temperature?
Sure.
You mentioned your opinion about injury on Mr. O'Keefe. And at one point, you said that his injury was inconsistent with a taillight, and you said because there was no damage from the bumper. Do you remember saying that?
I don't think I said it quite that way.
Okay. Do you remember how you said it?
No.
Do you remember discussing or raising the issue of a bumper as part of your equation, that the injury to Mr. O'Keefe was inconsistent with the injuries?
He has no injuries on him that are consistent with being hit by the back of the SUV. That includes the spoiler, that includes the bumper.
Okay, if we could play video E, please. I want to ask you, Dr. Laposada, have you seen this video before?
No.
Thank you. You can take that down. Did you see anything in that video that would suggest any contact between that mannequin and the vehicle's bumper?
Objection.
I'm going to see you at sidebar on this for just a minute, please.
All right, I'm going to see you at sidebar too.
That was highly inappropriate, in my opinion.
Yeah. Yes. I thought it was highly inappropriate that she said, "Will you answer the question?" Oh, what? She's answering the question. Like prior to that. There has not been anybody that has testified to a collision. Like that.
Well,
there has not been anybody that there has not been anybody that testified to a collision. Okay. Well, oh wait. Oh my God.
I mean, Welcher, he kind of did a 2-hour pussy test. I don't want to hit myself with a car going 29 miles an hour. That's not scientific, honey. Out. But you can't show this video.
Okay, so let me take that back. He's not a medical professional. He's not. The injuries aren't consistent with anybody. Like no broken anything. Like, so is it Hank's theory now that John O'Keefe was blasted by the spoiler on the top of the Lexus in conjunction with getting scraped on the arm, and now he's going to try to say have Dr. Welcher come through and talk about that this sweatshirt could have possibly been in different positions and rolled up? And I mean, what? I just. Bev's allowing this kangaroo court. Bev's allowing all of this.
You call it a kangaroo court, and I'll call it a Dominican donkey show. It's disgusting. She has to control that courtroom. She's the one that controls it, and she's not doing that.
The ridge, you guys, if the ridge is causing the crack in back of John's head, okay, how does that take into account what you just said earlier about the hat. Well, did you take into account like his hat? Well, wouldn't that be like, I mean, the same thing with anything. If you think that John fell backwards, but he didn't have his hat on. If he fell backwards, like by getting sideswiped, what, he lost his hat, right? Or what? He had his hat on, it still caused the damage from the ground.
He's throwing spaghetti at the walls and seeing what sticks. He's just throwing everything out there because this
Yeah,
witness
because Bev is
intimidates
letting this happen.
100%, 100%.
Like you're contradicting yourself. Like that's what I don't get, why this wouldn't be allowed. Or are you just allowed to look like a fool? Because these jurors have to be saying to themselves, well, isn't Hank now contradicting his own shit?
I think the jury is eye-rolling this. I think they resonate with this witness and they don't appreciate that Hank's trying to be slick. But absolutely, that he is trying. I do believe what you said earlier about the spoiler. I think that is kind of what Hank is trying to imply with his line of questioning.
Well,
and
all right, so jurors, I am going to strike the last bit of questioning of this witness and the video as it goes to this witness.
Okay. So he just lost.
Dr. LaPosada, after you received materials, did you ever ask for any additional materials?
Let's see, I always make sure I have all the scene investigation, autopsy, medical records, police and witness investigation and witness statements. So I felt I had a pretty complete database. I didn't get the x-rays until a couple weeks ago, so that was delayed.
That was newer?
Yes.
You said a medical examiner has to make a determination in 90 days. Is that the rule?
When you work at a medical examiner's office, when you get a deceased in, our national standards want us to have the autopsy report completed and all the associated tests done within 90 days.
Can investigations occur and the additional accumulation of evidence happen after that 90 days?
Oh, sure.
Okay. Thank you, Dr. LaPosada.
No more questions? Dude, use your time wisely here, man. Dude, what? Like, I think there's barely any rehabilitating here.
Dr.
Okay,
LaPosada.
hold on.
What, he's not done?
Jurors, when I strike something, that means disregard it. And what I've struck through this witness, the video that you just saw and some of the testimony means that if it's in evidence, it's in evidence, but it is not part of your consideration with this witness. Okay.
Jesus, Bev.
Right,
what a
go
man.
ahead, Mr. Jackson.
May I proceed? Thank you. Dr. LaPosada, you were just asked a series of questions about body cooling, correct?
Yes.
Does a body, as it's cooling, does it know if it's indoors or outdoors?
No.
If there's a very cold environment, be it indoor or outdoor environment, would it still cool?
Oh, absolutely.
And it would it cool at the rates that you earlier described?
Yes.
Great job.
Even if that indoors was cold?
Absolutely.
Your Honor, may we approach along with the Commonwealth very briefly?
Dude, I think Bev's middle name needs to be Sloppy. You know what? That's just the best way, I think, to describe Bev here. She's just sloppy. Like, nothing is crisp. Like, she's just... everything's just sloppy. Like, to be able to explain to the jurors, like, okay, the question about this, like, she's just so sloppy. And so, she's the definition of do you want to go and get a burger from Five Guys, or Bev prefers, the thrown together rally slop fest? She's the fast food version of getting a steak. Then you can go to like Jeff Ruby's. She's a mess.
I like that analogy. Sloppy and mess.
Yeah, she's just, it's just so sloppy. Like it's when you said earlier, you made a good point how the jury considers her like, hey, you feed us, you give us treats, you give us heartbreaks, blah blah blah. We take, high regard on how you are. She lost that respect though from this jury, in my opinion, a long time ago, because they're just feeding off of your energy, Bev. Your energy is that you don't even want to be here. So then, like, it's like a parent teaching like their kid. You are your kid's energy. You are how they behave as a reflection of you. And this jury has to. I think that they lost respect for Bev. That's what I see.
I hope you're right, but I just think humans are more simple than that, and psychology is just more potent in our chemistry. But yeah, I mean,
well, if these people have ever been in an organized atmosphere before, they have to look at this as this is just so disorganized. This is so, just even when she gives us like direction on something, it's just so like disorganized, sloppy. She's a slop tart. She's
yeah. I didn't want to say slop tart because that's, but yep. She's the tofu steak. She's the ew tofu.
I think Alan Jackson just made a great point, though. Regardless, when the body, someone's dies, whether they die outside or inside, your body starts to cool. Your body starts to cool, so you're going to go automatically down. Doesn't matter inside or outside. And that what that does is that takes away for the juries if they're considering that. Oh, the only way that the body started going down is because his body was outside.
Right.
No, your body, if you die and you're in a house, your body will start to cool because you aren't pumping, you're dead.
Yeah.
And so that was a great question there, I think, for anybody that's considering in the deliberating room when you're going to be arguing with each other, is to say, wait a second, no. There is more than just you're outside as to why your body is cold. You could have died already and wherever you're at and you're cooling. So hopefully people,
Yeah, it takes the doubt out of it that like you had to be lying outside in the snow in order to lose that much body temperature in that amount of time. So a rectal temperature at 6 a.m. of 80 degrees. Yeah.
Mm-hmm. And I don't think it's going to hit hard with the jury saying, oh, do you remember how Karen said that when she pulled out that piece of glass that it was a gush of blood? And I don't think she said that it was squirting at her. It was built up right there. So when you go to pull it out, like anything, I don't know, if I take that out, whatever's right behind it,
the pressure.
That it's just going to like, not guzz out, like come at you. But regardless, Karen should have never been doing those interviews. And I'm sorry, but I would give zero weight to anything that Carrie, Karen, or Gemma Cabe, because I would take them as, dude, they are in shock. Okay. And then we're going to try to ask them to remember when they were in shock, what happened. That's what I would be saying in the deliberating room. I'd be saying, throw out Jen's statements, throw out Carrie's statements, and throw out Karen's statements. I'd be arguing to say, if you're going to throw out one of those broads, you need to throw all of them out. Or if you're going to keep, because you're considering the same playing field for all.
For me, this is like playing in Texas Hold'em at a poker tournament, and the rivers come, and now the flop is whatever it is, and then the river, the turn, and then the river. I'm going to be like, this is my ace in the hole, and now I have a straight flush with her, and I don't care about anyone else's cards. Like, none of that Karen stuff matters to me. What she just said, she is the ultimate expert on what caused, like, his cause of death. She knows everything about body temperature, about everything that's going on biomechanically inside of a human body when they die and how they are presented and all of that. And she makes it make sense. And she's really relatable. So I don't care what the flop had and what that person had and that person
So
had.
basically, Hank Brennan has been bluffing this whole time, and now the river came.
Yeah.
Boom, boom. Hank Brennan came with the bluff. AJ just flopped the nuts, and then came with the river.
It hit on the river. She was the ace in the hole for the river for the straight flush, and everything else can just get disregarded because that's the winning hand. So I don't care if I'm in the waiting room. I'm gonna just bank on her, throw anything else that contradicts her out.
Yeah, and then you have Russell backing up, like, and I think they're allowed to take their common sense as well to say, hey, raise your hands. My question would be, raise your hands if you think that that's a dog bite, or raise your hand if you think that it reasonably could be a dog bite. If everybody in this room raises their hand to either they think it is or that it reasonably could be, if every single one of us raise our hand in that room, then I think the next, all you have to say is, I think we answered our question.
Right.
It's not guilty, reasonable doubt.
Reasonable doubt. If there's one element of reasonable, just one element of reasonable doubt, she is, by the definition of reasonable doubt, found not guilty. So done. We are done. And I don't see how anyone else sees it another way. And even if I have bias, I still can look at it the other way, like anyone else's way. And I just don't get it.
Yeah, and I was trying to that's how I was looking at the phone data too. I said it, I was like, you guys, when the defense gets the case, they need to explain why this phone would just abruptly end when it would seem like, okay, Karen's leaving, John's phone never moves again, and then begins her, text messaging at 12:33 to explain that, well, I think Alan Jackson is going to put it all on a bow, and to say that John walked in, and this was instant in terms of going into the garage, the dog jumping up, forcing John to go back, and he then hit his head on the ridge of the step, because until this trial, we didn't know there was actually two little steps that go down into the garage.
Yeah. I take her word. I take Dr. Laprasada's word over any other witness and everything she has to say. I mean, she is stacked. Her CV is stacked. How she just handled herself on cross, which is where you get to the truth, where, like, the core of truth, and that's like the definition of a cross-examination. She just handled herself like a champ. She he couldn't land a punch.
Like, I think she's sound in her, like, she also knows this case. Like, she hasn't needed to look at anything. Like, can I refer to my report? Can I refer to this, refer to that? Like, she's just
one confident bitch.
Well, yeah, like, it's almost like when you look at this at the window, is the sky blue or is it gray today? I mean, what is it? It's blue. Sky is blue today. With this case, yeah, you can ask me about, could this happen? Could this happen? Sure, yep, 100%. But with this case, no, I can eliminate those. Oh, how did you do that? Well, how about for one, there's no bruises, no broken bones. And that's what AJ was hitting on all, the beginning parts of his direct.
Art of War.
Yes.
Thank you. Dr. Laprasada, stand back here for a quick second. Before I sat down the last time, I asked you a little bit about x-rays.
Yes.
And the effect of x-rays on an evaluation by a forensic pathologist. Do you remember that?
Yes.
Are x-rays important for a forensic pathologist to consider?
Yes, they are.
Did you find any, you reviewed the x-rays, correct?
Absolutely.
I'm going to relegate my question to just the right arm of John O'Keefe.
Yes.
Did you find any deformities, defects, breaks, fractures, or hairline fractures of that kind on any of the x-rays that you reviewed?
None.
May I approach you?
Yes, I have a question for you. When you printed these, did you print them from a flash drive?
May I have one look at it?
Sure.
I have some assistance with this.
Do you have them up on the,
We do have electronic versions of this.
why don't we do that instead of the big, the large?
As long as I can mark the large ones, I want those marked and moved into evidence for reasons that we discussed at sidebar.
So those will be, and if you're objecting to this, Mr. Mayor? Okay, well, even if the Commonwealth objected, I'll allow those in, but I'd prefer to give the jury a flash drive with these on them instead of these big. So we will mark
The jury's
the flash
sitting
drive,
there.
and you can just go ahead, do it in evidence. We'll mark the flash drive. The flash drive will go in with the jury rather than these very cumbersome additional pieces of paper. And you can go ahead and show them.
I don't want to hold discussion open in court. If it
All right, jurors, we're going to make this one really quick.
I cannot freaking believe she just did that. I cannot believe she did that in front of the jury. That is so improper. I can't with her decorum. I can't with her kangaroo court lately. And I can't. How did that just?
So I went back. She doesn't give a shit. That's just what it comes down to. So I went back to Jen McCabe's digital data really quick. So check this out.
You tell us.
Now, based on, let's say that he walked up to the house and instead of going into the front door or what would have been the second side door, he opens up the garage door, okay? Well, if we go and take a look at her steps, okay. She gets out of the car at 12:18 and 50 seconds.
Yes.
Oh, God.
Thank you so much. Sorry. I'm going to show these to you and then I'll put them on an overhead. May I approach, Your Honor?
Yes.
Do you recognize this document?
Yes, I do.
How do you recognize it?
I recognize it by the medical examiner identification of Mr. O'Keefe, and I recognize the x-ray of the right hand, the right wrist, the right femur, and I can also tell by the R designation here that that's the right side of the body.
Is this what you reviewed in coming to your opinions and conclusions concerning injuries to his right hand?
Yes.
Thank you.
So these now will mark whatever the next exhibit in A, B, and C.
A, B, and C, yes, Your Honor.
H is now 229A.
May I approach, Your Honor?
Yes.
I'm sorry, I need to wait. May I approach?
Yes.
Doctor, if you would assist me,
Sure.
do you recognize this document?
Yes, this is a x-ray of the body of Mr. O'Keefe from the medical examiner's office. The R indicates the right side, and we see here the two bones of the arm. There's no injury to them. We see the pelvis bone. There's no injury to that bone. They're perfectly normal, and there's no abnormal soft tissue swelling. It's a normal right arm.
Thank you. I mean, is this marked as next in order?
That may obviate the need to put it up, right?
It could.
The 229B.
May I?
Yes.
Thank you. Doctor, do you recognize this document?
Yes, this is another x-ray at the medical examiner's office of Mr. O'Keefe. And again, it shows the right side. We see some of the ribs there. We see the shoulder and the humerus, the upper arm bone. And the upper arm bone is totally normal. There's no soft tissue swelling around it. There's no breakage or microfractures.
Thank you, doctor. With the court's permission, next in order, sub C is in Charlie.
Yes.
C.
Dr. Laposada, that's all I have for you. Thank you for coming.
Anything, Mr. Brennan?
No, thank you.
All right, Dr. Laposada, you are all set.
Thank you, Your Honor.
That was condescending as fuck.
All right, is there anything else today?
Yes. What do you mean, is there anything else today? Come on.
Your Honor, may we approach?
Okay, jurors, feel free to stand up and stretch.
Lana, tell
Okay,
us.
so this is what I'm thinking that they have here is obviously they still have 1 hour and 10 minutes until 4. Okay. And so, I personally think that they're going with Derek Ellington next, but, I don't know why she's over here thinking about, like, is there anything else today? Like, what that means they must have talked about something in terms of that we're just going to have him start on Wednesday. Okay. Meaning Welcher, I guess, because they both talked about how long it was going to take. I'm going to last like 3 hours. And let's see. Okay.
With court's permission, I would ask the court to invite Dr. Andrew Richard to join us.
Okay.
Oh, wow. They're going with Dr. Wenchler.
They said they were going
Okay.
to.
This is who they're ending with?
Yes,
There's
that's
no
what we're
way.
talking about on lunch break, that this is who they're ending with. Yeah. Most likely, yes.
They just put in a report for Derek Ellington. There's no way.
Well, maybe he'll be coming out. Let's see. But remember, Bev wants everyone to stick to schedule because the jury's time.
Sir, I need you to step up, face the clerk, and raise your right hand, please.
You solemnly swear that you ever give the court and jury in the case down hearings for the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Good afternoon.
No, Your Honor. It's fine. It's fine. Feels good.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Sir, could you please, pull that to you. You're a little on the tall side. Pull that to you right up under your chin if you can. And in a nice, clear voice, tell the jurors your name and spell your last name for us, please.
Dr. Andrew John Rentschler, R-E-N-T-S-C-H-L-E-R.
Sir, what do you do for a living?
I'm a biomechanist, a biomechanical engineer, and an accident reconstructionist.
Where do you work?
I work for a company called ARCA LLC.
Tell us a little bit about ARCA. What is ARCA?
ARCA is an engineering consulting firm. So we do litigation type work, both civil and criminal, where we look at, for instance, I do biomechanics. So I look at injury causation in different types of events, motor vehicle accidents, pedestrian, automobile incidents, sports related injuries, industrial accidents. We also do accident reconstruction, as well as all types of really forensic type engineering. And we also do R&D, research and development, for private and governmental entities.
What's your current title?
I'm a vice president and director of biomechanics for the Midwest Division.
The director position that you hold, that's the official position at ARCA?
That's correct, yes, sir.
How are you ARCA's senior biomechanist?
I'm one of them, yes.
And how long have you held the position of director of biomechanics and human factors?
It's been at least 5 years. I don't recall exactly how long.
What exactly does is it biomechanist or biomechanist?
Biomechanist, yeah.
All right, I'll get it right by the time we're finished. What is a biomechanist? What do you do?
So a biomechanist really looks at the human body, and we look at the response of the human body to forces and accelerations. We apply traditional engineering, but to the human body. So a mechanical engineer, for instance, might look at a piece of steel, and you know the dimensions and size of the steel. If you apply a force in a certain direction with a certain magnitude, that steel will bend and eventually it'll break. Was a biomechanist or biomechanical engineer, I do the same thing, but I look at the human body. How much force has to be applied in what direction to get a specific type of injury, whether it's a fracture of your humerus, a concussion, intervertebral disc injury. Any type of injury has what we call an injury mechanism. So we look at the response of how the body reacts to forces in different environments. Ultimately, our hope is to actually help prevent and mitigate accidents. You know, motor vehicle incidents, we look at the design of airbags and seatbelts, sporting equipment, how can we reduce concussions and injuries associated with that. So ultimately, we try to figure out how to make the environment and the world safer for people in whatever type of interaction you might have.
Is that sometimes called injury causation analysis?
It is. That's one aspect of it. Injury causation analysis is looking at how an injury occurs. So if someone sustains an injury, as a biomechanist, I can look at the events surrounding that incident and determine how the injury occurred. Now, how someone was positioned, how much force had to have been applied to certain parts of their body to actually produce a given injury.
Why is injury causation analysis important in the broader field of biomechanics? Why do you want to know the causation of certain injuries?
Well, like I just said, our main goal and interest is to really mitigate and prevent injuries from occurring. So in order to do that, you have to know how they occur. You have to know, for instance, hockey, we do a lot of work with the NHL, how certain injuries occur, cervical injuries, concussions, shoulder injuries. So if your intent is to prevent injuries in certain settings and situations, you have to study how the body reacts, how those injuries are created, and then you can determine or attempt to determine how to prevent them from occurring in different events and situations.
What sort of contracts or commissions does ARCA routinely engage in?
You know, we have a number of different contracts. We've worked in the past with the United States military. I helped design what we call the energy absorbing seat for the MRAP vehicles.
Hold on 1 second, Dr.
Sure.
Okay.
For the MRAP, which are the mine-resistant, ambush-protected, armor-plated vehicles that they had over in Iraq and Afghanistan. And the issue there is that when they go over an IED, an improvised explosive device, it would blow the vehicle up off the ground. So we were seeing very severe accelerations and forces going through the vehicle, through the seat, into the soldiers' spines. And we're seeing severe spinal and head injuries as a result of that. So we worked with the military to design what we call an energy absorbing seat design. As the vehicle gets blasted up off the ground, the seat's designed to absorb that energy and that force from the blast and the movement of the vehicle and help protect the soldier's spine. We also, as I said, do a lot of work with the NHL. We work with the Department of Player Safety there, the National Hockey League. We look at the equipment, we look at helmets, trying to help prevent concussions, skate guards, how to prevent cuts and injuries due to the skates. One of the big things we did was actually redesign part of the rink. It used to be at the player area. At the end of the player area was a 90-degree stanchion of plexiglass. And what was happening was players were getting checked into the boards at the player area and then slamming up against the glass. And they were sustaining head and cervical injuries. I've mentioned before, it was actually the Boston and Montreal that caused the NHL to take a look at it, the hit of Chara on Pacioretty. He sustained a concussion and a cervical fracture. So they gave us part of the rink to the Winter Classic, the outdoor contest, and we used crash test dummies, hybrid 3 50th percentile male dummies, and threw them into different configurations of glass. And ultimately, the new design that we developed is a curved piece of spring-loaded Lexan or plexiglass. So now when the players get checked into the boards, it absorbs that impact and they glance off of it. And it's helped prevent and pretty much mitigate any type of head or neck injuries as a result of player interaction at that part of the rink.
Hockey players tend to be pretty big guys, right?
They do, yes.
You said you used the 50 percentile hybrid 3 as a crash test dummy, an ATD, to do your work in furtherance of the NHL contract or commission, correct?
That's correct.
Did you need to use a hybrid 3 that was the same size as these big, tall, 6'4", 230-pound hockey players?
No, not at all.
Why not?
There's a 95th percentile male dummy, which not many people have or use. The 50th percentile male is basically the gold standard for crash test dummies. And you're probably most familiar with it if you see automotive manufacturers and the ads on TV where they put the crash test dummy in the car and run them into walls and flip them over. Well, they use the 50th percentile for all of those tests. And then they scale the actual injury assessment reference values to different size people. So they record the force off of that, and they might say, well, for the 50th percentile average person, you can sustain 180 Gs of acceleration to the head before you see a severe injury. And then they'll scale that and say, well, the hybrid 3 has to record, say, 300 Gs before someone twice that size gets hurt. So you just use one size dummy, and then you scale that to whatever size person you're looking at or you want to actually investigate.
Is that undertaking of mathematical scaling, is that an industry standard in biomechanics?
Absolutely. And I mean, it's set forth in NHTSA, the National Highway Traffic and Safety Administration. They set, well, the government sets the Federal Motor Vehicle Safety Standards, and that's all the crash tests that vehicles have to go through. And during those tests, they have to ensure that the values on the dummy, on the head, on the neck, on the spine, on the arms, are below certain values to ensure that they're safe at specific speeds. And they scale, they have a certain papers, a lot of papers actually, which talk about scaling the values for different size people.
Is that an accepted methodology in the scientific community?
Oh, it certainly is, yes, sir.
Dr. Rentschler, do you specialize in any particular research and analysis at ARCA to evaluate the relationships between crash injuries and crash forces?
I do, yes.
What about kinematics?
Kinematics is one of the specialties, yes, sir.
Fancy word, probably nobody knows. I didn't know it before I met some of the folks involved in this case. What does kinematics mean?
Kinematics is just motion of the human body. So it's looking at how the body moves in different situations. Whether you're in a vehicle and it hits a wall, how does your body move? It moves forward. Will it load into the seatbelt? Does the airbag deploy? Or if you're a pedestrian and you're struck by a car, how does the body move as a result of that interaction? That allows us to look at the loading to the body. Forces are exerted on someone's body because their body's loaded by different objects or different forces. So kinematics is one of the first steps. If you're going to look at injury causation, you have to determine the kinematics of an event.
What are human tolerances?
Human tolerance is really just looking at how much force it takes to cause an injury. So there's been generations of testing to look at different forces. For instance, the humerus, the upper bone in your upper arm. How much force does it take to cause that fracture? They've tested the cadaver bones. There's a lot of research for decades out there looking at different parts of the body, the ulna, the radius, the two bones in your forearm, skull fractures. Almost any type of injury, again, has an injury mechanism, and in order to determine how it occurs, we have to look at tolerance. How much force can the body withstand before you start to see a specific injury occur?
Doctor, how long have you worked at ARCA?
I've been with ARCA now for about 17 and a half years.
How many cases have you been a part of in terms of investigating or conducting crash injury analysis?
Over my whole career, probably thousands of cases. I've been doing this since 2004, so for about 21 years total.
Dr. Rentschler, are you able to estimate how many of those cases that you just talked about, those potentially thousands of cases, have involved motor vehicle pedestrian circumstances?
Oh, I'm sure over the year there's been hundreds of cases. A lot of them are motor vehicle accidents, but certainly a large percent's automobile pedestrian type impacts.
What education, training, and background qualifies you to perform the duties that you just told us about as the Director of Biomechanics and Human Factors at ARCA?
Well, I got my BS in mechanical engineering with a minor in biomedical engineering from Carnegie Mellon University in 1995. I then went on to get my master's in bioengineering and biomechanics from the University of Pittsburgh in 2002. And then I got my PhD in bioengineering and biomechanics from the University of Pittsburgh in 2004.
2004. Thank you. Are you a member of any professional associations associated with your field?
I'm a member of SAE, the Society of Automotive Engineers, as well as the American Society for Mechanical Engineers, ASME.
Are you also a reviewer for an outfit called Archives of Physical Medicine and Rehabilitation in Biomechanical Engineering?
I have. I've done peer-reviewed articles for those journals before, yes, sir.
When you say peer-reviewed articles, you're the peer reviewer?
That's right. If you want to submit a scientific article to a journal, you'll write that manuscript and then submit it to the journal, and then they'll send it out to other experts or peers in that same field, probably 3 others normally. And then they'll review that transcript, send it back with any suggested revisions, and then usually the author will make changes, send it out again, and that's how it gets accepted. Usually it goes through several different iterations before a paper is actually published.
Have you received any additional training following your PhD, formal training or otherwise, in the field of biomechanics?
I have, yes.
Describe some of that for us, please.
Throughout the years, I've taken classes through the NTSB, National Transportation Safety Board, as well as SAE, as I said, Society of Automotive Engineers, and at different universities, Virginia Tech, different seminars and classes with respect to biomechanics.
Is that normal to, even for someone at your education level, a PhD, to take continuing education to stay up on issues in your field?
It is. You take continuing education and then also just working with your peers. And when you work in a certain company, for instance, at ARCA, we don't do just litigation. We do the research and development. We have an epic sports branch at ARCA where we look at sports performance of athletes, how to help them perform better, whether you're a baseball player or volleyball player. So it's really the experience and the work that you do that also helps keep you up to date with technology and the different aspects of that field.
Does some of that additional education include biomechanics of high impact injuries that was offered by the NTSB?
Yeah, that's correct, yes.
Methodology and techniques of crash data retrieval offered by IPTM?
Correct, yes.
What is the IPTM?
That's the Institute for Police Technology and Management. It's actually a school down in Jacksonville, Florida, that offers basically vehicle crash reconstruction and biomechanical classes.
What about human factors in traffic crash reconstruction, also offered by the same outfit?
Yes.
Did you take a course in automobile safety and injury biomechanics from, is this the one from Virginia Tech?
That's correct, yes.
Okay. Did SAE offer a course in injuries, anatomy, biomechanics, and federal regulations?
Yes, that was in Detroit, I think, where SAE is based.
And you took that seminar as well?
Yes.
What about vehicle accident reconstruction methods offered by the SAE?
I've taken that class before, yes.
Linear momentum analysis offered by CAARS?
That was, yes, in a class out in California.
Motor vehicle accident reconstruction offered by SAE?
I've taken that class as well, yes.
Advanced collision investigations out of California law enforcement?
Yeah, I believe that was a 2-week class I took. That's the introductory class they give to the sheriff's department and police officers out in California.
And what about the post-collision passenger vehicle inspection and seatbelt analysis offered by CARS, C-A-A-R-S?
I've taken that as well, yes, sir.
Have you published in peer-reviewed articles and book chapters? You said you were a reviewer. Have you actually published yourself along with you and your colleagues?
I have published, and that was mainly when I was in graduate school doing graduate work. I worked at the Human Engineering Research Lab. We helped people with disabilities, so we looked at people in wheelchairs, manual wheelchair users, looked at the forces acting on the arms, how to help reduce injuries, rotator cuff tears, carpal tunnel syndrome, things such as that. So I did publish primarily when I was in graduate school at the University of Pittsburgh.
When you were in graduate school, approximately how many publications did you participate in, either yourself or with colleagues?
Probably 10 or 12 papers, and then some abstracts, and I believe a book chapter as well.
Have you been qualified in other courts to testify as an expert in the area of biomechanics and accident reconstruction?
I have, yes.
Approximately how many times?
Oh, I've testified throughout my career probably over 150 times in both state and federal courts throughout the country.
I want to talk to you for a second, Dr. Rentschler, about how you began working on this particular case, the case that's before the bench. When were you initially retained in connection with this case?
We were initially retained, I believe it was for the first trial. It was, I believe, maybe it was the fall prior to that actual trial that was last year.
All right. When you were, by the way, initially, were you hired by the defense?
No, we were not.
Were you hired by the Commonwealth?
We were not, no.
Was that a separate agency that hired you?
It was, yes.
It wasn't an insurance company, was it?
It was not, no, sir.
Okay. What were you initially asked to do by this separate agency?
Good job.
Initially, we were kind of constrained in what we were asked to do and to review, but we were asked to evaluate whether the injuries sustained by Mr. O'Keefe were consistent with being struck by the Lexus.
And who at ARCA was assigned on the team to undertake this commission?
There was myself, Dr. Dan Wolf, and I believe Mr. Scott Klein was another engineer who was involved.
And did all three of you join in the analysis that ultimately ended up in a report that you authored, or the three of you authored together?
We did, yes, sir.
What materials did you review in furtherance of your initial consultation in this matter?
Obviously, I looked at the medical records. We looked at photographs of the vehicles, information about the vehicle, photographs of the actual incident scene, various information pertaining to the Lexus itself.
You know who Dr. Dan Wolf is?
I do, yes.
Is that the other person, the Dan Wolf, the Dr. Wolf that you just mentioned?
That's correct, yes.
Did you and Dr. Wolf look at basically the same set of information? You were provided the same set of information?
We did, yes. We were provided a tranche of information that all three of us looked at, yes.
Can you explain the difference between your area of expertise and Dr. Wolf's area of expertise? I don't want you to get into his analysis, just what area he covers. In other words, you're dealing with a Lexus and pedestrian, Mr. John O'Keefe, correct?
Correct, yes.
What's the difference between the analysis that you undertook and the responsibilities of Dr. Dan Wolf?
So Dr. Wolf really concentrated looking at the vehicle itself and the damage to the vehicle, the damage to the taillight, which is really the only damage we have to that vehicle. And so his analysis pertained to evaluating the force associated with producing that damage, what's consistent with causing that type of fracture and damage to the taillight itself. Whereas my part of the investigation was really looking more at the injuries and looking at Mr. O'Keefe and his kinematics and his alleged or any interaction between him and the vehicle, and whether that would be consistent with his injuries as well as the damage that we see to the Lexus as evaluated by Dr. Wolf.
Did you ultimately issue a report, an initial report summarizing your opinions and your conclusions following your analysis?
We did, yes, sir.
About when was that report issued?
I believe it was sometime in February.
February of what year?
It would have been February of last year,
Okay,
2024.
2024, okay,
Correct.
thank you. Were you able to provide an analysis, given the information that you had, were you able to provide an analysis for the biomechanical aspect of the analysis of the case?
I was, yes, sir.
All right, did you review medical records and other materials?
I did, yes.
Did you make note of anything with regard to Mr. O'Keefe's injury or injuries based on what you reviewed initially when you began your analysis?
I did, yes.
Can you describe what you noted in terms of Mr. O'Keefe's injuries?
There were really just two basically different areas of injury. There was injury to the head. There was a laceration on the rear kind of right occipital region of the head, which resulted in fractures, an occipital skull fracture, which is the rear part of your skull, as well as basilar skull fractures that propagated up through the skull. And then there were injuries which were noted or diagnosed to be superficial abrasions along his right arm.
What is a subscapular hemorrhage?
Subscapular is?
Yes.
Yeah, with respect to the head, is that what? Yes,
as it relates to the head.
Yes, well, so when we talk about there's subarachnoid, there's pia hemorrhages, but basically they're hemorrhages, and scapular is hemorrhage under the scalp, but above the skull. So subdural is within on the surface of the brain, but scapular means that it's a hematoma or bleeding that occurs under the scalp but above the actual skull.
Did you note subscapular hemorrhage in your analysis of Mr. O'Keefe's injuries?
There was, yes, I believe there was extensive subscapular hemorrhaging.
What about skull fractures?
There were, as I described, occipital skull fracture in the back of the skull that then propagated forward, the calvarium as well as the basilar or the base of the skull.
You mentioned subdural hemorrhage as one of the issues that you would look at normally. Did you note whether Mr. O'Keefe suffered from subdural hemorrhage?
He did, yes. He had sustained subdural hemorrhage as a result.
And also subarachnoid hemorrhage?
Correct, yes.
What about bilateral orbital ecchymosis?
He did, yes, bruising along the eyes, basically.
What does bilateral mean? Both?
Bilateral means left and right, correct.
Did you note a 1 centimeter or approximately 1 centimeter laceration to the upper right eyelid?
There was, yes, 1 centimeter, yeah, and so, that's a little less than half an inch laceration right above the right eye.
What about abrasions to the anterior and left aspect of the nose?
There were some abrasions on the nose, and then I believe a few lacerations as well.
Laceration on the right anterior tongue?
The tongue was lacerated, yes.
You noted, with regard to one of Mr. O'Keefe's extremities, abrasions along that extremity.
Superficial abrasions, that's correct, sir.
Describe which arm we're talking about and what part of the arm.
It was the right arm, and it was from the forearm up towards the top of the shoulder. And there were various abrasions that were diagnosed as superficial abrasions along that kind of posterior aspect of the arm, the elbow, forearm, and the upper arm.
When you undertake an analysis, do you use biomechanics and kinematics both to try to evaluate whether or not a specific set of injuries are consistent or inconsistent with a proposed set of facts? Or I guess I'll just leave it there, a proposed set of facts.
Yeah, I mean, those are basic steps to look at how an injury occurs. I mean, first you have to identify the injury, and that's by looking at the medical records and determining what the diagnosed injuries are. And then you have to determine the kinematics and the kinetics associated with a certain event. So how did the person move? How was their body moved? Did they interact with anything? And how did that result in loading or force being applied to the body? Those are basic steps of a biomechanical injury causation analysis.
How did you go about undertaking those steps in this particular case?
So in this particular case, we looked at how those injuries are actually produced or created. So occipital skull fracture, you need a sufficient force. You need a force of around maybe 1,400 or 1,600 pounds applied at the back of the skull to actually cause a fracture like that. the abrasion, superficial abrasions, and an abrasion is basically rubbing or scraping or friction that kind of scrapes away the top part of your skin, the epidermis. You have the epidermis, the dermis, and then the hypodermis. An abrasion is just gets into the top epidermis and doesn't get any farther. Laceration is an actual tearing or ripping of the skin, usually down past the epidermis into the dermis. And so that takes either a blunt object or a sharp edge, depending on whether it's an incision or laceration, to actually produce that type of an injury.
Did you look at patterns of injuries on Mr. O'Keefe?
Yes.
Did you also, the other side of that handshake, did you also look at damage to the vehicle, physical damage to the Lexus?
We did, yes. Our goal or what we were tasked with was to determine whether the injuries are consistent with the damage to the car. So clearly, you look at how these injuries are created, what injury mechanism you need to produce them, and then you look at the damage to the car. Can you line up contact between where those injuries occurred and how they occurred with damage to the vehicle?
What kind of materials did you review, in addition to, I'm guessing, photographs?
Photographs, yes, autopsy photographs, as well as photographs of the vehicle and the damage to the Lexus.
What about medical records, hospital records, things of that nature?
Absolutely. That's the first step, looking at the injuries to find what the injuries are, what are the diagnosed injuries, as well as it's important to determine what injuries don't exist, because that's also helpful in determining whether certain impacts may or may not have actually occurred.
Did you receive a full file from the medical examiner's office in this case?
I did, yes, sir.
Did you also receive police reports, follow-up reports, witness statements, things of that nature in this case?
We did, yes.
Did you receive any data concerning the vehicle itself, contained either in police reports or follow-up reports or expert reports?
We did, yes. Mr. Jackson, I'm just going to ask you to slow down the cadence of your voice a little bit.
It's late in the day and I'm doing it again, aren't I? I'll slow down. I forgot where I left off, but let me ask you sort of openly, was there anything else that you considered and analyzed in at least building a database from which you would build an analysis?
Well, yeah, I mean, we review all the materials that are provided to look at all the injuries, to look at all aspects of the vehicle, damage to the vehicle, information about what the vehicle may have been doing. Any other evidence that may help contribute to looking at what either caused the injuries or what may or may not have caused the damage to that vehicle.
When you and your teammates undertook this analysis, did you even know who we were?
Initially, we did not. No, initially, I personally didn't know anything about the case. And we were asked not to do any research or to look up anything about it. We were given certain parameters, certain information, and that was it.
Did you follow those instructions?
I did, yes.
The undertaking, the analysis that you did, was it in keeping with the accepted methodology or methodologies in your field of engineering?
It was, yes.
Did you ultimately reach some opinions and conclusions based on that initial investigation or analysis?
I did, and we did it at ARCA, yes. Myself, Dr. Wolf, and Mr. Klein did.
Did you reach any opinions or conclusions with regard to the force required to produce the occipital skull fracture that you noted with Mr. O'Keefe, his head being struck by the rear tail lamp of the subject Lexus?
I did, yes.
Tell me what those opinions and conclusions were.
Well, again, we determined by looking at research and tolerance values that it would take about 1,400 to 1,600 pounds of force to cause an occipital skull fracture. Now, we were tasked with looking at, again, could that result from impact with the car? So one of the things we did is we took a head form, the head from a dummy basically that's instrumented with accelerometers, and we dropped it onto a taillight cover to attain a speed of 15 miles an hour. And so that would be comparable to the vehicle striking the head at 15 miles an hour. And I concluded a few things from that. A, that the force wasn't sufficient, or the acceleration wasn't sufficient to produce enough force to cause a skull fracture at 15 miles an hour. And also, when you look at the position and configuration of the occupant, it really wasn't possible to get a skull fracture by hitting the taillight and not sustain any other significant fractures. For instance, where the taillight's positioned to have an impact to the back of the head, you really couldn't have someone positioned in such a manner to strike just the head and not have subsequent concomitant injury to the neck or any other part of the body. So my findings with respect to the skull or the occipital skull fractures was that it likely did not occur as a result of contact, specifically with the taillight cover on the rear passenger side of the Lexus.
So as to the question of whether Mr. O'Keefe suffered the occipital skull fracture as a result of being hit by the tail lamp at 15 miles an hour, were you able to scientifically rule that out?
I was, yes, sir.
Was that to a reasonable degree of scientific certainty?
It was, yes.
Did you reach any opinions or conclusions regarding the abrasions on the right arm that you noted earlier on Mr. O'Keefe's body?
Yes, I believe my conclusions with respect to the abrasions are that it was inconsistent with contact to the tail light, and that not only that those injuries are inconsistent, but you would expect additional injuries, likely fractures to the hand and or the forearm, depending on the actual speed of the vehicle.
Other than the expectation that you would see fractures or other damage to the arm, what was the basis for your opinion that the linear abrasions would not result from impact with a non-damaged taillight traveling in reverse?
What you have to look at the kinematics associated with that, and that in order to get just superficial abrasions, that doesn't take a significant amount of force, but essentially that to have an arm contact the rear of the car, and we weren't really given any theory of how the arm contacted the car. So initially, we weren't privy to any theories or allegations of how this may occur. So just generally speaking, looking at the arm, how it would contact the car, and subsequent movement and interaction with the light cover, my opinion was that the injuries would be inconsistent, or the injuries that Mr. O'Keefe sustained on his right arm and didn't sustain would be inconsistent with actual interaction with the taillight.
Doctor, were your opinions and conclusions, along with those of your colleagues, reduced to a report?
They were, yes, sir.
Was that report, to your knowledge, ultimately turned over to both the defense and the Commonwealth in this case?
To my knowledge, it was, yes, sir.
I want to change gears for a second and bring us forward to the spring of 2024, after February of 2024, moving into the start of 2025. Did the defense at some point reach out to ARCA and contact you and Dr. Wolf?
They did, yes.
That was back in 2024 after the spring, correct?
That's correct, yes.
At some point, did the defense engage you specifically to testify?
Yes.
This year?
This year?
This year, meaning
Yes.
this trial?
For this trial, yes.
Okay.
Yes, correct.
Were you asked to conduct further testing in furtherance of your potential testimony in this trial?
We were, yes, sir.
And were you provided additional materials from the defense in furtherance of your potential testimony and your testing?
We were, yes, we were provided additional material with respect to, yes, the theory of how this may have occurred and how Mr. O'Keefe may have sustained his injuries, allegedly.
Included in the materials that you were provided in anticipation of your testimony in this case, in this trial, were you provided anything from a company called Aperture?
We were, yes.
What were you provided from Aperture?
We were provided a written report from Aperture, a PowerPoint presentation, about 140 some pages from Aperture, and then a file material, I believe what was reviewed and the results of some testing that Aperture had conducted with respect to this case.
Was it your understanding that the Aperture PowerPoint was authored by a particular individual?
Yes, sir.
Who authored that PowerPoint as far as you knew it?
As far as I'm aware, it was Dr. Judson Welcher.
Your Honor, may we approach briefly?
Okay.
All right, I like that comment right there. Hey, they got the same material. We got the same material. We chose to use your material. The Commonwealth had it. He also asked about the insurance company, so he must have been taking notes from the people screaming it from the sidelines on YouTube. Ask them if they were hired by an insurance company. So, I think he hit some, like, I think he nailed it with as far as making it known that Commonwealth could have used them. A different agency hired us. So you're both given the here it is, and we chose to use you. So, right now I'm currently doing my finalization of my Bethany and Dylan calls, not overlapping on a spreadsheet like I did for the Jennifer McCabe stuff. And I'm listening and I'm like crossing up my brain. But it's 3:30. We're going to 4. Then I check texts for bingo. Do we have a bingo winner? Michelle says there's no way she's being found guilty this time around. I agree. But I thought that the last time. I thought it was going to be the fastest not guilty I've ever heard in my life. So, I don't know. Let's see. They said the average of the age of the jurors are 31. Is this what the other people have heard too? 31's young for be the average. Think about that. 31. Damn. I agree right there. Michelle says Hank just sounds crazy. Trying to say witness statements, police reports. That doesn't matter. Look at the car injuries. They don't match. So the Virginia was not hit by car. We better get a civil. I want a civil case. I hope Karen Reed takes all these bitches down in a civil.
So jurors, that was about scheduling. We picked up a lot of time today. I think it was because we did spend less time at sidebar and less time doing things outside your presence. So we're back on track, and we're going to let you go for today, and we're expecting a full day tomorrow. I can tell you, the lawyers tell me that we're definitely winding down. Okay, so please, those same 3 cautions, do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And please continue to be very careful with your social media use. So we'll see you ready to start at 9 o'clock.
Oh, thanks, Bev.
Did we get a bingo?
I asked you.
I sent
Stacy.
Thanks.
Yes. Stacy.
Stacy Ryan. Calling Stacy Ryan.
Yeah, bingo. As long as Stacy wasn't playing with 3 cards, that was the only thing that I. Since Stacy's in, like fun. Let's see what she has to say for herself today.
You're all set, Dr. Rensselaer. I should
you.
have told you. I'm sorry. We'll see you tomorrow morning as well. So, thank you.
Okay, Dr. Ramsey. You can leave. I got to handle
All
these.
right.
Okay.
So first of all, anybody object if I give Ms. McLaughlin back the paperwork on the State of Rhode Island versus Michael Patino transcript or whatever she was giving me? Any objection to that? All right. Thank you. All right. So, Mr. Jackson, for purposes of your edits,
Mr. Jackson.
so the text will be removed from 5, 6, 8, 9, 23. The word measurements, I think, is perhaps the only word there. 24, 31, 32, 33, 34, 46, 47, 54, 55, 56, 58, 66, 67, 68, 69, 71, 72, 73, 74, and 75, and 76. Separately, pursuant to what will be an upcoming evidentiary ruling on whether foundation has been made, if you could separately have a way to exclude, if it becomes appropriate based on whatever ruling based on the foundation that you're going to attempt to put, slides 9 to 23. Now, as I said to you at sidebar, once you do this, or if you talk to the Commonwealth, if there's no objection to some of those numbered slides that I said needed to be edited, if the Commonwealth agrees that they come in, you can go ahead and put them in because I would allow them if it's by agreement.
Thank you.
Okay? All right. So do you expect that we will finish with Dr. Rensselaer tomorrow?
I do, Your Honor.
Okay, Mr. Brennan?
I don't think I'll be as long as I was with Dr. Wolf,
Okay.
depending on how it goes. If he has an hour and a half, I expect I'll probably be about an hour, maybe an hour and 10 minutes.
Okay. All right. And then we'll figure out where we are Thursday. It seems that the case may be ready to go to the jury Friday, maybe Monday at the latest. But that's,
By Monday, based on our
does that seem like a fair estimate to you, Mr. Brennan?
I think we'll be ready Friday.
Okay. All right. So we'll see. Okay. All right. Thank you. We'll see everybody tomorrow morning. Yes.
Should I have Dr. Welch report tomorrow or wait for Wednesday? Oh, tomorrow's Wednesday?
Tomorrow's Wednesday already. Can we, Mr. Jackson, can we reevaluate that mid-morning or the luncheon break and see where we are, whether we need Dr. Welcher here in the afternoon?
Of course.
Okay. All right, we'll do that.
But I think Mr. Alessi will have one issue he wanted to address before.
Yes, Your Honor. With regard to various exhibits that Your Honor said would be admitted based upon the issue that we had with regard to the Exhibit 88, Your Honor said you would...
Yes, we'll put those into evidence.
Thank you very much.
Okay.
That was the only item pressing for today.
Yeah, I said yesterday they'd come in, they're coming in. Okay, so those will be in evidence. Mr. Brennan, you were on notice yesterday that I was letting those in. Okay. All right, we're all set. We'll see you tomorrow.
All rise for the court, please.
Goodbye.
Okay.
Bye, Helen.
Okay, so where I see this is, did you hear how he just asked, do you want me to have, you hear how Alan Jackson kind of like shushed along, what's his name, Hank, when he asked him, oh, should I have Dr. Welcher here tomorrow? You know, and I'm telling you, they're not, they are not ending with this man. I don't, that's why AJ's being really, like, he's not, I think they're ending with Derek Ellington.
Okay.
To like
Would you hedge
put it
your
all,
bet?
to put it all, like, to put a bow on, because I can't imagine, do you understand that if they rest on him right here, that means that they would have called no digital forensic expert to the stand. None.
Right. I know. I get it.
Like, not a single one. Yet the Commonwealth called 2/3, if you count Nicholas Guerrero and him, like, you know, submitting the shit. But I find that hard to believe that you're not going to touch on the inaccuracies. But whatever. I mean, I believe that's going to happen. That's why AJ was like, I think that the jury would have it by Monday. I also think that AJ doesn't want to give, why would you want to give the jury the case and then have a whole weekend for them to be subjected to shit? I would not want the jury to get the case on like a Friday unless they're deliberating on Saturday and Sunday. I want them to get it on a Monday.
Yeah.
If that makes sense. Like, I don't want, that's what I mean, that's what I would want, but that's just me, I guess. I don't know. I'm going with my gut here. There's no way that they're ending with him, because otherwise, like, that means that they're not calling. Like, they're not calling a digital forensic expert. I find that hard to believe. I find that absolutely hard to believe. But hey, I find that hard to believe. Okay. I think that you at least have to show that
This is what I was saying about that, though.
you at least have to get, you at least have to like have somebody get up there to show that that their data that they're going off of is inaccurate because of the Waze app. If the Waze app is off 3 minutes, it changes everything. And all you have to do is put that doubt again in that.
Do you really think there needs to be more reasonable doubt than already was presented today, and what Dr. Rentschler is going to be testifying to more? I mean, tomorrow, do you think that there needs to be any more reasonable doubt? Because it costs money to put on this defense.
Well, I don't think it's going to be long. I don't think it's going to be long then to call, you know, and to call to call Derek Ellington to the stand and to touch base. I mean, this was like their whole big claim to fame. Like, Jennifer McCabe Google search, how long to die in the cold. Okay. But I clearly think that they've gone completely away from that. And it's just more like, this is a tragic accident, but yet, it's a tragic accident, but then these idiots just didn't call for help. They just decided to carry his body over to the edge of the lawn and leave John O'Keefe there. Like there has to be some there has to be some.
You want it wrapped nicely, but your brain thinks in the ways of timelines, okay? But if there was an executive decision made, like I keep using the term
Well, because
dumb.
of what they said in the opening. Because of what they said in the opening. So he's going to have to say in the closing that they didn't call these people to the stand, and I don't even know if that's I don't know if that's improper. I'm saying you said a lot of things in the opening, okay? And if the jury remembers what you said, all right, and anybody wants to talk about, yeah, we were expected to hear da 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 da, and we don't get that, then ultimately this is what it means. If John O'Keefe was attacked by a dog and a dog just had an accident and just jumped up, okay, and just took John out. Moral of the story is those people there would have been like, oh my God, and then just take him right to the hospital.
That's what you should do, yes.
Okay, so for the jurors to go back in that deliberating room and just to be like, okay, so we all believe that these people in that house, whoever was there, John gets taken down by the dog, or whatever happens, and then they just say, we're not gonna do anything, and we're gonna instead frame Karen Reed.
Yeah. And we have bigger obligation.
Without anybody like maybe putting more doubt into the timeline of, because Rensselaer's not testifying to what like Jennifer McKay, Carrie, I don't know.
Right.
I don't know. Sure. I would just want someone to tell me that the Waze app is off 3 minutes. And then then it's over. Then
that's over for you.
Then you're timing all this stupid shit up to nothing. Because then it all happened way earlier. Like the whole 3-point turn, the acceleration, and because you're going off of the app time.
But do you understand that for your brain, yeah, and you've done the data and you've researched it and all that makes sense to you, those numbers. But right now, what we just got from the last two, and what we're going to be getting from these last two witnesses, absolutely dunk on the CW. Layups, no layups, however you want to use your sport analogy, they just got dunked on.
And then these people just decided to say, oh my God, rather than just being like, let's rush him to the hospital, this is clearly such a bad accident. We just were like, what? Decided, you hate me, John?
Yeah, I don't want to get in trouble. Whatever they decided, none of it
Who's going to get in trouble? A dog just jumped up and took somebody down.
Listen, and all of that's just we're going to be speculating. Sure, we can do that. But if we're talking legit facts, it doesn't even matter. What matters is the CW's theory that she ran into him at 29 miles an hour and fled doesn't match with any of the evidence, which is basically John's body.
So would you take a hit then when you're talking about you're arguing your point on the closing, and to say they didn't call anybody, so we couldn't provide you guys with this evidence?
Absolutely not. I wouldn't take a hit. See, it's very true. It's very true that what you say in your opening statements, you better prove what you say in your opening, because the jury's paying attention to that. But at the same time, when you just put on what the defense just put on, in my opinion, the last two witnesses, you're banked. It's bank. It's money in the bank. I don't even care what anyone has to say after this. Fuck all of you. Fuck any other opinion. Vote against me. I don't care, because I will fuck you up. You guys have fucked up so bad. I don't even, there's not even, you don't have
just to say this is clearly, we're going to go in the deliberating room and say, oh my God, the Commonwealth made, they're all going to go back and be like, wow, this is trial number 2. So something must have happened in trial number 1.
I don't listen. I don't care if you're not even if you're not allowed to deliberate things that haven't been like accessed for you to that level, then they're not going to be doing that. But what they need to say is reasonable doubt. And Karen is presumed innocent. And the Commonwealth has the burden to prove her guilty, and that's going to be in the closing. Remember my opening that I very generously gave Hank Brennan a beautiful opening? He probably used my opening statement, but I'm letting you know that Hank's done. This is done. I don't care anymore. This is over. They dunked on them. It is done. This is disgusting what happened. They are framing her. Anybody that doesn't see that is choosing to be blind. And I think this young jury gets that. And now it's about saving money. Do I spend more of my client's money to bring in a timeline expert to satisfy and maybe confuse some random number lover out there in the jury? No,
Random lover out there. I would just simply to say that the Waze app is off 3 minutes due to, and then that's your, and that and then what he was supposed to be testifying to is that the handlings of these two people's devices after the fact, they were not stored properly. They were not put in airplane mode. They weren't so then when you're going to try to extract the data then is inaccurate. So I don't know why you wouldn't want to have somebody just say that, which all it would do to the person that's sitting there. Oh, okay. Makes sense now as to if the Waze is off 3 minutes, and then because we didn't hear about anything about the phone and how it was preserved or not preserved.
Exactly, Lana. And you're going to have to spend time laying foundation and boring the jury. And maybe potentially, I'm not taking the risk to piss anybody off after I just had these beautiful 2 last freaking witnesses. I am not pissing anybody off. I dunked. I'm
okay.
done.
We'll see. We'll see. I'm not. I think they were done when the Commonwealth rested, and you could stand up and say, okay, I don't think they met their burden here. When they decided not to call anybody that had all this material, they were material witnesses that were not called. Your lead investigator, you think that you're going to go and charge somebody with murder and not call the lead investigator? Like, to me, they didn't have to put even on a case. To me, but the reason that they did in a way is because of the way that Hank lied about the evidence. And just so if you don't think that he lied about the evidence when it comes to the digital stuff, then he did. He did.
Once
he 100% lied about that, and
once you're found not credible, in my eyes, in that kind of setting, I can't take anything you say seriously, right? So sorry, I can't trust you.
Well, I just hope that these people don't say to themselves, "You guys, I find it really hard to believe that 16 people, if the dog just attacked him or whatever, like that they wouldn't just go get the man help." Like, now that's unreasonable to me.
Okay, well, listen, how about this? Let's just put this in the atmosphere. What if, as first responders, they know what Dr. Laprasada knows, which is, oh my God, the way he hit his head, and maybe he had a seizure because he had vomit on his, on his chest, on his clothing.
They don't know about that, I don't think. I don't know if they know about that.
No, I'm talking about the people at the scene. I'm talking about the McAlberts, okay? So let's say that they're first responders, okay? And they know as trained first responders.
Oh, that they know that he's a goner.
That he's a goner. That this is bad. There's no saving this dude. Okay, so what if it's that, and then they're just like panicking or drunk or whatever. Literally, this is just semantics because I don't give a fuck anymore. I am.
Well, that's why I wanted to look at the data one last time with now what I perceive to be the defense's theory with this jury is that John got out of the car, walked up to the house, and he went into the garage side door, like that side door, and that boom, dog. Because if you're not going to change the app and shit is wrong by 3, he's still getting out of the car at 12:31 and 52 seconds and walking that amount. And then there's no, how did they move his body? Okay. and to put him where he was found and not make any steps, because even if your phone is on you, it's still going to calculate the steps. If somebody walks you, if somebody carries you, your phone is still going to calculate the steps.
But
So
they're
I'm just trying to
alleging that
say, if you're gonna
Higgins.
listen, if you're going to have people in the jury, if you don't think they're going to be talking about that in the back of the deliberating room, they are, because everybody believes in Copville. If Massachusetts is so hardcore cops and the cops don't ever do anything wrong, and oh my
What?
God, it's so, yeah, that's how Massachusetts is. They're all about, oh man, if you're a blue family, like your dad was a cop, your grandfather was a
No,
cop, mom was a cop.
that's not true. No.
Yeah.
The Massachusetts families aren't like that. You
Yes,
have a
that's
cop, you have a
exactly.
firefighter, and you have a criminal in the same family. Same family.
But
All of them.
but no, the community puts these cop families on pedestals in Massachusetts. That's a fact. That's what everybody was talking about. Like,
In Canton, maybe. In Canton.
no, it's a Boston thing, man. Anyways, as I was saying,
Go ahead.
that you're gonna have, and so what it looks like on paper right now, because they have all these little reports back there, they have all these sheets of paper, and they're gonna say, okay, well, he gets out of his car because nobody has testified that no, he didn't get out of his car at that time. He didn't get out of Karen's car at that time. They're just gonna bank on, listen, when those people pulled up behind Karen, they saw only Karen in there. That means John has to be somewhere else. Okay? John has to be somewhere else.
That's right.
So don't you think that if he immediately gets, pummeled and this happens right away, that Karen would have heard? I think that that's not now why Karen's saying I had my music up or whatever. I don't know. Is that, don't you think that there would have been that initial, like, oh my God, you guys got here. They're like, oh, holy shit, what the hell just happened? Like people freaking out, like you might like hear that. Anyways, at the end of the day, the phone stops. So how it's seen right now, you're going to have idiots in the back of that room talking, and they're going to be saying things like, well, he gets out of the car, he takes his steps, and then he's basically met with the dog. Okay, I get that, but his phone just doesn't move again. It's in pocket state. And they're going to have strong people back there to say, fuck pocket state, fuck all this. We don't even know if that shit is even like accurate, works. Like you need somebody to get up on that stand and to shut down his phone having dick to do with dick. And then I think if they hear something like that, then it's like you're not gonna be able to. These people need something to combat the idiots in the jury back in the deliberating room. You need something to combat it with. These people aren't going to have anything to combat it with. So you need to give them that. And Derek Ellington gives that to people to have discussions with in the jury room. Tell them once they hear that the Waze app is off 3 minutes because of the clock, that's enough. Once they hear that, hey, if you don't preserve a phone the right way and people are doing certain things, then when you go to download the data, you could lose data, you can get this, And if you move up the time by 3 minutes, then John O'Keefe is there a chance that I believe, and when he took the steps to get out and go from the waterfall bar, if you are within 10 minutes of before you would like your steps can still be counted on your last, like, I have to pull up the data and show you, but the way that it works is you can get out of your car and start walking, and it would still touch on to like the steps that he had from when he was leaving the waterfall bar and got in the car. And then depending on if you were able to get out of the car within a 10-minute period, then those steps would be counted more up until the 12:24 point. And then when he stops for 5 minutes and then he restarts with those last 32 steps. And I think that if you can show that those last 32 steps that were taken, that those 32 steps was with somebody else that grabbed his phone.
Well, I mean, they started to, Lana, when the defense showed Higgins, right? And they showed him going into the Canton Police Department, and then they were talking about video not being there, and that he grabbed something. And I mean, they're basically saying like there was a Faraday bag. They're not saying, they haven't said it, but I mean, they're alluding to some wackiness happening.
Well, yeah, but you have to you have to combat. You're combating everything else. You're just going to not combat the digital evidence. You're just not going to combat. Everybody lives and dies and breathes with their phones. You have to combat that. I believe I'm going 100%. I'm all in. They're calling Derek Ellington, and that's why Alan Jackson is letting them believe whatever they want to believe about if Rensler's the last guy, whatever, blah, blah. I see the writing on the wall here that Alan Jackson's letting them believe whatever, because I just heard Alan Jackson say, well, yeah, we believe that the jury would have it, by Monday. I don't know where it came out that Rensler's the last witness. I have not heard Alan Jackson nor Karen Reed nor anybody from that defense team say that Rensler is our last witness.
And I hope you're right, because I would love to see that. But if I'm thinking about and
then why do you call the PI? We call a PI to go measure. To go measure because that's the whole purpose remember, did you hear Yannetti say it? Hey, yeah, we have to call him and he has to testify first, because I have the report right here. I have the motion right here.
Mm-hmm.
We don't want Ellington to testify. And so what they did is Bev said, well, can you call him? Let me consider the motion. Let me look at this stuff and I'll make a decision on Derek Ellington. Because Hank put in his motion and said they plan on calling him tomorrow. So I find it hard to believe that on June 1st, you're planning on calling Derek Ellington, and all thing that Hank does is put it in motion to say, well, that's fine, but he changed it, or he added to his report. Okay? So I can't imagine that you have Derek Ellington and you hit him up in March after he already wrote a report in March, then you hit him up here in June or just before during the trial to say, hey, I need you to add da-da-da-da-da-da. And so he adds to his report. This then motion gets put in on June 1st or June 2nd. Hank goes fucking ape shit, writes an opposition to it. He's objecting to that. And at the end of the day, whether or not that extra additional part gets to come in or not, Derek Ellington is testifying. So I know it. I'm all in. Derek Ellington is testifying. The motions show it. I can't imagine that from June 1st to June 10th here, they said, okay, we're just not going to use Derek Ellington. You have to. There's just no even arguing it. And I said you need a timeline person. You need to bow it up. You have to use him. He's 100% has to be used.
Well, I hope you're right, because I'd love to see it.
And I don't think that it is. I know that PI was foundational for Ellington. I know it. I know that's exactly what it was for, because of what he's going to testify to. And it's needed. You guys, you're going to have people in the back of the room at the jury deliberating. They're going to be back there. They're going to be talking. And not a single person is going to be able to combat when somebody brings something like that up.
Are you saying though, without Ellington, that the defense might not win?
No, I'm saying why would you not? That's the last piece. Like, that's your last thread. You're just going to leave a thread hanging on no, you're going to clip it. Like, you're going to call this person. I don't give a fuck about Bev's time schedule that she thinks she's on. The reason that Bev thought that Rensler was going to be the last witness is because Ellington was going to go before Rensler. But due to us holding on to Derek Ellington, because Bev, I don't know, has she ruled on that motion? That's the last thing you would need to address. You're going to have people, if you think you're going to go back into a deliberating room and those people there's not going to be one idiot, possibly two, maybe fucking four, okay, to say, you guys, the guy stops moving at 12:32, okay? Just because his phone took an extra couple steps, maybe it just registered a little bit after the fact because of what that other guy said, that it takes time to catch up because your phone doesn't know that you're going to take steps. So it calculates them after the fact when, okay, you're done moving. And so what are the odds that her car would do all this crazy ass shit, right? And he he has a busted up back, I mean, head, and look at that burn. We all saw it. What are the odds that all that just would just stop? Like, boop. And then somebody needs to stay in the room. Well, what are the odds that nobody saw it? What are the odds that nobody saw it? What are the odds that nobody saw then him laying on the ground? And then if you have, that's why you need Derek Ellington to come in and say, hey, let me just help all y'all out. That Waze app that they were using to calculate what time everything was happening, well, that Waze app is off.
I can get behind that. I mean, listen, you've done the data, you've done the work, and it's good, and Ellington would cinch it up. I just know that I just know from today, and okay, in my opinion only, I just know within my own soul, from today, and
they are definitely not calling Karen Reed. I would, if they call, they are 100% definitely calling Karen Reed. They are not calling Karen Reed.
Anyway, in my opinion, from the last couple of days, they just dunked on him. Done. So whatever. Stick a fork in him.
Well done, no shit. But we can't handle the logical people. We need the illogical people to be handled. And Derek Ellington is going to handle all the, especially if these are 31-year-olds or average of 31-year-olds. These are phone people. Okay? These are phone people.
Phone data people.
No, they live and breathe their phones.
Auntie,
and
listen.
Their phones are the Bible. Like, dude, my phone knows that's where I'm at. My GPS is never wrong, because I would even say it too, dude. I don't type in an address and my phone takes me into the middle of the woods or into a freaking lake. Like, I take my Google Maps, boom, there it is. It doesn't have me driving on like freaking, into ponds and shit. It's taking me to where I need to go. And it's accurate within the time that I get there. Boom, done. Okay. Well, now if you hear about some interface with that app, and that when it's the clock that it's going off of, and blah, 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 when you hear all that shit.
And by that app, you mean Waze?
Yes, because you guys, that's where the GPS is coming from.
Mm-hmm.
Do you understand they couldn't use anything that they were able to use in this trial, in the last trial, because they didn't have the statements of Karen motherfucking Reed? They were able to do what they did in this trial because of Karen Reed's interviews saying that me and John, and then we pass up the road, so we had to turn around. They didn't have that last time. And so Bev allowed those statements to be used, and then that's what all the stuff that was applied. Here you go, you guys, to these experts. And so though they were using her statements to say this is what they did. And so it's like, okay, well then, yeah, when you can take the Waze app, you couldn't do that before because that's John's app. And John could have been in a different car. He could have started that's not the Lexus's shit. And so they didn't have that the first trial because they didn't have Karen's statements like saying that this is what happened. And that's how they were able to use it in trial 2. And so with that, that's how they did their whole entire case, was all off of the digital data. And so I think that if you show that Waze isn't accurate, or it's accurate but not with the clock that they're using, and then you throw into the fact that, hey, John's steps that he took, 190 some steps, that was leaving the waterfall bar, okay? And when we were there last time in Canton, I wanted to walk it all to see how many steps it would take for you to get leaving the waterfall bar, walking to Karen's car, getting in the car. And so like we measured different spots from the waterfall bar to see how many steps it would be, because then I wanted to see, are we really light here? Because then that means that when he initially got out of the car to take his first steps to go up and in, then because then there's a 5-minute resting period between 12:25 and 12:31, because they calculate all of his steps from 12:14 until 12:24 because he's not wearing a watch. And so it comes out to being 190 some steps. Well, just so we're clear, if you start walking and you get into a car and then you're able to get out of that car within the time permitted by Apple to then start walking again, it'll count the steps that you took from leaving the waterfall bar, getting in your car, driving, and then if you get out, it'll then count those steps all in the same trip if it's all within a 10-minute period. And so, or let's say that he would have gotten out over there on Oakdale for even just a little bit, taken some steps there, then gets back in, then proceeds. And then you get out, and that's how you're able to get the 190 some steps, because we were light. I was like, how the fuck did he get 190 some steps in that period of time and that's when it's like, okay, it's because he got out of the vehicle and the steps for Apple were still counting. So the 32 steps, those aren't walking towards the house. That's something that's happening after that initial walk up. And you need a digital forensic person to show that to the jury. And then the jury is going to be able to say, oh, okay, I get it. So the 32 steps, that wasn't him getting out of the car and walking up to it. Like it could be that, or it could also be he took steps initially. They were being counted on that first 10 minutes that had to do with waterfall bar as well. That's the type of stuff that needs to happen.
Okay, then.
That's what I think.
I know.
I mean, and I'm going to go all the way with it.
The BNVIA says, love you, Lana Brain. And I'm going to go all the way to the bank with it.
Yeah, that's why why would you call some guy that just chalked the lawn? So
to chalk the lawn.
Because he used his little rolling meter, to say how long, how far, to say how far stuff was. Like, if you think that you can just say stuff, like have somebody testify to like that type of stuff, and a jury's gonna be able to say, "Oh, I know why he did that now." No, you need. He asked him. Yeah, no, I'm actually so shocked that they didn't call. If you wanted those stupid ass garage pictures in, why didn't you just call Caitlin Albert to the stand? Why didn't you just call Brian Jr. to the stand? And then you're gonna get two birds with one stone if you use Caitlin. Caitlin, well, you left that night, didn't you? And you left around 2. Your boyfriend picked you up. Okay, did you see a body on the lawn? No. Okay. Is this a picture of your garage? Is this a picture of the? Yep. Mm-hmm. And then you call Tristan Moore. I mean, these are people that you would just blow through like lickety split. You picked her up, right? Mm-hmm. So you had a pass the lawn. I mean, boom, boom. Didn't see. Now you got your garage pictures in. I don't. That's who can authenticate if that's your garage, is like somebody that lived there, because Brennan wasn't stipulating anything. If anybody didn't realize that, you had to lay a proper foundation. And so it would be, is that how your garage was back in 2022? What was different about it?
I just think it's just asinine, because we just heard Dr. Rentschler say, and we heard Dr. L say, that the Commonwealth's theory that she backed in and hit him with her vehicle does not match the evidence.
It didn't match last year. It didn't match last year.
But see, this is a
their case is way
trial.
Their case is way stronger this year, in my opinion. The Commonwealth case this year is way stronger.
No,
that's why I'm saying you cannot end and not talk about the phone.
And you might be right, but what I'm saying is it's so clean. The defense has done a clean job of taking out the minutia, in my opinion, because we have a jury member from the first trial who went and worked for Karen and went and gave her opinion on, here's what we talked about. Here's what was said. She's a lawyer. This is what you guys should do. And that's a powerful thing to have in your pocket.
Yeah, but that was off of how the woman thought the trial was going to go. Hank totally changes that up. And the reason that there's way no minutia is because it had nothing to do with the defense taking out the minutia. The Commonwealth called all those people.
No. Listen, that's fine. But what I'm saying is the defense, because the defense has a choice. They can also call the McAlberts. Okay, they're not like limited to who they can call. They didn't, and I think that was wise because of what the interview that we saw with the jury member who came out and said, and how they had kind of just like, it just seemed weird about filibustering, whatever. This is a cleaner trial for the defense, in my opinion. And let me just explain something that today we learned unequivocally, okay, that I want to be fair, according to the defense experts, that John did not die from hypothermia, that his injury would have resulted in death in 15 minutes, estimate 15 minutes.
Yep.
And that the vehicle impact, which is also what Wolf said, right? The vehicle impact did not match at all the injuries on John's body. You cannot get those injuries by what the Commonwealth is stating. So therefore, what the theory is that the Commonwealth has put forth, and they are charging Karen Reed with,
this is the same thing as last year, though.
Reasonable doubt. There is reasonable doubt. And so it's done.
You're not listening. Last year, they did not come with any of this type of data. Last year, they did not come with any of the type of the data that they came with this year.
Okay.
It's night and day. Night and day. Okay? Night and day. They wanted, the Commonwealth is going to definitely talk about why he didn't call Michael Proctor. Again, I don't even know if that is
what do you mean
permissible.
they're going to be? What do you mean
the Commonwealth? You don't think Hank is going to talk about why they didn't call Michael Proctor in the closing?
When you say why they, who is the they?
Commonwealth. Hank is going to talk about why they did not call him. Yes. Hank is not going to play by the rules.
You think in closing, Hank is going to get up there and say why he didn't call Proctor?
I do.
Okay, well, maybe that's a smart move, but I don't think so. But okay, I invite you. Bring it.
Girl, I'm over here saying, listen, last year, same people testified. Dude didn't get hit by a car. Dude didn't get hit by a car, right? Same people. Dude got bit by a dog, right? Same people testifying.
I think that we're speaking the same language and kind of saying the same thing.
No, you're saying that you don't need to call Derek Ellington. I'm saying that you do.
I'm not saying you don't need to. I'm saying, well, yeah, I guess I'm saying you don't need. Yeah, I am saying you don't need to.
I know that. That's why I'm trying to show you the argument. The only reason that you call him is so that the jurors have to be able to argue each other in the back room, and you need to give them some ammo. And so I need to argue you as to why, hey, the phone stopped moving. I need to have ammo. You have to supply your jurors with ammo to combat people that are idiots back there. And so if you don't give them Derek Ellington, you are leaving a chunk of the pie, the last piece. What? And I can't believe that you just argued about money. I'm going to save my client money. They are not thinking about money at all, dude. That is like the last thing. This isn't about money. This is about closing the pie up. You have to give that to the jurors so that anybody that's an asshole back there, they have the ammo to combat the idiots. Because then you can say, because that's evidence. You have to have evidence that you can use to combat the fucking morons back there. It's just that simple.
I guess I just have a little bit more faith in this jury than I did 2 weeks ago.
Fuck shit.
Fuck shit, bitch. Like, what the hell? No, look, it's my opinion on it. It just is. I literally, I'm so done.
Our mind plays tricks on us because we've heard the first trial, right? We've seen all this stuff on social media, right? So then we come to this trial that we're like watching right now, and every single person's doing it because it's life. It's how our brains work. We're thinking that these people know something. Oh, guess what? They didn't come out.
No, I am not. Lana, you know me better than
that. Not you.
Okay, good. Because I don't do that. I look at every angle.
I'm saying I would do it too. You forget what these people actually know and think. because all they're supposed to know is what has happened in that courtroom. And and right now, the best thing that happened with these past two is that John O'Keefe, okay, now we have another thing. Okay, boom. The reason that his phone stops, okay, on the drop of a dime like that is because he was attacked immediately when he walked into the garage door. Okay? Now explain what time that really happened. Explain that it wasn't at 12:32 that he
Now
was
you
taken
explain to
down.
me, why does it matter what
And
time if
a
you're what
phone
is
digital
why
data
does it
person will.
matter? Why does it matter the time if you're telling me that Karen didn't hit him with a car? What does that matter to me?
No, because I think that there's idiots that are going to be back in that room.
Saying
That,
what?
what do you mean? They're going
Saying
to be
what?
saying they're going to
She
be
didn't hit him
saying
with
that
a car.
they're going to be saying that he did get hit by a car
How?
because of the
Who?
phone. That's their logic. That's their logic. You think I'm kidding?
I mean, listen. I don't even know. I mean, I guess I guess we're living in
Dude, these people are
1984.
morons. I
And
just think that you have to give them something to argue with. I just don't want to see these people in the back deliberating and they're trying to argue something that's not in evidence, because if you have a stickler in there and she's like, well, wait a second, they never said that. Nobody's testified that this is not accurate phone data and blah, blah, blah. And you know what? They didn't even try to combat it. They didn't even bring in their own expert to say that when they were reviewing, this is what da 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 da. You don't think that that's going to happen? I know what's
I
going to
mean,
happen.
it definitely could never leave anything in the hands of a jury that you don't cinch up. I get that. I don't know. I mean, it would be nice for them to call Ellington.
They are. Take it to the bank. We just proved it right here, mine and your conversation, literally right here.
Mm-hmm.
Copy, cut, and paste this, send it to fucking Alan Jackson. This is why you have to call him.
God damn it.
And we actually have brains. Imagine morons.
Wait, were you the moron in this situation? Like,
I
because
said
you're the one
we
arguing.
have brains. I said we have brains.
Compare, copy, cut, and paste our
Yeah.
conversation to Alan.
Here's two educated, logical, very common sense broads. And I just, especially if you're going to we need one person to supposedly just be this holdout. And then that way all of the pressure can be put on by, if there is a rigged juror in there, that the pressure then can be put on by 11 people to get that one person to come this way. But if it goes in there and it's like a 6-6 to start split, Karen Reed's coming out hung jury. And that's not, that'd be a shame. It'd be a fucking shame.
No, it would completely be a shame. And I do think that that's a really good argument for that, is that's a good argument. That's probably the best argument you've made against what I've had to say. But totally.
The best argument that I had all day with this whole topic is that they called Hyde. Okay? They called Hyde.
Yeah.
They called Ian Whiffen, and they used Ian Whiffen's shit. Okay, remember, we get to see all the bullshit. These tools were taken away. Okay?
Sure.
And so when they're back in this deliberating room, it cannot be all this overwhelming evidence of these reports that these people all did and put all together. And then they look at, I get it, they're going to think Shannon's an idiot. Okay? But he's the one that found, hey, when you want to compute this, yeah, but without Karen Reed ever saying a word, I don't care what Shannon found. You're unable to put the ways on Karen and in that vehicle because you can't go off of that. You can't go off of the ways for Karen's car. And how you will make sure that you definitely can't do any of that is by having your own digital forensic person testify to the fuckerage with the phone and how steps would have worked for John O'Keefe. That they would have started and been part of the waterfall leaving there because it's within a time frame.
God damn it. Do I have to tell AJ to come into the live? I'm going to text him. Whatever. Can we wait like 10? Do you think he's busy? Like, wait 10 minutes?
Being educated is not always a good thing. Depends on who and how you were educated. I think actually my definition of being educated doesn't matter how you were educated as long as you were educated. Education is education. But common sense is common sense. Can't teach it. You can nurture it though. They're definitely going with Derek Ellington. There's just no way.
You better not make him feel bad. Like,
No,
remember when he listened to our first?
No, there's no way. Like, you understand that. Like, why would you leave meat on the bone? This isn't a boring testimony. This is putting everything in those jurors' mind. Like, okay.
Okay, hold on.
It's everything that they couldn't get out of the cross-examination of those other witnesses. They could poke holes all day. But give them the ammo. No, this is Atlanta. I'm saying if my name was Karen Reed, how about, let me just put it to you this way. If that was my life, Karen Reed, hi, that's me. My name's Karen Reed. Okay, Karen, you want to rest with Dr. Welcher? What? No. I want to rest with Ellington. You think he's needed? Absolutely he's needed. Why wouldn't, how could it hurt? How about that? I don't think it would hurt. Is there a way that it would hurt? No, I think that this is a lot younger of this is my life, and there's, I think, a chunk left there that this guy just gobbles on up and spits out, and these younger people understand phones. And so,
did Kobe Bryant do a lot of dunking?
Huh? all you have to do is let Ellington show how Jen McCabe's freaking watch isn't having any movement for 10 straight minutes from 10:25 until 12:35. So during that time frame when Jen McCabe's saying that she's walking over back and forth and she has her watch on, is that what her watch data is indicative of? No. Is it saying, what's it showing? It's showing that she's not moving at all. Okay, so is that, are we supposed to go by her word or her, like, that's what you're going to show. You're also then going to show, okay, so then if John's phone doesn't have steps, does that mean there weren't steps? No. And I think that Jen's watch shows that. And that's actually a watch on her. I would use her words against her for the jury. To say, she says she's walking all over, and she kept walking over the door, walking back and walking over the door. At the very least, you're going to show that she's a liar, or you're going to believe it, and then you're going to say, okay, yeah, now it makes sense. Like, we can't go off of these steps, you guys. Look she was walking all over, and it shows that she wasn't even moving for 10 straight minutes. Come on, guys. I think we got it now. Now it's just, that's ridiculous. These phones aren't as accurate as everybody thinks. That's the type of shit you need to have happening in that back room. And if you leave that out, if it's my life, hey, no, Derek Ellington's coming, and I would tell Bev she can lick me sideways. There's no way I'm not having Derek Ellington testify if I'm up for murder. Absolutely not. I don't care about what Bev's talking about with time. I do not care. She cannot not allow me to call Derek Ellington to the stand. And then I'm going to say, oh, why? Because they had Hyde, they had Ian Whiffen, and then they had Nick Guerrero putting all this shit in.
I forgot that Guerrero got up there and did his little cuff checks. Yeah. All right.
That's it. We'll do a friendly wager.
Me and you?
Yeah. I think he's going to call Derek Ellington.
Okay. What's the wager?
Steak
I guess
dinner.
I was saying it's not needed,
Steak
right?
dinner choice. Steak dinner, Jeff Ruby's choice.
What do you mean? I don't have a Jeff Ruby's here.
Fine, pick a place. Winner choice, steak dinner.
Right, that's what choice means.
Yeah,
Usually.
choice.
Yeah. Okay.
All right.
You
deal.
also just told me to go to so I just texted Alan and gave him the link. So if you're so convincing and
Yeah, they're on
convincing,
a gag order. They can't talk to anybody.
he's not going to talk back.
No, he.
So
All right,
just
I'm ending this. We thank you
convincing.
guys so much. You heard it here first. We have a live bet. We have a live bet. Don't be on the wrong side of the bet. I'm flopping an ace on the river here. Derek Ellington's testifying. If those media people had a damn, I don't know, brain cell, they would ask her, "Hey Karen, so are you still going to call Derek Ellington to the stand?" That's all I have to ask her when she walks out. Would love to see her reaction. You know, come on, if it's your life, you know you would be calling him. You're not going to let somebody get up there and blast you with all these phone people, and you don't got to call one phone person. It makes it seem like the phone data is accurate. Fuck that, because
And
it's not
that's a
accurate.
good argument. That's a really good argument for it.
I would
That's a
never.
good argument.
All right, guys. Much love. We appreciate
Thank
you.
you guys.
Tomorrow. Wait, back tomorrow. 9 a.m.
You're
8:30.
9 a.m.
Yeah. All right, guys. We appreciate you.
Bye,
Thank you.
everybody. Thank you.
Thank you, Bella, for rocking it all night long. All night.
I get a song.
All right, guys. Good night.
Bye.